So today we gonna look at some Fani Willis disqualification testimonies. Okay, we're gonna do a recap over here. Before we get started today, though, we're gonna listen to Lakea with the song called Maneuver. Let's go. Okay. So today I thought that I cannot fucking talk. Today I thought that we would look at some of Fani Willis's, situation. Y'all, I have definitely been entertained. What's good, Jeanette? What is good? So it'll be a laid back type of at least 2 days or so. I plan on coming back tomorrow to finish it up. If you don't know, the judge has decided to take a couple of weeks to, come up with how he's feeling about the situation. So we will definitely, have to see what's going on. But before we get started, just for those that are not aware, let's listen to a few news clips on the situation. Let me move us over there. Shout out to Glock Dookie. Shout out to Jeanette. So I don't anticipate many people in here. This ain't one of those streams, but we gonna talk our little smack, and things like that. But like I said, I got a few clips that I want to show y'all before we get started. So really we'll just be looking at the testimonies. We'll get done with Robbins, the first one of Terrence Bradley, and then also Nathan Wade's. And then we'll start with Fani next live stream. Her father testified, as well as Roy Barnes, who is, somebody down there, child. I don't even know, but I was interested in this whole thing. It is crazy. It definitely is, Jeanette. So let's take a look at this clip really quick so we can get, kind of an understanding for those that are new. Y'all know I don't mix with politics really much, but this is scandalous, y'all. Okay, period. Let's take a look.
Hi there, everybody. You have been watching for the better part of the day. This proceeding in Fulton County. Just now, you're listening to the closing argument.
Hey, Lavina.
At a courthouse in Atlanta on the disqualification efforts to disqualify Fulton County District Attorney Fani Willis from her sprawling RICO case against the ex-president and his co-defendants. You were listening there before the rebuttal began to Adam Abadi from the DA's office, mounting a defense against allegations that Fani Willis financially benefited from the case by appointing Nathan Wade as the special prosecutor. Both Fani Willis and Wade have testified under oath that they were in a romantic relationship, but that it did not begin until after Wade was hired. The defense has shown no concrete evidence that Willis profited from hiring Wade. And today, the DA's office described the defense's star witness as a, quote, disgruntled, vengeful speculator. That witness earlier this week crumbled on the stand. He testified that he did not actually know when the relationship between the two started. Now, the fate of Willis and the entire...
She is, John. John said she's another Soros attorney.
RICO case will soon be in the hands of the judge. That's Judge Scott McAfee. If he decides to disqualify the district attorney, then her whole office risks losing this case against Donald Trump. Let's bring in MSNBC host and legal analyst, Katie Fang. She's outside the Atlanta courthouse. Also joining us, former Republican congressman, our friend, MSNBC political analyst, David Jolly. Katie Fang, take me through the importance of what transpired and tell us what might happen next.
So we did hear a long presentation by a number of defense attorneys as to why the judge should disqualify Fani Willis. But you notice that during the defense's presentation of its closing arguments, and then when the state just had the opportunity to get up and do it, the court actually peppered the defense several times with certain questions that indicated that he had some skepticism in terms of whether the legal standard had actually been met by the defense in this case. There were a couple of highlights that I wanted to bring to your attention, Nicole, that came from Judge McAfee, one of which was really important. So it was this question as to when could you make a determination as to when Terrence Bradley was lying. So Terrence Bradley's name has been brought up so many times, Nicole. He's the former defense attorney for Nathan Wade. He was supposed to be the star witness for the defense. In fact, the evidence was reopened for the purposes of Bradley to have to testify again. However, Bradley indicated that he was providing pure speculation when he texted with Ashley Merchant, who's the defense attorney for political operative for the GOP, Mike Roman. So the thing that we're kind of focusing on here, Nicole, is this idea that Bradley was supposed to be presented to impeach these witnesses. He was supposed to be able to take the stand and say that these other witnesses like Wade and Willis, et cetera, would have lied or were lying on the stand. And yet Bradley didn't impeach anyone. In fact, he impeached himself when he said that the texts that he sent were just based on speculation. Another question that came from Judge McAfee that was very telling. Is the court supposed to police people that take the stand and lie? Isn't that what you do with lawyers? Aren't you supposed to send them down the street to the bar, is what Judge McAfee asked, indicating what is he supposed to do with this idea that Wade and Willis, as members of the Georgia bar, have lied? And he's going through an academic exercise, I think, with a lot of these defense attorneys when he's been asking questions. But there's been some, I guess, criticism is the word I would use on social media and other places about the presentation by the state. You know, it wasn't as, I guess, compelling, and yet in some ways it was, Nicole. And the reason why is you have to reduce this to just the facts and the evidence. There's no jury in this courtroom. It's just Judge McAfee. And the back and forth that we saw between the state and the judge when it focused on the law was critically important, because that is what the judge has to rely upon when he makes this decision. He has to make his decision not based on any type of emotion, not based on whether or not he personally has an issue with what transpired between Nathan Wade and Fani Willis. He has to focus on only the facts and the evidence. And so with the state getting up and making legal arguments, that feeds directly into McAfee's questions to the defense as to whether the burden, the preponderance of the evidence standard that must be met by the defense has been achieved. And at this point, he really didn't have any strong, very harsh questioning for the state versus, I think, what he had for the defense, which are some really probing questions.
David Jolly, there's a movie, I think it's called Why You Were Sleeping. I think Sandra Bullock stars in it. And all this stuff happens and they wake up and they're like, what happened? And so before I went out on maternity leave, people were flipping on Donald Trump faster than, you know, the temperature dropped before 32 in New York. And I come back, and while I was sleeping, while I was away, something that transpired in Fani Willis's personal life now has her at the sort of hinge moment of perhaps losing this case, and perhaps the case against Donald Trump, the sprawling RICO case involving his efforts to overturn the presidential election and specifically his defeat in Georgia. Crimes that happen on a open phone line, not in the sit room, on a secure line, are very much in question. What are your thoughts as you watch all this?
Yeah, Nicole, first of all, the whole world missed you. I know I missed you, but the whole world missed Nicole Wallace. But listen, I don't know that you missed that much. I mean, Taylor Swift is now part of the deep state. Donald Trump is peddling gold shoes. We're all trying to remember the Speaker of the House's actual name, and democracy is still going to hell. But other than that, like, you know, it's pretty much how you left it. Everything's fine, right? But look, I think in this case, for people who are not lawyers like Katie Fang and not skilled with the courtroom as she is, to the layperson, this sounds and looks a lot like the House Republicans' investigation of Hunter Biden. It's like, what are we really talking about, and what are we trying to get to the bottom of? Because this has nothing to do with the actual indictment, the allegations of election tampering in the state of Georgia. And so I think for non-lawyers and for people who are worried about justice and democracy, you're right to kind of feel maybe accountability is beginning to slip away, because this is one of those weeks between the high court's decision on taking the case on immunity and now what we're seeing in the courtroom. But I would also say this: if the lawyers are actually arguing in front of the judge, whether or not the standard is appearance of conflict of interest or actual conflict of interest, once again, you've lost the American people. But I would suggest that hopefully justice actually does win the day here, because if Trump's lawyers and the defendant's lawyers are arguing that the standard only needs to be appearance of conflict of interest, that's because they know that they failed to establish a real conflict of interest. That said, to Katie's point, the judge has to consider the law and the facts as he sees it. And this is kind of all or nothing for whether or not there's going to be accountability in Georgia. It's hard to see this case surviving the disqualification of Fani Willis.
I do agree. I definitely agree that, man, they can try to minimize it all they want. We're going to listen to another one really quick, and this is just on the timeline. But they could try to minimize it all they want, but it's definitely not looking good at all. Let's take a look at this one really quick before we jump into the hearing. It's not a trial. She is not up for trial or whatever yet. But let's take a look at the timeline of the accusation.
Today's developments out of the Georgia General Assembly are adding to the pile of answers being demanded from the DA.
Fox 5's Brittany Edney is live outside the Fulton County Courthouse with a look at the controversy surrounding Willis. Brittany?
Courtney, Willis is really being bombarded with attacks against her office on multiple fronts. So we took a complete look at all of the local, state, and federal efforts to either get answers from the DA or see the action is taken against her. Fulton County District Attorney Fani Willis continues to experience fallout from her alleged personal relationship with Special Prosecutor Nathan Wade. On Friday, Representative Charlize Byrd filed an impeachment resolution against Willis.
Yes, I have a big hill to climb.
Byrd acknowledges that even if it would pass the House, a 2/3 majority vote from the Georgia State Senate is required.
One never knows until you push the envelope to try these sorts of things.
Former Fulton County prosecutor Ash Joshi thinks the articles as written are ridiculous.
The language that's used in there about tyrannical prosecutions seems to me it's more for political effect.
On top of that, the Georgia Senate is forming a special committee to investigate allegations of misconduct. The same claim Judge Scott McAfee will be ruling on come February 15th in the election interference case. Former DeKalb County DA J. Tom Morgan weighs in.
It certainly is salacious and scandalous, but it is not something legally on its merits that warrants recusal or disqualification.
I don't expect that Judge McAfee will dismiss the case unless the defense is able to present actual evidence that District Attorney Willis did something that is impacting how the facts or the evidence or the law will be presented to a jury.
Regarding how Willis spent funds during her investigation into former President Donald Trump and co-defendants, both Chairman Jim Jordan of the U.S. House Judiciary Committee and Fulton County Commissioner Bob Ellis are demanding answers. But even if Willis was removed somehow from this high-profile case, Morgan says she'd be hard to replace.
Ms. Willis's office is the only one I know that can handle such an expensive prosecution.
And everything that we've outlined, that does not include Willis's involvement in Wade's recent divorce proceedings, where a judge recently put her deposition on hold. In reference to the impeachment resolution, Willis's office declined to comment.
So that is the timeline, basically. Shout out to Lee Q. Lee Q, you had a great live yesterday. And shout out to Observing Stuff as well. Man, this shit is crazy. I was watching this and I was like, what the hell? And then they had this woman with them glasses, child, Robin Yeartie, came in there and she snitched on her girl. You got Terrence Bradley. He talking about attorney-client privilege. And then there was Nathan Wade's testimony. If that man would have waited any longer to answer some of them questions, I think I would have fell out. But y'all, this is one of the things that has been totally having my attention lately, child. So we gonna get into it. You know, this isn't, we just here to chill, basically. I'm gonna let y'all in on a little secret. On the 13th, I'm having surgery, so I don't want to like really do too much far as, you know, get into any story that I won't be able to cover because I do anticipate being gone about 10 days or whatever. It is in and out surgery, so it's not a big issue. So we gonna at least look at this for a couple of days because, like I said, the judge, he has said that he is going to think about it and he's going to come back and address it. So I thought that that was crazy. Yeah, it's crazy. It really is. Her friend came in there, child, Robin, Yeartie. I was like, what in the hell? So y'all, I had to do this one different because what I did was I took the testimonies that I wanted and I was hoping to put them all in a video, but then I had ran out of space because I had other stuff on here, child. So I uploaded them and then I was gonna download them, you know, to put them in for each day. And then YouTube had did something where they was like, I couldn't upload videos. I was like, the fuck? So I'm looking, I ain't got no flags or nothing. But for some reason it didn't. So I was like, well, we just gonna do it in parts and like this. I already gotta upload Fani's version tomorrow because that's up on another channel on private so that I could, you know, lessen some of the load on my computer. But like I said, it wouldn't even let me upload it. I don't know what is going on. But shout out to y'all. So we just gonna be in here chilling today and looking at this shenanigans in this courtroom and see what's going on. To me, it was a bad look. Talk about conflict of interest. And even if, you know, she had allegedly hired him afterwards, then you knew during hiring that you thought he was fine. And if given the chance, you would elope with him and spend allegedly, you know, money that she wasn't supposed to be spending. So, y'all, you know, I don't get into politics or whatever. I don't look at this as politics. We're looking at a prosecutor that was looking at, you know, charging Trump and things like that. And now she is going through this. Now, another thing that I did notice, obviously, I'm sure that everybody else did, that Terrence Bradley, right? There's 2 times where he came up to testify. He really wasn't trying to testify the first time or whatever. But I do also have the second one done. But he may be disbarred as well because but it's lying all around, child. So we gonna watch this. This is Terrence Bradley's testimony, and then it leads into Robin Yeartie, and then it goes back to Terrence Bradley for his first you know, round of testifying during this hearing. Again, this is not a criminal lawsuit yet. I don't know if it will become that, but you know, it's just a hearing to disqualify her and it looks like her office as well as Nathan Wade from you know, bringing the case against Donald Trump. Let's go, y'all.
Good afternoon, Ms. Bradley.
Good afternoon.
Before I begin, I wanted to ask you if you wanted to clarify any of your statements that you made yesterday.
Go ahead and begin.
I wanted to ask if you wanted to clarify any of your statements that you made today.
Go ahead and ask whatever you're going to ask, Ms. Merchant.
You initially became involved in this matter because you called me. Right?
Absolutely not.
I didn't call you.
No, it was through a third party.
Now, I really quick want to say that Ashley Merchant really just wants everybody to know that she had text Terrence, that he was giving her information, and obviously we would find that out. But I think there's a possibility that Terrence liked Ashley Merchant and, wanted to give her all type of information if he could get up in them cheeks.
You called me.
I don't know.
Read an article and I don't even know where it was. I found one in the Washington Examiner. I've got an objection. Can we approach the bench?
Okay.
Well.
Well, I can alert the court broadly to my concerns. This witness, it appears from the questions that Ms. Merchant had proposed, don't differentiate between what I'm considering three kind of buckets of information that this witness might have.
I agree, John Columinati.
One is communication derived from his representation of Mr. Williams. Second is any information that he might have from personal knowledge. The third category, which I believe is the substance of what Ms. Merchant wants to go into, is information not derived from personal observation, not derived from communication with Mr. Wade, his client, but gossip, secondhand, thirdhand, speculative things. Ms. Merchant's questions don't differentiate those categories of information. And I'm concerned about the questions being proposed without that qualification so that Mr. Bradley doesn't know when to invoke the privilege. I think the testimony yesterday was he didn't have any personal knowledge of any of this. That was my understanding of the testimony. I believe that was Mr. Bradley's sworn testimony yesterday. And my concern is that the gossip.
That's why I don't believe in the voting.
Part, the unsourced hearsay.
Hey, Poetic Cows.
Is where we're going to get to really fast.
Sure. And I think that's a fair point. I think she's following the script that she already provided you. So we have more than enough notice of when that might be coming. I think the second she asks a question that you think might weigh into that, make the objection and we can rephrase if necessary. All right, Ms. Merchant, you can re-ask that last question.
Read an article that was published September 11th discussing how much you and Mr. Wade were handling me, correct?
That is correct.
And you called me that same day and left me a voicemail on my cell phone asking me to call you back.
I do not recall that, but I do not recall that.
You don't recall that?
I do not.
So it's possible that happened.
I do not recall calling you after the article came out. I was shown the article, but I do not recall calling you after the article.
Can you tell us your phone number?
It's 334-717.
Wait, hold up. Why is that relevant, Ms. Merchant?
Because I need to establish that his phone number is the one that all of the texts that he had with me.
She is really just trying to bust him out that he literally had this phone conversation. Now, I did look at the text messages that came out. Man, it was crazy.
You can just ask him if he has texted you at some point. We can stipulate that as a matter of record. We don't need that on the record.
Okay, we don't have to put it in the record. How about this? Can I show him a copy of his what he saved in my
Sure.
May I approach Judge?
You may.
Take a look at that.
She said, can I show you a copy of what he is saved under my phone? What if she got like some cute little nickname for him?
And just verify if that's your number and your cell phone.
That is my number and my cell phone.
Okay, and is that also your email address?
That is my email address.
Okay, great. And I'll keep that separate, Judge. And we can redact it.
And if he wasn't trying to get with her, why did she have his mailing address? I mean, I guess she could have it by now during the investigation, but like, was that in the text?
So after whether or not you left a message on my voicemail, the next day, we were all in court in front of Judge Harris on September 12th, 2023. And do you recall that?
I do recall being in Judge Harris. Yes, I do.
and your attorney, BC Choker,
And possibly something with some money or something.
was there, and I was there, and another attorney, Bert Cohen, were there, correct?
Those people were there at the time. BC was not my attorney. I didn't realize I needed an attorney until I was subpoenaed.
But BC Choker was there.
I'm going to object to the relevance of this.
Ms. Cross, as I see this line of testimony.
And he did though, and Mac, he did voluntarily snitch. I don't know if he thought that this would never come up again at some point or whatever, but he was texting her and telling her everything.
Much of it is I'm taking in response to the original, how we started off this whole hearing, that Ms. Merchant had no basis whatsoever to bring this and she should be sanctioned. And I think she's laying that out. Okay. All right. Ms. Merchant.
I recall it was in a conference room in the front.
That part, Jeanette.
I don't know. I know you were handling a case in Judge Harris. I think I was speaking to Bert about a case, and BC was there to speak to Bert about a case. Yes, I think I do recall that happening, but I can't recall who else was there. It was a regular court date.
That conference room, that's sort of in Cobb County, there's a conference room in front of it.
Correct.
And it's not a public room, it's sort of like the jury room.
Correct.
And it was the four of us in that room talking.
I don't recall if anybody else was there. I will say that I do remember at some point it was myself, you, BC, and Bert there, but people were coming in and out of the court.
Yeah, I had heard the portion about the credit card shit, and he had to have known. You know what I mean? That, because it makes sense. Nathan was, I was finna say pregnant. Nathan was married. So if he was using the, Terrence Bradley's credit card, then he would claim to his wife that he was just paying Terrence back for something.
Room, so I cannot sit here and accurately say.
But allegedly, did y'all know this? Allegedly, Nathan's wife was cheating with Nathan's best friend. That was, when I heard that, I was like, what?
That somebody else wasn't there at the time.
Correct. And based on that phone conversation, I told you I had been submitting open records requests and I was going to continue to submit open records requests, correct?
Based off what phone conversation?
Based upon our conversation in court.
Oh, okay. Correct. You said that you were doing some open records requests, correct?
And then based on our conversation, I told you I was going to do some additional open records requests.
Yeah, is that $74,000?
Open records request are you talking about?
Just saying. Just asking if we talked about that I was going to be doing some follow-up with Fulton County.
Yeah, I didn't hear much about that. I heard somebody reviewing this whole thing, talking about the sexual allegations, but not showing anything. I forgot to look into that. I definitely will, though. Thank you, Jeanette.
Because I recall open records requests being made for other things, and so I don't know which one that you're referring to.
At that time we talked about getting, I guess it's called a county card, and getting access cards and things like that for coming in and out of Fulton County for you, Mr. Wade,
Okay.
and all of the.
My bad for the audio during something. You should have heard it at first. Where I got it, it was all type of interference in the background. This is the best, but it changes. It was weird.
Yes. And you asked me, did I have an access card?
And you are the one that told me that you and Mr. Wade, or that Mr. Wade at least had an access card.
I told you that the three of us had an access card because we had a contract with the DA's office or the county. I told you what those contracts were, and that we had an access card that will allow us to pick up the documents, go into a specific office, and leave out.
Right. Okay. And so we talked about that badge access card and asking for that I was gonna ask for that, right?
Correct.
And then a couple days later, I sent you a text, and when I say a couple days, so that was on September 12th when we had that conversation.
Do you mind if I pull out my phone?
Not at all. On September 14th, at 6:38 p.m.
And I don't know why they like grabbing on whatever they grabbing on by the mic, but there's a lot of mic interference. So this is that Ashley Merchant dude. This is who Terrence Bradley had sent the text messages. He just told her everything. I don't not like her. And then I don't like this dude right here. His last name starts with the S. I do not like him. He is rude. He is really rude, child.
And what day was this?
It was September 14th.
September 14th, correct.
And I sent you a screenshot of a Fulton County opening records request I did.
Yes, and I said, wow.
And then, and then we continued to text.
Wait.
Okay, sorry.
And then you sent another text about a badge, and I did not respond. You sent another text about an entrance card. I did not respond. You sent another text about some other badges and with a circle around it, and I did not
I
respond.
object, Your Honor.
Okay.
I'm sorry, thank you.
All right. Mr.
I-
Bradley, if you could just respond to the question asked and only the question asked.
That was
Thank you,
actually, I have an additional
Okay.
thing I want to raise. Ms. Merchant provided some text messages that she let us know that she was going to refer to. The text messages are inconsistent with Mr.
Like, and I'm looking at the mics trying to figure out who is touching their mic like that or around the mic to where there would be, be making that kind of noise.
Bradley's exchange as he apparently is reading it off of his phone. So if I could ask Ms. Merchant, it is true, accurate, and complete? And perhaps we could see what's on Mr. Bradley's phone. But more importantly, I am going to object. I understand the court's leeway about Ms. Merchant
Sure.
being able to establish contact based on previous statements made. But I'm concerned about going into the.
I swear we gonna be looking at that tomorrow. I figure because there's about 10 hours, 10 and a half with just the testimonies. So I figure like 5.5 hours of testimony per day will be caught up in a day. And then if we want to look at the closing statements, we can or whatever. I haven't edited that one, but
Content of the statements without putting things in the buckets that I've identified.
Sure. And so am I, Ms. Merchant. I'm not seeing so much the relevance of it back and forth. I'm allowing you to establish, the contact that was made and line with the outline you provided me. And I think we're on track with that. Were you planning to tender these text messages?
I was planning on discussing them with him. Now, if yesterday he said we didn't text about this case, so that was his testimony again today, then yes, I will at least show them to him to refresh his recollection or to impeach him. But their first part of their argument is foundation, is what I'm assuming. They're saying all of these. They're not all relevant. I can give you all of my texts, but they're not all relevant. And so they asked for screenshots, and so I took screenshots. If there's a way to submit my entire text history with Mr. Bradley, then that's fine. If they want us to read every single text, that's fine. I just don't want to be in a position where people are saying that I'm not.
Well, I also want to avoid the situation where you as counsel of record are having to lay the foundation and do that sort of thing yourself. So I don't know how much further we can go with this.
Yeah, and then Ashley Merchant was like, how much money do you have in your house? To Nathan Wade. Like, who would answer that question? Like, trying to make him a target or something. But when she was talking about how her dad told her to keep money in the house, now that's real, but telling somebody, like just telling everybody like that definitely could have made her a target. I mean, come on now. Stick up kids, home invasions. She just told everybody that she keep money in her house.
We get into that. So,
well, I'm not sure what their objection is. So I asked him about one question and he read off several other.
Why don't we just go with your next question and we'll see where we go from there.
All right, let's see.
But so
when she wait for her to ask a question.
I feel that, but telling everybody, I guess she and him both had to answer the questions, but that kind of made them a target. I'm just saying.
I understand that, Judge, and I'm not.
Well, apparently you don't, sir. Wait for her to ask a question, and you'll have a chance.
So I think the last thing I asked you
was safe, but how many times have people been, home invasion, right? Their home was invaded and then they got pistol whipped until they gave the code or something like that. Come on now.
About September 14th. So those texts that you're talking
I just don't think it's a good idea. But she does have a security team, so maybe, but also one of the reasons why she had to leave her home and go to Robin Yeartie's condo is because she was getting death threats to her home.
Yeah, those refer to the issue that we're here today about them.
Some text did, yes.
Yes, okay. And then you called me again on September 15th, 2023, and we spoke on the phone.
I do not recall that.
Well, I texted you and said I needed to call you back, and then I later called you back.
I'm not sure. I do not recall.
You don't recall that? Okay. And do you recall the following Monday,
Your Honor, I appreciate the question as it is on the form, and if the question is what she's going to read, I object to it even being asked out loud.
I think we need to make sure. There we go.
All right, so they cut to Robin Yeartie. This lady is a character in herself. These little, we'll call them 2 chains, these glasses holders or whatever, that shit had took me out.
Deputy Scott, if we could swear in the witness. Ms. Yeartie, can you hear us?
Yes, I can.
All right.
Raise your right hand down. You swear affirm that testimony you get a court will be the truth. That the truth will help you.
Yes.
Would you please state and spell your full name for the court?
Robin Latrice Yeartie.
Thank you, Ms. Yeartie. Thank you for being here. Can you tell the judge when you first met Miss Willis?
In college.
Okay.
So probably 90 or 91.
Okay. And have you been friends since 1990 or 91?
Yes.
Okay. When was the last time you spoke with Miss Willis?
March of 2022.
Okay. From 1991-ish till 2022, were you what you would consider good friends with Miss Willis?
Yes.
And did you all share
bags with the glasses on with the damn straps? I ain't seen the glasses straps in like years.
Personal information regularly?
Yes.
And did you even come and work with her at the DA's office?
Yes.
And when she needed a place to stay.
That ain't no better. He old as hell too. Shout out to her father. I ain't trying to talk about her father, but man, them stick up kids don't care.
Hey, did you let her stay at your apartment?
Yes.
It was a condo, right?
Condo, yes.
Okay. Do you remember approximately when she moved into your condo?
It was April of 2021.
Okay, great. And you know that Miss Willis and Miss Wade met at a conference in October.
I don't think so. From the sound of her testimony, which will come up in a minute, Robin Yeartie, it came up that she had performance issues. So I don't know if she was let go or what. And that's what ended her and Fani's relationship.
Of 2019.
I'm going to object to that, Your Honor, without a foundation for how this witness would know that.
Are you talking about Ashley Merchant?
If Ms. Merchant can establish she has personal information of that, then certainly that's something the witness can testify to. But if it's she heard
Understood,
it,
Ms. Cross. All right, Ms. Merchant, if you could lay the foundation.
Do you have information that Ms. Willis and Mr. Wade met in October of 2019?
I'm going to renew my objection, Your Honor. Information is not sourced.
I don't think she has her job there no more. Don't hold me to that.
To personal information. If the question can be rephrased, then that may address my concern.
So Judge, I just want to make sure that I understand. So they've objected to me calling Willis and Wade.
It's just a matter of foundation. If you can just rephrase.
Do you have knowledge of when Willis and Wade met?
I'm going to object again.
Oh yeah, you're right. Because Terrence Bradley stated that they don't do the law firm together no more. I didn't hear how that was resolved though, but damn. Yeah, because what I heard is that when Robert Yeartie was talking to Ashley, she gonna bring it up in a minute, that there was performance issues, and Fani had to say something to her about that.
Personal knowledge.
Overruled.
Thank you. Do you have personal knowledge of when Willis and Wade met?
Yes. She told me that they met at a conference. I don't know what conference.
Okay.
I'm going to renew my objection, Your Honor. Clearly, this is not firsthand information from this witness. It's hearsay that was.
But you said she told me.
Yes, it's statement against interest, Judge. If Ms. Willis.
Just pause.
I'm sorry.
Okay, Ms.
Yes.
Cross.
The representation of the witness, the testimony of the witness was that Ms. Willis, District Attorney Willis, had a conversation with her. There is no statement against interest. District Attorney Willis is not a party opponent in this case. The information that the witness has testified to came from Ms. Willis, and we have a hearsay objection to that.
Why wouldn't she be considered a party opponent in this context?
She is a representative of the state, Your Honor. This isn't private litigation or civil litigation. Obviously, the court's aware this is, Ms. Willis is not on trial. Ms. Willis is not a party to the litigation outside her obligation to pursue criminal charges for the state.
Ms. Merchant, I guess it's evolved into a hearsay objection.
Yes, Judge, and we plan on calling Ms. Willis to the stand. She's under subpoena, so hearsay will be cured. If there is a hearsay objection as far as that issue. But we do still think that it's a statement against interest. Ms. Willis has filed a document that states that they met at this municipal court conference.
Oh, that's the cameraman moving around, and the microphone is picking up his movements. I wish he would sit his ass down.
So,
Your Honor, I think maybe I can streamline a little bit. State will stipulate that District Attorney Willis and Mr. Wade met in October 2019 at the judicial conference that we've been talking about. There's no reason to get it secondhand from this witness.
Hey, Godmama.
That's true.
All right, you accept the stipulation, Ms. Merchant?
Yes. Am I permitted then to ask questions about that, since it's now not hearsay?
If it's just to a stipulation, if it's just to that basic fact, I don't think we need a question, but if there's a follow-up that you think is admissible, go for it.
Ms. Yeartie, you have personal knowledge that Ms. Willis and Mr. Wade began their romantic relationship soon after this time that they met at the municipal court.
I'm going to object to that question. That certainly is a leading question. No foundation has been laid for how this witness would have personal knowledge of that. Until that's happened, the state objects.
Judge,
I think you can do a yes or no. And
how's she gonna say that Robin wouldn't have personal knowledge of that when Fani was living at her house and also working with her at work? There was some talk about Fani and Nathan getting it in at the office.
Then follow up with how she knows it.
Thank you. Do you know if Ms. Willis and Mr. Wade started dating in October of 2019?
I don't know if it was October of 2019.
Could it possibly be November of 2019?
Could possibly.
Okay.
I agree, John.
And when we spoke, you said it was shortly after the municipal court conference, though, correct?
Yes.
Okay. So you know that their relationship, their personal relationship, began shortly after.
That's facts, Godmom.
This municipal court conference.
Yes.
And when I say personal, romantic. I just want to make sure we don't get in an argument over what personal and romantic is later. When I ask you personal, do you take that to mean romantic?
Yes.
Okay. And do you understand it that their relationship began in 2019 and continued until the last time you spoke with her?
Yes.
And you were essentially her best friend during this time, right?
Not best friend, good friend.
Good friend. Okay, close friend. And so
I bet you at the time, if you would have asked her, is that her best friend, she would have said, yeah.
Do you frequently socialize with her?
Yes.
And you saw her at work every day?
Yes.
So you had a chance to see them interact together on a personal level?
Yes.
And so from everything that you saw, heard, witnessed, it's your understanding that they were in a romantic
Doe Eyes TV
relationship beginning in 2019?
Yes.
And when you left the DA, I'm sorry, let me ask you, you said that Ms. Willis came to live with you in April of 2021. I'm sorry, April 1st, 2020 or 2021?
She didn't live. I never lived with her.
Okay, I'm sorry. She took over your lease in April 1st, 2020, correct?
No, 2021.
Okay, I'm fed. I have
it to you
both ways, so I'm glad you clarified. So when she took over your lease in April 1st, 2021, it's your understanding she moved out of the house that she was sharing with her father and started staying at the condo?
Yes.
And is it your understanding that that's because she needed to have her own space?
Yes.
Away from her father?
Yes.
Okay.
But I thought it was because people were sending her death threats. Now it's because she wanted to get away from her father.
When you left the DA's office, was it, were you fired?
No, I resigned.
Mac.
You resigned, okay. Just one moment, Jen.
In tomorrow's testimony, you'll hear Fani say that she moved to Robin Yeartie's condo and took over the lease because she was getting death threats and people were coming to the home, and even the father speaks on it as well. But it's very possible that she, probably wanted to sleep with Nathan, but not in front of her father. Like, that could be kind of awkward, I guess, because he lives there.
Can you tell us why you resigned the DA's office?
The number of things that was happening.
And then she spoke on her father being hard-headed and he wouldn't come with her.
Things that were happening, is that what you said, ma'am?
Yes.
Okay. What was happening that caused you to resign?
It was a spiral of things. So I guess the last straw is I was put in a department that I knew had no knowledge about. Something happened and I didn't like it. They didn't like it. And that was it.
Okay.
I wish they would have went into that more, because she said she was put in the department, something happened, they didn't like it, she didn't like it, and that's it.
Did you have any falling outs with Miss Willis?
Well, we never spoke after that.
You never spoke after that, okay.
Yeah, I thought that was her husband. Fani's husband had some DJ equipment in the garage or something like that he would go in and grab it or whatever.
And so you're, without going into all the painstaking details.
Yeah, but okay, I get your point, Jeanette. But what if, the dad met him, but they weren't having maybe the dad didn't live with Fani, when she was with the DJ boyfriend. I don't know, when he, moved in.
There's no doubt in your mind that from 2019 until 2022, Miss Willis and Mr. Wade were in a romantic relationship.
That's a fact, Mac.
What's the question?
You have no doubt that their romantic relationship was in effect from 2019 until the last time you spoke with her.
No doubt.
And that's based on your personal observations and speaking with them and seeing them together and things like that.
Yes.
Okay.
Damn, Fani, your ex-girl snitched on you, boo.
Questions. Thank you. The other folks may have some questions for you, Mr. Yeartie.
Say no.
You want me to go to the
If it's more than a couple questions, then sure, but if not.
It's only a couple questions.
Okay.
I think, can the court reporter hear me okay?
In this hearing you're talking about, John? Because I didn't see that. I thought only Terrence Bradley testified twice.
Let me be very specific. Did you talk with Miss Willis about her romantic relationship with Mr. Wade?
Yes.
Did Miss Willis tell you on more than one occasion that she was engaged in a romantic relationship with Mr. Wade prior to you leaving the district attorney's office?
Did she tell me or did I observe?
Let's go. I'm straight right now with the tell me.
Yes.
Did she tell you that in the year of 2020?
Yes.
In the year of 2021?
Yes.
Are you certain that Miss Willis told you about the romantic relationship with Mr. Wade?
I agree.
Prior to November 1st of 2021?
Yes.
Now, did you also have observations of Mr. Wade and Miss Willis together prior to November 1st of 2021?
Yes.
And are those observations, were those in a social setting?
Yes.
And did you observe them do things that are common among people having a romantic relationship?
Yes.
Such as, can you give us an example?
Hugging, kissing, just affection.
All before November 1st of 2021, correct?
Yes.
That's all I have.
Mr. Stocks.
Ma'am, did I understand you to say that there was a period of time when you and Ms. Willis lived together?
No.
Mr. Durham.
No, nothing from me, Your Honor.
Mr. McDougall.
Nothing, Your Honor.
Mr. Rice.
Good morning, Ms. Yeartie. Were you aware in 2021 of any trips, social trips that Ms. Willis and Mr. Wade took together?
No.
Are you aware of any social trips that Ms. Willis and Mr. Wade took together in 2022?
No.
And are you aware of them in 2020 or 2021 spending the evening together overnight?
No.
No further questions.
Mr. Gillen. Mr. McCullough. And Mr. Cromwell.
No questions, Your Honor.
Ms. Cross.
I do have some questions. Thank you, Your Honor. Ms. Yeartie, we haven't met before. Is that correct?
Correct.
You're able to see and hear me okay?
Yes.
All right. I want to start with a couple things. Now, I think you've made it clear that you never lived, and we'll call it the South Fulton address, the South Fulton condo that you were leasing. You never lived at that address with the District Attorney Willis, correct?
Correct.
And never at any time?
Never.
All right. You never observed or have any information about District Attorney Wade and District Attorney Willis and Nathan Wade living together, correct?
Correct.
You don't have any information about that?
No, I don't.
Anybody say?
Yeah, but Jeanette, what if, Robin thought that because Fani was renting her townhouse, that she could perform anyway at work, but Fani had, let her know that her performance was slipping, and then Robin Yeartie got into, she got in her feelings. Maybe Just throwing that out there as a possibility. Yes, about the credit card thing. That's a fact.
Said that that information was sourced to you, then that's incorrect.
That's incorrect.
Did District Attorney Willis pay rent at that establishment, at that condo while she lived there and you were living elsewhere?
Yes.
Who paid the rent?
She did.
And then was she even qualified?
Nathan Wade ever pay the rent?
No.
And you never told anyone otherwise? I didn't hear your answer there.
Yeah, why was it just a few people that testified? There's a whole office of them.
Ms. Yeartie, did you ever tell anyone otherwise?
No.
All right. So let's talk for a second about your time at the district attorney's
I did see those cell phone pings as well, John.
office. You were disciplined several times in the district attorney's office during your employment there, correct?
No.
You weren't.
See, this is what I'm talking about right here. Maybe she got in her fifis about Fani correcting her behavior at work.
Written up ever for poor performance, Ms. Yeartie?
Once, not several.
One time you were written up for poor performance. Were you counseled several times about your performance in the district attorney's office that was subpar?
No.
And the reason why I said that is because she only wants to take accountability for the one time yet, and it could be possible that Ashley Merchant doesn't know what she's talking about, but Ashley Merchant is claiming that there was more than one time.
Did the district attorney tell you that your performance was insufficient and that you were going to be fired?
No.
That never happened?
No. Maybe when we were at the end. What's the question?
The question, Ms. Yeartie, was did the district attorney ever counsel you on your poor performance in the district attorney's office prior and inform you that you were going to be fired?
That's a fact, Jeanette. You might be sleeping with, no, related to things like that.
I don't really know how to answer that.
I'm looking for the truth.
I don't really know how to answer that. I mean, the situation happened. That wasn't my fault. And I either was going to resign or be let go. So
You understood that that was the situation. You could resign or you could be let go.
correct, yes.
You were not welcome to stay.
No.
And I really wonder what that incident was.
And the conversation where you were informed that you could resign or you could be fired, that conversation was not the first conversation you had with the district attorney about your poor performance in the office, correct?
Well, it was kind of a spiral, but no.
Yeah, it was. Whatever the situation was.
See, that's why I feel like, in my opinion, that Robin Yeartie thought that because Fani was renting her townhouse, that she could act anyway at work.
Commentary by counsel. Questions are fine.
Understood, Mr. Sato. Ms. Cross.
Ms. Yeartie, the circumstances of your leaving the district attorney's office ended your friendship with the district attorney Willis, correct?
That's true, M. Mac.
Yes.
Y'all haven't spoken since?
No.
All right, I want to talk about the representations that you made here this morning, Ms. Yeartie, about any relationship between District Attorney Willis and Mr. Wade. I want you to tell me what was the first time let me ask it this way. You said that District Attorney Willis personally informed you of a romantic relationship. Is that what you testified to?
Yes.
When did that conversation that you purport to have to recall, when did that happen?
I mean, I don't have a month or a day.
Where were you?
Just talking in general.
Your Honor, we'd like to keep this witness under subpoena, but that's all the questions I have right now.
All right, thank you, Ms. Cross.
I have to recross then. I mean, redirect, I'm sorry.
All right, on those points only.
Yes, just this one. The state asked you a lot about when you were let go, when you resigned. Did something happen as far as purchasing that you didn't feel comfortable with, purchasing things through the county for Ms. Willis that caused you to not be comfortable working there anymore?
No.
And I didn't tell you how to testify here today though, right?
Right.
And everything you've testified to is from your personal knowledge?
Yes.
Okay. And you've told the truth here today?
Yes.
Okay. Judge, I believe she's only under my subpoena and I'm fine releasing her from that subpoena. Oh, I'm sorry.
By show of hands from other counsel, starting with Mr. Sadow.
Your Honor, I believe the door has been opened now to ask this particular witness about statements that Ms. Willis made to her. She brought it up on cross-examination on a couple of occasions. Did Ms. Willis say this or inform you of that? So I'd like to now ask her questions directly about what Ms. Willis told her about her romantic relationship.
She fluttering her eyes, rolling her eyes.
I think we'll take those one at a time, question by question, and we can address those to see. I don't know about a complete opening of the door. We'll see where we go.
The first time that you spoke to Ms. Willis about her relationship, romantic relationship with Mr. Wade, do you happen to remember what Ms. Willis said? In essence, not word for word, but in essence, what she said.
No.
Do you remember the first time she told you, in whatever words were used, that there was a romantic relationship?
That's a fact, Jeanette. Really, 3 of they credibility is damaged. Terrence Bradley, Nathan Wade, and Fani Willis.
No.
Like crazy.
Is this the kind of conversation that you had with your best friend, ongoing over a period of time in which it was common knowledge to you that there was an ongoing relationship between Ms. Willis and Mr. Wade?
What's the question?
Yeah, I'll ask it again. Is the nature of your then relationship with Ms. Willis?
Did she or did I thought Merchant communicated with Bradley, Terrence Bradley.
Such that you were having these
I didn't hear about her communicating with Nathan Wade. Maybe I missed that part.
ongoing conversations, that is best friend type conversations about her relationship with Mr. Wade.
I don't remember.
Okay. Without getting any further in too much detail.
What's good, Jay?
Is there any doubt at all that Mr. Wade and Ms. Willis had a romantic relationship, as was told to you, prior to November of 2020?
She was already asked that question by Ms. Merchant.
I just didn't know whether that needed to be.
She said no, no doubt.
No doubt.
All right. Any other defense counsel by show of hands? Seeing none. Last recross from Ms. Cross. Anything else?
Not this time, Your Honor, but we'd ask the witness remain under subpoena and subject to recall.
Judge, she's under my subpoena and I'm releasing her from my subpoena. So if they want to subpoena her, they're welcome to do that.
Ms. Cross.
I would prefer that the court keep her under subpoena. I think,
Sure.
Given the representation of Ms. Merchant, given how she intends to proceed today, that this witness may need to be recalled.
All right, understood. In the interest and knowing that we may have to bring witnesses back and forth, I think it's in the interest of effective presentation of the evidence here. Ms. Yeartie, you are still going to remain under the auspices of your subpoena. And so please stay in touch with your attorney. We may need you to rejoin us on Zoom at some point today.
I might have missed this, but Robin Yeartie stated that she was told that Fani and Nathan were together, but then that she also saw it. So why would she need to be told if you see them like kissing and shit or whatever, random acts of affection? It's pretty, common sense to let you that they're at least having an affair or something. Like I said, allegedly Nathan's wife was having an affair with his best friend during this time.
Tomorrow, understood?
Okay.
All right, don't discuss your testimony with any other potential witnesses, all right?
All right.
All right, you can log off.
And Judge, I'd ask, can Mr. Partridge stay on for just one moment?
For what reason?
The state had made some allegations that I misrepresented some things to the court, and
It's good, Belle.
I'd just like the opportunity to clear that up, that Mr. Partridge is the one that told me that they lived together for a month. They've called me everything but a liar today, and so I just think that it's appropriate for everyone to know where that information came from.
All right, Miss
Ashley Merchant is like a Karen. You know what I mean? I don't know, she's annoying as fuck to me.
Ms. Merchant, I think you've made your position clear. That's I don't think we need to get sidetracked on that. All right, Ms. Merchant, you can call your next witness.
Yeah, I didn't hear it in court. It was like one of those, it was on mainstream media, so take it with a grain of salt, but that's what was said. I didn't see like no proof or nothing like that. And also the lead attorney, I've been watching him too. He had said it as well.
He may have told you something, but it does not appear that there's any evidence that the client ever waived and allowed that information to be conveyed to you. Next question.
Thank you, Judge. All right, let's see. So
that's an interesting point, Jeanette. Jeanette said, why didn't they bring his wife to testify? Yeah, that's true, Jeanette. Could be.
We talked about Ms. Willis and Mr. Wade coming to and from your
right, because aren't they still married? But maybe, yeah.
office and security details following them. Do you recall that?
Technically, because that's her husband, she wouldn't have to testify.
Do I need to look at my phone?
No.
Just asking if you
recall. Do I recall?
Yeah.
I think I did, yes.
Do you recall security taking Ms. Willis to your office?
I'm going to object to that.
Does he recall
Actually, I
Ms.
say that
Willis
back. No,
taking?
I don't object to that.
But you can answer the question, sir.
I do recall security detail bringing Ms. Willis to my office.
Okay. Do you recall approximately when that was?
I do not.
And was that on more than one occasion?
I remember 2 occasions.
Okay.
Yes.
Can you tell me about those?
Yeah, but they were allegedly going through a divorce for years now, which it does take sometimes years for it to happen. This is Terrence Bradley, Nathan's alleged, divorce attorney back then. So, yeah.
I can't remember when they were.
Were they before she became DA?
So I don't know if she had a security detail before she became DA. So, I mean, if she was sworn in, or I don't remember the dates, but I do remember. I think she was DA.
Maybe during her transition team period? Was that?
No, it wasn't. Trying to remember. She would have had to have been the DA, I think. And I don't want to go on, I think. But I do remember twice her coming to our office, correct?
And she had a security team both of those times.
There was yes, she had a security team with her.
So if she had a security team at that time, why did she have to move out of her house because of death threats and shit like that? Now I get it, her dad was there and he could feel rough and tough and all that. But where was the security team then? Wouldn't they, have somebody at her house or maybe outside or something like that? It's interesting.
And do you believe that it's a different security team than she has now?
I don't know her security team now.
Well,
however,
I'm sorry.
I don't know her security team now. I don't know her security team now.
Do you remember telling me that it changed at some point, her security team?
Yes, I think I recall saying that, yes.
And that the most likely people that could testify or had seen things about them having a romantic relationship early on would be the original security team.
I don't recall saying that, no, but
Do you recall talking to me about other people that might have known about their romantic relationship?
I recall.
Yeah, objection based on we don't know the source. This is either based on privileged information or it's hearsay. Neither one is.
It's neither. I asked if you recall.
You need to clarify it. If you're actually going to think, if you think that this draws on information from outside the relationship that he's already testified to, then you need to lay that foundation. Let's sustain.
Are you aware of other people that you believe would have known about when their relationship began?
I object to the relevance of that. Again, the witness has testified he has no firsthand information of it. Anything he knows about the topic came from representation. Who he thinks might have been able to say something else is speculation, not relevant to anything, and a backdoor to get in the gossip and innuendo that has been pretty much this entire.
All right. Okay, Ms. Merchant, I think we're getting to the point where, you know, the reason I thought this line of questioning was appropriate was to rebut certain inferences about why we were here in the first place.
Right.
But to go into it at the granular level, I'm not as wild about. So if maybe you can ask more overarching questions, and if you have anything else you think that's relevant, then you can get to those as well.
Isn't it true that I gave you a copy of the motion to disqualify in this case? I emailed it to you and you read it, reviewed it, and emailed me back that everything in it was accurate, to your knowledge.
You emailed me, and
Objection.
Okay.
And I wonder, was he mad or is he still like at odds with Nathan? You know what I'm saying? Him and Terrence. Because like, what would make him just come forward and give, you know, the other side any information besides the fact that he wanted to sleep with Ashley Merchant? I don't know what else. I mean, all these text messages back and forth and all this and that about his boy's business. I mean, morally, it would be good to tell the truth, but this is just very, very odd.
All right. So there are things contained within that, Ms. Merchant, which he has now said fell within the privilege and that he did not have the ability to waive. So I think that's where we have to.
Or you mean the talk of divorce? Because he's still married, isn't he?
And I believe I still have to ask the questions, and then if he wants to assert the privilege.
Well, I think we pretty much already established the privilege and the objection has been made. And I think it's a valid one at this point based on the record. So the answer was he did acknowledge that you sent him the motion, and I think we leave it at that.
Let's see. And you had knowledge about an apartment. I'm not asking what Mr. Wade told you in furtherance of legal advice, but you had knowledge about an apartment in East Point or a condo in East Point that was owned by someone, and Miss Willis was staying there.
Judge, privilege.
I think in the way the question's phrased, she qualified that. So
I did not have knowledge.
You did not have knowledge.
I did not have personal knowledge
Oh, okay, I got you.
at all. No,
So no knowledge outside of what is privileged.
that's correct.
Did you have texts between yourself, Miss Willis, and Mr. Wade?
Do I?
Have you ever?
I have. Maybe once or twice, but
Damn, I didn't know that, John.
Did Mr. Wade ever ask to use your credit card to pay for trips?
Objection. On privilege, I think it's still the same thing.
just asking you to use your credit card. How's that in the nature of furthering our divorce proceeding?
Okay, I didn't even know. She's out here doing interviews too. This is crazy.
I have a business card, and we would use my business card. use my business card.
For travel?
Are you asking if I use my business card for travel?
Would Mr. Wade use your business card for travel?
Just say yes, dude. You know the answer is yes.
I recall I recall a trip, but I don't know if that trip has anything to do with this case. So I do recall him using my card once.
When was that?
And I don't even know.
Right, he doing the most. You know who else did the most too? Nathan Wade. He was up there. Merchant must have asked him a question. He literally waited like 3 minutes to answer the question, and it was like an easy question. Like, what the hell?
And that sounds true.
I guess they be thinking if they don't answer like quickly or whatever, you know, another question will be answered or they won't have to answer that one. It was just crazy.
I recall him using my card once, but I cannot remember what that was for. I do remember it was a trip, but I cannot actually state, where it was and who it was with or anything like that.
And he paid you back for that trip in cash?
I can't remember how he paid. I think it was. I mean, I'm not certain if it was cash or a check. We routinely would use my card for filings, for paper, for whatever stuff with the office.
I'm sorry. You're done, sorry.
And so he would, whether he paid me back in cash or whether he wrote a check, it was paid back to the business card.
But this was the only time he had used it for travel.
Facts. Now, Terrence isn't married, is he?
I cannot recall. I don't even have that business card anymore. But I do recall at least once for travel, yes.
And that's got to be cap, because you mean to tell me somebody is spending money off of your card in the amount of like going on a trip somewhere and you can't remember? Like, that's cap.
And that was when you were still law partners with him,
Facts.
Do you recall approximately when?
Especially if you knew you had to testify, wouldn't you want your statement to be accurate?
That was.
I do not.
You did not go on that travel with him, though, correct?
I did not.
Okay. And so he asked you to use your card for the travel.
Yes.
Yeah, of course he was, because like I said, he was having Terrence Bradley charge the shit, or he was just charging it, and then he would pay him back so his wife wouldn't find out all the money he was spending with Fani.
I mean, I'm assuming. We would use the card for firm stuff, and so it was a business card.
Your business card, though.
It was my business card, yes.
Right.
The law office of Terrence Bradley, correct.
Okay. So it showed up on your accounts.
That is correct.
Okay. Wouldn't show up on his accounts, is that correct?
That would be accurate, yes.
Do you know if this was before he became special DA in this case, special prosecutor?
I cannot recall.
Did you see he and Ms. Willis together? You said you were in and out of the office, in and out of the DA's office. You saw them together, correct?
In and out of my office or the DA's office?
The DA's office.
Correct.
You saw them together in and out of the DA's office?
Did I see them in and out?
Yes.
Well, if you preface it like that, no. I saw him in and out of the office when I would be there doing my filter work for the tank team.
Okay.
He would come by. I rarely saw Miss Willis and Mr. Wade together in the DA's office.
You could tell by the way that he squints his face and the way that he talks, like explains his shit. He's trying so much to, like, you know, not get Nathan in trouble. But at the time, apparently, even January-ish, he was having, Terrence Bradley was having these communications with Ashley Merchant via text. So, like, wow, bro.
Brought up the tank team. Let's talk about that for a minute. Tell me about, you did work as, you had a contract as a tank lawyer, correct?
That is correct.
Okay. And that was in the anti-corruption unit?
Yes, I think so. Yes, correct.
And how did you get that contract?
What do you mean?
The anti-corruption unit? Yeah, okay.
I didn't get it.
How did you get the contract?
It was.
Bid? Did you apply online?
Oh no.
In his office?
It was proposed.
By who?
We were. It was proposed by.
And I bet you, Nathan probably didn't pay Terrence all the money back, and he probably was like, "Fuck that, dude! I'm taking my business, my friendship somewhere else, buddy." I don't know. This shit is crazy.
I didn't speak directly with her.
Okay.
It was with Mr. Wade, and he asked if we would be interested in having a contract with the Fulton County.
Okay.
Yeah, it's the way that he's squinting or just sitting in there, like his body is like, you know, tight on the inside. He definitely like defensive without being defensive, like outwardly, you know, being confrontational with Merchant, but he is drawn into himself.
Yeah, Campbell?
Look like a kid up there that's in trouble. He about to get suspended from school.
I think so. I mean, I can't recall if he asked us both together or not.
God, shinier and shinier.
Rarely. We all handled several, different things for the firm.
Okay.
Criminal, personal injury, things like that, family law. And so rarely were we together there at the same time, like for an abundance of time. So he may have called me and then he may have called Chris. I can't recall how we got the contract, but.
Did, was Mr. Wade, to your knowledge, part of the transition team for Ms. Willis?
To my knowledge, he was part of the transition team.
Did he spend?
Yo, when he started sweating, I thought he was crying though, because it was like all down by his eyes.
A lot of time at that office during this transition period.
He did.
So from when Ms. Willis took office to when you left the firm, did Mr. Wade spend most of his time at the DA's office?
When you say most of his time, you're saying just working business hours?
Yes,
or
working business hours.
I would say he spent I would probably say he spent majority of time. If you say over 51%, I would say yes, he spent over 51% of his time.
Okay. And that was the entire time from when she took office to when you left the firm?
I can't say that was the entire time, but yes, it was majority of, it was I can't pinpoint specifically when the time that he would spend. I think if my memory serves correctly, getting to the majority of the time, it would have been whenever he started with this, maybe.
As a special prosecutor?
When you say majority of the time.
Right. Okay, so let's talk about the time before he became special prosecutor. Did he spend a lot of time at the DA's office then?
He spent time. I mean, it depends on what you say is a lot. He spent time at the DA's office, correct?
And so, just so we're clear, you were hired first on January 25th. Both you and Mr. Campbell were law partners, and you were both hired by the DA January 25th, 2021. Is that correct?
Repeat the question, I'm sorry.
You and Mr. Campbell,
yes.
Both?
How didn't he hear what she asked? What is he listening to?
Were hired on a contract basis by DA Willis, January 25th, 2021, correct?
Which contract are you talking about?
The first one, the taint contract, not the first appearance contract, the taint. Okay, so what was the first contract?
To my knowledge, the first contract was the first appearance.
Okay, so let me just mark these and see what I'm doing. 23.
He can't remember nothing.
4, 25. Judge, when they're done reviewing these contracts.
That damn coughing.
This rally showing you it's been marked. I think it's at 23, 24, and 25. You can just look at those.
He must have dry mouth. He definitely has 2 waters up there. To drink them. Bottom what he said. Think about it, y'all. He probably seen Nathan Wade, frolicking around with Fani, right? And he was like, I'm going to find me my Fani. And he thought it was going to be Ashley Merchant. And he got played by her. Right? Now he can't read. This man was in college for like 12 years, and now he can't read. Or he can't find the paper. And when she asked him, it was not that much to be reading and flipping through pages. What is he doing? I swear he thinks she gonna be like, just never mind, Terrence, just never mind. And ask him something else. He playing.
Okay, that's it.
So on now that you've reviewed those, is it true that on January 25th, 2021, you got your first contract as a taint lawyer?
As a taint lawyer, yes, I see the date on that as a taint lawyer, but I'm also looking at this contract here for first appearance, and there must have been. I don't have it for me, but there must have been a contract before this.
Okay, so you think there's a 4th contract?
I can't say that there is or isn't. What I do know is that we did first appearance during COVID, and it was before 2021. So I don't know, if I had a written contract at that particular time or anything, but I do know, I think that you could look at the recordings because everything was recorded at that time, as to when the first appearance contract started and the taint contract started.
So when the three of you were partners, you had at least 2 contracts to do taint work, which is filter work, and then at least 2 contracts to do first appearance work. Pretty much throughout.
It's the fact that they call it taint work. What's good, Mac mean? What's good with you?
Entire 2 years, right?
Well, it renewed. So, I mean,
yeah, but also can he be disbarred because he lied or had involvement in it? Like, if he up here lying on the stand, right? Because they had him come back, and we'll look at that testimony tomorrow or whatever. But if he go up there and lie, can't they take his, take his attorney license? It's crazy. Come on, damn it. Hello.
it just renewed. So yes, I mean, if it was the same contract, but it was a renewal of.
And so how did you, and you said you got these contracts through, Ms. Willis gave them to you, but it was through her knowing Mr. Wade, correct?
Yes, I didn't have a meeting with Ms. Willis or anything. It was brought to the attention that a contract was going to be needed or awarded, and if I was interested, because this was
right, exactly, and definitely unethical. This shit's crazy.
Off mine, and I said yes. And so,
I mean, to me, the trips, the money that may or may not be accounted for, that's pretty odd. The sex thing, that's just scandalous, but it should be a conflict of interest. I'm just saying.
And so Mr. Wade brought that to your attention?
He asked if I was interested in doing the contract, correct. And then after that is when.
Yeah, because wasn't he up there? He was saying that violates client attorney privilege and stuff like that. And that's why they called him back up there like, no, it doesn't.
Ms. Willis, would come in, or I think we actually came down here or something.
That part right there, especially for trips.
And signed the contract.
Like, it's not like he was going to buy office supplies with it.
Okay. And so that is how you were paid from Fulton County, these contracts.
From Fulton County government? Yes, ma'am.
And you shared your partnership, you shared a third of all your profits with Mr. Wade?
At that time, yes.
And so his contracts, he got a contract that same year, 2021, and he shared a third of all his profits with you, correct?
Yes, that should be fairly accurate.
Okay. So during 2021, 2022, you all had 2 filter taint contracts. You had 2 first appearance contracts, and you had Mr. Wade's special counsel contracts, correct?
My firm had what I have here,
Okay.
correct?
But Mr. Campbell and Mr. Wade were part of your firm, correct?
So I don't think at this time we had established WBC.
Okay.
At this time, I think I had mine, Chris had his, Nathan had his, and we operated in the same building. But if you ask me, did we fee share or, without everything that came in, yes, that is correct.
So you weren't actually partners, you just fee shared?
At this time, well, yes, at this time, we were not.
So you weren't even partners in a firm with him, and you let him use your credit card?
We were, at this time, I had.
That's hella trust right there.
Law Officer Terrence Bradley, Chris Campbell, PC, and whatever Nathan's was, if I'm not mistaken. I'm just,
And all these the taint contracts and the Nathan's special counsel contracts, all of those were under the anti-corruption unit, correct?
first appearance was not under that. The tank contract, if I recall, was under the, I don't think they called it, what are you calling it?
You can take a look at your contract if you need.
Okay.
And I'm
The irony of all this coming from the Anti-Corruption Act.
I'm not asking about the first appearance. I'm asking about the taint contract and then Mr. Wade's contract, which has already been admitted in evidence if you need to look at that.
Again, this man is supposed to be an attorney. He's supposed to remember several details at one time. Think about it. Oh, my damn thing. Okay. Wait, it's working now. Think about it. In a case, he got to remember several details about the case. But for these little ass questions, he got to refer to this paperwork.
Let me know when you're done reviewing.
Well, I see on the first page where it says taint attorney, and I'm trying to go through and I see where it continues says taint attorney, but it always says Fulton County District Attorney's Office. Your question was specific as to the anti-corruption unit, and I'm looking for the verbiage of anti-corruption unit, so I apologize.
Oh, no, take your time.
I mean, this is this man's money. How would you not know? A lot of people know when they started working certain jobs or whatever. You know what I mean? Like, this is wild. Because he ain't really looking at nothing. He really thinking in his head what he gonna say to get out of this one.
And see, on both pages, I mean, it starts out Fulton County District Attorney's Office, and then it just goes to initials FCDA, unless I'm overlooking where it says the anti-corruption unit, then the contract was with the FCDA. I mean, unless you want to show me something.
I'm just asking you, and I didn't know if that would refresh your memory. Those contracts were for the anti-corruption unit, right?
Well, they were for the
Is that who you worked for?
I worked for the DA.
Okay.
I worked for the DA.
Okay, so just in general, the DA.
Correct. I worked for Fulton County District Attorney's Office in as a contract person, as it says here.
And the
contract person.
When you did the taint work, you had to report to Sonia Allen?
I did not.
You did not. Who did you report to then?
I can't remember his name. His first name was Brian.
Okay. And let's see. So I know you said you met with Ms. Willis when you signed those contracts, right?
Yes, I know I met at least one time to sign these contracts, or to sign when I signed the contracts, yes.
Did you meet with her any other times?
I did not personally meet with Ms. Willis any other time. When you say meet, what do you mean meet with?
Talk with her, meet with her.
I mean, I would see Ms. Willis in passing if I'm walking through the office and something like that. But no, I didn't have any meetings with Ms. Willis.
Okay, so the only times you met with her were when you signed those contracts.
What if I meet with? I mean, I
sat down and had a conversation with her.
Terrence is playing a deadly game up here. Clarify meet with. What do you think meet with somebody means?
I signed these contracts. So when I signed these, I met with her to say that I sat down and
not if she was the one paying him.
Spoke with Miss Willis. Are you saying in life, and you saying during this time? What are you asking me?
I mean, if it's voluminous, I can narrow down the times, but I wasn't.
Ms. Merchant, I haven't really heard a point in a while. Can we get along to something,
Yes,
or we're going to have to wrap it up?
Yo, and then the judge, the way that he was losing his patience with her several times throughout these testimonies was cracking me up. Like it was appearing patient, but you could just tell that he was like, come on, like, hurry it up.
So I had one more question about your text.
You wasn't trying to hear
Have
it.
you ever been in any group text with anybody other than with me and somebody other than
Stall him out, lawyer.
You're gonna narrow that down. I'm sure
I can look at my phone.
No, with him, if there have been any other texts. And I think that state had some things in rebuttal they mentioned. So I was just trying to clean that up and work out there.
And when he called, it was out of the blue, but he did call. Yes, ma'am.
Okay. And you relayed that to me as well, correct?
I did.
And then you also got a call from your best friend who was relaying a message to you from Mr. Wade, correct?
See this bead of sweat right here? I thought he was crying.
No, I got a call saying that he got a call, not that a message that was supposed to be relayed to me. The call was.
I'm going to check if there's a hearsay. It's the response to the call for hearsay. Thus far, it hasn't. But
Sure. So here's the objection as to the contents of the call, Ms. Merchant.
I believe the contents of the call were to remember your privilege. I took that as a threat. I think Mr. Bradley took it as a threat. I think he would testify to that.
he hasn't testified to it. He also said there wasn't any message relayed by Mr. Wade or any party.
Well, no, he didn't say it by any party. So
you looking at her like, bitch, I will fuck you up. You got to think about it. Like, he's probably thinking about his whole career up here, his credibility, everything.
Assuming he did hear something from a party.
Then what if, like, you know, recently him and Nathan had patched up their shit and this just opened up a new wound when Miss Merchant got to bringing up all, you know, these texts that he had thrown Nathan and Fani under the bus.
What's the hearsay exception for that, Ms. Merchant?
I believe that it was a threat, so it's a statement against interest. I'm sorry, it's a if he took it as a threat to influence his testimony, then it's not hearsay, then it would be admissible.
All right, so
I did not take it as a threat.
If you're saying it's to the effect on the listener, perhaps?
Yes.
Then we'll go from there.
Were you told to remember your privilege?
Right, because he's definitely trying to figure out what he's going to say. And if he would just tell the truth, it would just come out, you know, smoothly and shit. I mean, he's taking like 3 minutes to answer the stupidest, like, well, easiest question, rather.
The witness just testified he didn't take it as a threat.
Understood. I'll overrule the objection. The testimony given the weight it deserves.
And imagine you lose your law degree, right? Or you're sued because Nathan and another person had sex or did this and that, and you didn't distance yourself. That's crazy. I mean, the man went to school for like 12 years.
To remember your privilege.
I was not
a witness. There may be a potential witness.
That part, facts.
Now in the courtroom, because the person that Ms. Merchant is referring to is sitting in the courtroom.
Well, if that witness hasn't been told to testify, then I don't see any sequestration issues.
I don't know who it is. I don't know his name.
Okay, and so were you told anything to that effect, Mr. Bradley?
Repeat the question one more time, but so I was not told, remember my privilege.
Something about privilege, remembering that.
I do recall privilege being mentioned, but it wasn't remember your privilege or a threat of any sort.
But you immediately called me after.
I mean, and what would make him get a hold of Miss Merchant, and just start texting all this man's business to her? Again, I think that he was trying to court her. He thought Miss Merchant was fine. He see Nathan over here hitting Fani. So he like, shit, let me get one. No.
I called someone else after.
You called me quickly thereafter then.
I talked to you that day, yes, ma'am.
Okay, thank you.
Sit down.
Your Honor, because this is a defense witness, is it the state's first cross? I think that's how we had been doing it yesterday.
No, actually, we're doing it just this way.
Yeah, I've been,
Okay.
this is the first time he's gone, and then we go through all the defense, and then you'll have your chance.
Some foundation questions to begin with, please. Your testimony as you began representing Mr. Wade as his attorney on what date or what approximate date?
I didn't have an approximate date.
Okay. And give me an approximate date when you began acting as Mr. Wade's attorney.
I would say it was, if I'm speculating.
I really don't want you to speculate. I mean, you're the one that was the attorney and Mr. Wade was the client.
Correct.
So give us the ballpark figure of when it was that you began acting as his attorney.
Like, wouldn't he know this already? Because the date would be on any paperwork that he filed initially, in, the alleged divorce of Nathan and his wife.
Maybe 2017, 2018, I think, maybe.
And the purpose for which you were retained?
His divorce.
So, according to you, from that time period,
I think it was a tear because notice is gone now.
Your communications with Mr. Wade.
He do look like a milk dud. His head shiny as hell too.
Regard to the divorce or any matters related to the divorce, is your position are confidential? I'm sorry, are privileged, correct?
Yes. Yes.
Okay, good. Now, did you ever meet with Ms. Willis and Mr. Wade prior to, and everything I'm asking you is prior to November of 2021, okay? Keep that in mind. That's.
Why are you yelling?
I don't think he's yelling, Mr. Bradley. He's just speaking up. All right, Mr. Sit down. Let's go.
Okay, thank you.
Now, I will say that this attorney that's talking to him, his last name starts with the S, but he's a douchebag. I don't like how he was questioning Fani or other statements that he made in the courtroom. I don't like it.
To Mr. Wade getting his contract with Fulton County, which is November 1st.
Not Nature Boy's father.
2021, okay? Please keep that in mind.
November 1st of 2021.
Right. Did you ever socialize with Mr. Wade and Ms. Willis prior to November 1st of 2021?
I've never socialized with Mr. Wade or Ms. Willis in any setting. If you're asking, have I ever met with them, then I would say yes. But when you say socialize, what do you mean socialize?
Have you ever gone out to eat with both of them?
Before 2021, I do not
Or
think.
November 1st of 2021.
Out to.
The man is a whole lawyer and he don't know what socialize means now. So he don't know what meeting up with somebody means or socialize.
Eat with both of them before.
Where did he get his law degree? In a Cracker Jack box?
When was she sworn in? I'm sorry. When was she sworn in? There was a dinner before, when she was sworn in that I attended. Shaquille O'Neal was there. So it was like her inauguration dinner. So I'm thinking that's before 2021. So I would say
Let's
yes.
assume for purposes of my question that
Yes,
that's in early January of 2021.
So that is early January 2021. So yes, I mean, it would be before November. So if it was January, yes, that dinner would have been in, I'm assuming January.
Okay. And any other time that you socialized, went out to eat, went to anyone's home, you know what socialized is?
Exactly. So no, I did not socialize with Mr. Willis.
Nathan Wade got this thing with his jaw and his nose, how it comes down. It was annoying the hell out of me. I can't wait till we gonna go there next. And then, like I said, we'll come back for Fani's testimony. Her father, Terrence Bradley, comes up again, as well as somebody else. Roy Barnes. What's good, Uncle Shug? Roy Barnes comes up there, y'all.
I mean, with Miss
I said that
and
like
Mr.
y'all
Wade.
know who Roy Barnes is. I think he's the governor or something like that there.
So prior to
Wait,
November
what?
1st of 2021, did Miss Willis come to your offices? Your offices, I mean the offices that you shared with Mr. Wade.
I think she came once or twice to our office, correct?
And the purpose for which she came?
I don't know. We had separate offices. I do recall. I do recall some type of meeting happening at our office, and I don't know what that was about. I wasn't a part of those meetings. There was a meeting. There were other people there. There were other people from the, I want to say DA's office there, maybe.
He sounds like he's like talking about a dream that he had, not an event that he actually went to. In my opinion, it wouldn't be that much thought. Now, maybe he would leave out a couple of key points or whatever, but the way that he's describing it is exaggerated.
Okay, let's go back to the basics. Ms. Willis came to your offices, together offices, on a couple of different occasions.
I recall Ms. Willis coming to my office at least twice.
And on at least one of those occasions, or you tell us, did Ms. Willis meet privately with Mr. Wade in his office that you observed or heard?
I can't recall.
You can't recall?
No.
Did she ever meet with you in your office? Ms. Willis now.
Privately in my office? No. I've never met privately in any office with her outside of signing this contract.
Did Mr. Wade, prior to November 1st of 2021, ever talk to you about socializing with Ms. Willis?
I can't recall.
You can't recall?
You're asking me if he ever mentioned to me that he socialized
with Ms. Willis, correct?
And I'm saying I cannot recall if he socialized with Ms. Willis, if he ever mentioned to me that he socialized.
Did he ever mention to you that he ate?
So this man uses your credit card to go on extravagant trips and shit like that, but you don't know. Come on, like men don't talk like, hey, you bagging Miss Willis and all this and that. Come on, bro.
I went out to dinner with Miss Willis. Again, time period before November 1st of 2021.
Yeah, and I believe he has 2 attorneys. The second time he testified, they were over like where the juries sit, because Terrence said that when he was looking forward, Nathan Wade is there or something. He kind of hinted that Miss Merchant was stating that they were giving eye contact or communicating some way that way. They may have, though.
Did he, repeat your question?
Mr. Wade ever tell you prior to November 1st of 2021 that he had socialized, gone out to eat, visited Miss Willis in anything other than a professional setting?
I'm sure he did, maybe. I don't recall any specifics of any dinners, any specific places.
Right. Did he hear them having sex?
It's been 3 years ago, the time frame, but I do not recall at this time whether or not he ever mentioned any dinners or socializing.
Did Mr. Wade mention
Hey, Chief Callie, salute to you.
to you that he visited Miss Willis at Miss Willis's then current abode, which would have been a place, not her original house, but a place she was staying in the period of 2021 before November 1 of 2021. And his question is, did Mr. Wade ever tell you that he visited Miss Willis at her house?
I don't think I can answer that.
Yeah, that's a privilege based on communication with my client, also based on hearsay.
Mr. State, if you want to try and rephrase the question, you can, but otherwise that would be sustained.
On both grounds or just on the privilege ground?
Just both. I didn't hear a second ground.
It was a hearsay ground.
Oh, that would be on privilege alone.
Did you talk to Mr. Wade at all about his relationship with Miss Willis prior to November 1st of 2021?
I think he's just laying a record, Mr. Wade. It's okay. And so on those same grounds, Mr. State Allen, all subsequent grounds, apparently the relationship with Miss Willis in any way is covered by privilege according to this witness.
Well, I think the key words, respectfully, Honor, are according to this witness. So I'm trying to drill down to see if there are communications that are not within the privilege.
Sure.
I can.
So then we need to acknowledge the privilege in the form of your question, right?
You're asking me to ask it as in a way of saying, are there any non-privileged?
Essentially.
Okay. Did you ever communicate with Mr. Wade prior to November 1st of 2021 about Miss Willis that was not privileged?
I mean, we discussed this contract, but
this contract doesn't help. You have to give me a exhibit number, please.
You said before November 2021?
Yeah, November 1st of 2021. Before November,
this contract for 1/25/21 is before that. So I mean, we discussed this contract.
Okay. And if I remember correctly, again, just give me that exhibit number so we can reference
Exhibit 23.
Okay, hold on 1 second. 1 second. On exhibit 23, did I understand you to say that it was Mr. Wade that in effect brought you and Miss Willis together for the contract?
That would be accurate, yes.
Okay. And what did you understand was the relationship at that point between Miss Willis and Mr. Wade for Mr. Wade to be able to bring you to Miss Willis for the contract? It's not a hard question.
I'm just, say that again.
Mr. Wade is the one that basically says to you.
And I'm going to tell y'all something too about body language. When people squint like that, that means that they're uncomfortable with the conversation, basically.
Go see Miss Willis about this contract, right?
Because there's no reason for him to be squinting. There's no sun in there. You know, squinting doesn't make you hear better.
Okay. That's a yes, correct?
Yeah. Yes.
So Mr. Wade had to have some knowledge, you would assume.
Yes.
Right? That you going to Miss Willis might bring you the contract.
I never went to Miss Willis. So I stated I never went to Miss Willis.
No.
I was told about that there was a potential contract, and I was asked by Mr. Wade if I would be interested in doing that contract.
My question to you is, what was the basis that you understood Mr. Wade being able to essentially offer you that contract on Ms. Willis's behalf.
I'm going to object to that. That's a mischaracterization. Mr. Wade offered it to him. I think he said he expressed interest. And also, I don't see the relevance of this at all.
So just in terms of relevance or phrasing, I'll overrule on those grounds. So the question is standing unobjected to, Mr. Bradley.
Can you repeat the question?
You've explained to us how the contract
Yes.
came to you, correct?
Yes.
And my question is, what was your understanding of the relationship of Mr. Wade and Ms. Willis for it to have been offered, or whatever word you want to use, for him to have said, expressed to you whether you had an interest in the contract?
Privilege.
Mr. Evans is no privilege in that question.
Because how would he be able to agree if he didn't sit down with her?
So Mr. Sayal, I think you need to clarify whether.
And now I'm confused because I swear earlier he said he did when it came to the contract.
Privileged conversation that you had with Mr. Wade that let you know about the contract?
Or you know, it was the relationship.
Look at his eyes.
Focused on.
Is the nature, I'm trying to do it in such a way, and I understand what the court said. Was the relationship that I asked you about just now between Mr. Wade and Ms. Willis that gave rise to the contract? Did you know about that relationship as a result of an attorney-client communication?
No, I knew of that through whatever work they did together as municipal court judges.
And how did you know that? Who told you about the work that they did together as municipal court judges?
Mr. Wade told me that they did work at some conference.
Okay, now this would have been something that Mr. Wade said, according to your time period, at the time that you were representing Mr. Wade, correct?
Say that again, absolutely.
Mr. Wade would have told you what you just told the court after you had established an attorney-client relationship with Mr. Wade, correct?
Yes, but when he told me of them being at a conference, I mean, I'm not understanding how relate. I'm trying to understand your question.
Well, my question is basically, you had communications with Mr. Wade directly that
Yes.
were not attorney-client privilege, right?
I've had conversations with Mr. Wade that were not attorney-client privilege, yes.
That involved Ms. Willis, correct?
I just stated that they were at a conference. I don't know whether or not that involved her or not.
Well, if he's talking.
How didn't it involve her if you just said that they were at a conference? Clearly it involved her.
About her, that is, if Mr. Wade is telling you about Ms. Willis and Mr. Wade having met at a conference, right? And he's talking about Ms. Willis, correct?
Yes, but he also told me about other people that he met at the conference.
But he told you about Ms. Willis as well, correct?
I think so, yes.
Okay. So there were communications in which Ms. Willis was at least a topic that was not covered by attorney-client privilege, correct?
This particular instance, I was told about a conference. And
when were you told this? I
can't remember the dates of the conference, but it would have been after the conference.
Okay, I'm trying to get just the time period here. After the conference, I want you to understand from the record, I believe we've shown that the conference was sometime in October of 2019. Okay. So could you give us an idea, that being?
Somebody above had said that they were together since 2019. That might be correct.
A fact. When you would have had this communication about meeting with Ms. Willis at the conference, that is Mr. Wade meeting Ms. Willis at the conference?
If that's the conference that they were at, yes, then, I don't know how many municipal court conferences there are. I do know that at the time that I was in the firm, Mr. Wade was he had some position with the municipal court.
Yeah, right now, my only question is time-wise, assuming it's October of 2019, when do you tend to remember? What's your best recollection of when Mr. Wade told you about?
I can't remember because I didn't even remember that it was October 2019 until you said that.
So you don't have a present recollection?
I do not remember that, no.
Had to be before the contract, though, in January of 2021, correct?
That they met?
No, that you were told about Mr. Wade and Ms. Willis meeting at the conference had to be before.
Oh, yeah, yes, it would have been before that, yes.
So what other communications did you have with Mr. Wade about Ms. Willis that are not privileged? We know of one, about the meeting at the conference. Are you suggesting that that's the only one you ever had about Ms. Willis that isn't?
I cannot recall any. I cannot recall.
You cannot recall whether there were any other communications that weren't privileged?
No.
I'll be specific, and I understand there's probably going to be objections, but I want the record to reflect. Did you have a conversation with Mr. Wade prior to November 1st of 2021 about Mr. Wade dating Ms. Willis?
Mr. Wade has risen. An objection is sustained for the record. Excuse me, Mr. Evans.
Say that again.
You don't have to answer the question, Mr. Bradley. Next question, Mr. Evans.
Well, I understand it's been objected to and the court has sustained the objection. Can you tell us the circumstances in which, that is, under which Mr. Wade may have told you about dating? What I want to do is try to figure out if we can, you tell me if you want me, if I can do this. I'd like to know how the communications themselves took place, where they took place, how they took place, under what circumstance, whether he was at the time providing advice, seeking advice. So those are the basics. If I can ask as to all those, but if the court's going to sustain the objection to those, then I don't want to waste your time.
And that's something I'll cover in camera. So I'll note the question of the your question for the record, and I'll sustain the privilege objection to that.
Okay, all of this prior to November 1st, 2021. Okay? I'm going to show you two text messages. I don't have hard copies.
Bring out the text.
Okay, you want to get into
I'm going to set up a question based on here's follow up.
Okay, so I'm going to have objections.
Of course, you're going to have objections. I realize that. I want to be able to show it to you, and then I'm going to frame the appropriate question, and then you're going to object. We'll see where we are. May I approach?
You may, sir.
Look at this text message. Of course. Kind of hard to object. I haven't asked the question. And I know it's coming. Okay. Then you must be a soothsayer.
He's slow.
Mr. Bradley, I showed you 2 text messages, correct? Both of those text messages occurred on January the 5th of 2024 at approximately 11:56 a.m. Am I correct?
I think, yes.
Okay. And the text messages would have been between you and Ms. Merchant, correct?
I didn't see, yes, it should be.
Okay. And I've shown the same 2 to prosecution, so we're talking about the same 2. In the text message to Ms. Merchant, you indicated knowledge of some activity on the part of Mr. Wade, correct?
I'm gonna
I haven't asked him anything about what the,
flag for the court that this is a
How many times are they gonna ask the same exact question?
topic and a specific exchange that Ms. Merchant went into, and there were objections that were sustained.
All right, understood.
yes. And it's your testimony that the information that you imparted to Ms. Merchant in these 2 text messages is based entirely on confidential communications between you and Mr. Wade, correct?
Objection. He's referencing specific knowledge. The specific knowledge comes from Mr. Wade, which is we've already established as privilege.
What other question? He didn't get into anything. He just said, are these 2 text messages about privileged communications? We haven't actually, he's tested. I don't see an issue there.
Yes.
And is it your testimony that the knowledge that you have, which you imparted in these 2 text messages, came from Mr. Wade and Mr. Wade alone?
Yes.
Is that correct?
Yes.
Can you tell us when it was that Mr. Wade imparted this information to you?
Objection.
All right, and I think that,
That's what you're going to do.
sure, so I'll sustain that on privilege.
And I'm going to introduce for the record, when we finish these 2 text messages, so that Your Honor has those back there, so that you can.
Sure, what would they be marked as?
Here you go.
I have a whole set.
Okay.
Go ahead. Once I put a staple in it, I think it'll be Defense Exhibit 26. Give me a real pen.
All right, so this is marked and on the record is Defense Exhibit 26, but not necessarily for its.
This is not admitted
Evidentiary
26. It's for purposes of the court conducting the in-camera review. And put a staple in it just to make sure that you see it. No charge?
No, straight.
All right, let's say that. What else?
All right, so there was also reference, if I remember correctly, to some email correspondence in which Ms. Merchant sent you the motion that she was going to file to disqualify Ms. Willis and Mr. Wade for your review. Is that correct?
That's correct.
Okay. And that was sent to you in an email?
That was correct.
And did you respond to it in an email?
I don't think I responded to her in email.
Actually, do we know? You responded by text. I'm sorry, I mischaracterized it. You responded by text?
If I can look at my text, I can, but I'm assuming I did, but.
Okay, I'm gonna get it for you, because I don't want there to be any assumption.
I'm starting to wonder, was he drunk when he was talking to Miss Merchant? He was texting her.
Let me show you. This is. Here. I don't have anything besides the
So, is that what you're?
I'm going to show you if I might approach.
I made reference to an email Ms. Merchant would have sent you about the motion she was going to file. If you look at this, does this appear to be the email that you received? It's dated January the 6th, 2024, 10:20, 10:25 a.m.
Yeah, I see it, the email, yes.
So that's the email that you received, correct? Along with, obviously, the attachment, which is referenced.
Yes.
And then,
hey, Ray,
did you respond to that email within the text message that I just placed before you?
that motherfucker do look shiny as hell. There's 1, 2, 3, 4, 5, 6, 7. Just rays of light on his forehead or his head.
Yes, I said it looks good.
So the answer is yes.
Oh, yes, I did.
Okay. And we'll mark this as another exhibit for your honor to look at.
And then it's also crazy because she allegedly sent that to him last month. So he already forgot. That's weird.
Since you love my tone, can I have to sit with you? Oh, so I can catch up. Okay, I'm going to have these marked as 27. Okay? All right, so is it your position that what is reflected, let me hand it to you.
Ray, we're talking about the Fani Willis disqualification hearings that are going on in Atlanta. Right now we're listening to Terrence Bradley talk about him seeing Nathan Wade or Fani together. If you don't know, Fani is the prosecutor in Atlanta, and this man right here is an attorney as well. So allegedly, she had sex with Nathan Wade, and they had this inappropriate relationship. Nathan Wade is also an attorney. He's a special prosecutor. And there's some trips that took place and all this and that. So basically, they're trying to disqualify her from the Trump case in Atlanta, Georgia.
Yeah. What's the course rule to ask him about?
I'll take it case by case. I think he's doing all right. So we need to ask for this witness.
Is it your position that your response, which is the second page of Defense Exhibit 27, is based on a confidential communications that you had with
You're welcome,
Mr. Wade?
Here we go with the long
read the response
pauses.
No, I'm only asking you whether or not the response, you actually already said what it said. I don't want you to read it.
Like he eating booty, the look on his face, like it stank and it don't taste good, all at the same time.
Again, is that response, based on confidential communications that you had with Mr. Wade?
Objection, this is privileged and cumulative.
All right, so now we're talking about the email, essentially referencing the motion as a whole. He hasn't been asked to actually confirm or deny any specifics, just to say whether his response is privileged. So I think we're just laying the foundation, just like we did with the text message. So you can answer that question, sir.
Was my response privileged?
Was your response to the email of Ms. Merchant, which is on page 1 of that exhibit, is your response, which is on page 2, is that based on knowledge that you received from Mr. Wade pursuant to confidential communications?
Yes.
Have you discussed with the district attorney's office this case, your purported testimony?
Of my testimony?
Yes.
No.
At all?
No.
No prep, no conversations, no nothing?
No.
Have you given your attorneys, for this matter, did you give them permission to speak with the district attorney's office?
Well, he can assert his own privilege, but that's kind of crazy.
Is there a objection to be heard?
Absolutely, this is privileged
Sustained. Stay down. Next question.
Do you know whether or not your attorneys shared privileged information with the district attorney's office?
No, I don't know what my attorney shared or didn't share. I don't know if they even met.
Yeah, if you're in here and you haven't already, please hit that like. I appreciate you.
Have you?
Sorry for clearing my throat in your ears. Soon that will be corrected.
Last question. Have you spoken to Mr. Wade prior to today? No, actually, withdraw that. You're no longer in the same partnership or fee sharing arrangement with Mr. Wade, correct?
That's correct.
When did you leave that fee sharing partnership, pseudo partnership arrangement?
I don't remember the hard date, but maybe sometime like July, August of 2022, I think.
Okay. And what was the reason for the partnership or the fee sharing arrangements? What caused the separation?
I wanted to leave and go out on my own.
And that's the only reason?
I wanted to leave and go out on my own, yes.
I understand, but that was the only reason. There wasn't any suggestions or allegations of any form of misconduct on either part, either on your part or Mr. Wade's part, correct?
Misconduct of what?
I don't want to try and
that money that he's using off your credit card, sir.
Not to get into the specifics.
Did he not pay the money back and you just quit fucking with him?
Is there any allegations made of suspected misconduct on your part or on Mr. Wade's part? That's a fairly simple question. Did he accuse you of doing anything? Did you accuse him of doing anything? Without getting into what it is, were there any accusations made by you or him against each other?
Thank you, Ray.
Had a disagreement, yes.
What wasn't the reason, Jeanette?
Had that disagreement have anything to do with Miss Willis?
Oh, no.
Okay. Did it have anything to do with your conduct?
No.
Did it have anything to do with his conduct?
Hold on, wait. So we had a disagreement. Whether the disagreement was, we disagreed. And so we dissolved, I left the firm.
All right. And was the disagreement having anything to do with alleged or supposed misconduct by either one of you?
If you define misconduct, I'm telling you, we had a disagreement and we.
Just tell me what the disagreement was.
The disagreement is mine to know. I mean, I don't see the relevance of the disagreement that I had.
Because if you said the disagreement, it would expose y'all even further.
Nothing to do with this Trump case or any other case.
I guarantee they fell out about that money and that credit card.
Simply getting a question asked, what was the disagreement? It's not privileged, correct?
No, that is privileged.
Oh, it is privileged. Why is that privileged?
Oh, yeah. I keep forgetting about the sexual harassment. I'm going to need to make a note of that. Because, again, I heard it brought up like during one of them CNN, MSNBC things or whatever, and nobody really went into it more.
Because
I look into that.
I can tell the court in camera, but it was privilege.
Ask a few questions further to see if this is actually something that does fall within that privilege. We can take it from there.
Did it have anything to do with you representing Mr. Wade in any capacity? Excuse me.
It would fall in that line, yes.
But your testimony is that it has nothing to do with your representation of Mr. Wade in connection with Miss Willis.
As it a connection to Miss Willis, that's correct.
It's connected to the matter for which you were
hired by Mr. Wade?
I wasn't hired by Mr. Wade.
I thought you were the attorney representing him in the divorce.
Oh, I apologize. I thought you were saying something else. Oh, yes. So will it apply as to whether I was hired during the divorce? Yes, that's correct.
Yeah, he said it's his to know. Wow.
I'm not sure what this correct means under that. We kind of got lost on it.
Yes,
It
of course.
did or did not relate to your representation?
It did relate to my representation.
In the marriage case?
It does.
And this was whose decision was it? At that point, did you stop representing Mr. Wade?
It wasn't at that point, no.
Was it before that?
No, it was after that.
Okay. And how much longer did you represent Mr. Wade in the divorce action?
I went to see the divorce proceeding to see Mr. Wade. I represented Mr. Wade for a time after that. He represented me in a construction case for a time after that. And I'll have to look at the filings. I ended up hiring new counsel for my construction case. He ended up, but it wasn't right at that moment. It wasn't in a matter of weeks. It was.
So you continued representing him in connection with the divorce case after you had the separation that you've made reference to?
And he continued to, yes, and he continued to represent me on a construction case.
But the separation, at least.
He did. He is. He should just come out with it. Like, it's apparent that, because nobody takes that long to think about what they're going to say. It needs to explain everything. I mean, come on now. An argument between him and Nathan Wade is something that he's going to hold tight to his chest. Like, the fact that he wouldn't even speak on that just makes it look like he has something to hide.
In part, if I heard you correctly, and please tell me if I'm wrong, had something to do with your representation of him in the...
Oh, yes, you can. It's moving right here. Look. Wow.
Divorce case.
That is correct.
Now, Mr. Wade has testified that he did not have a relationship, personal relationship.
Okay, and stop doing it. But
A
I
romantic
seen it.
relationship with Miss Willis until sometime early 2022. Okay? I'm leaving that as the premise of what I'm about to ask you. Do you possess information that counters that, that's inconsistent with that?
Any information Mr. Bradley has would be privileged, Your Honor.
Okay, let's say that. I think we.
Would such information be privileged in your mind?
I think this has already been asked during Ms. Merchant's direct, so we're covering the same ground. So I'll sustain that.
So I can't get an answer to whether he possesses information which is inconsistent without getting into the information itself.
I think the issue would be that we've already gotten an answer on that. Now we're asking the same question again. Ms. Merchant asked a variation of that, and he already answered.
I think the variation, Your Honor, is referencing whether or not he had what would be personal information, independent source information. Mine is not so limited. Mine is, I'm asking him point blank whether or not he has information from whatever source, including Mr. Wade, that is inconsistent with Mr. Wade's testimony.
Because if it includes Mr. Wade, it is privileged communication. So therefore, the answer is it's privileged. If it excluded Mr. Wade, that would be a different appropriate question.
And I just want to say, the answer is either it came from privileged information or it's hearsay. That's it. He's already testified that he has no personal knowledge.
Unless it's for impeachment at this point. But Mr. Seda, I think that might be too fine a distinction for me to see the need for the question. I think I'm failing to see the difference.
Well, I'm not asking respectfully, I'm not asking you to see the difference. I'm asking whether I can ask that question and elicit a response which doesn't elicit the actual communications, which is what I'm attempting to do. And if Your Honor says I can't, then I'm finished.
And I think that this was another aspect of what came up before, which is, in my mind, even confirming the existence of the information goes into privileged communications, whether he does.
I wish the cameraman would stop moving around.
Or does not possess information if it came from that relationship. That's part of the privilege as well. So If I make that clear, then
So you're sustaining what the objection would be.
that's right. It'd be sustained on privilege.
And of course, all the questions that we're
Reserved for the
talking
record.
about as far as the foundation about when things are said and what is said, you're going to go into, if I understood correctly, ex parte in camera with the two exhibits we talked about.
That's right. My intent would be to make a record of the knowledge of when it was attained and the extent of it in the different sources, and that'll be sealed.
And what was actually said.
That's right.
So I guess my question to the court before I sit down is, if hypothetically, you learn through this in-camera ex parte examination that the information that this gentleman has through the attorney-client privilege is in fact inconsistent with what Mr. Wade testified to under oath, then the court is going to then make a determination of whether it can be used here or whether it just remains in the record sealed.
So my intent would be to make the distinction of, from the in-camera hearing, if I still determine that everything is covered by privilege, then anything else that is said cannot go into the factual determinations or credible determinations that need to be made. And so just the issue of whether the privilege did or did not exist is preserved.
Okay. So again, just to follow through to make sure. So if the court knows that there's been a fraud upon the court through the lie of Mr. Wade, none of us are going to know that that in fact occurred, and the court's going to be in a position of making a determination on the motion, even though the court knows that it doesn't have all the information, truthful information.
I'll take a closer look at the case law you provided to see if that is actually a variation of the crime fraud exception. And I'll apply the crime fraud exception as I see it.
Right. And again, I'm not suggesting it is a variation. It is totally separate from crime fraud. It has nothing to do with using the legal advice of the attorney in order to commit a crime. It's you go ahead and commit fraud or lie to the court when you fully know that someone, your attorney, has information which is counter or inconsistent with what you've testified to.
And to that end, Mr. Sadout, that is something that you can, I mean, I've got this case from Ohio, but if you can find something more on point in Georgia before we schedule.
Other than the one I gave you.
The
1935 case.
The Atlanta Bottling Company. I don't think it went that far. I think it just kind of said the sword shield language, and it didn't go
not the 1935 case.
So far as to say that there's this alternative theory about fraud upon the court, but we can flesh that out in our research.
I appreciate that. Thank you.
Okay, Mr. Stockton.
No questions, Judge.
Mr. Durham.
No questions, Your Honor.
Mr. McDougald.
No questions, Your Honor.
Mr. Rice.
I have a few questions, Your Honor. Mr. Bradley, you were counsel for Mr. Wade in the divorce case when the interrogatories were initially served on opposing counsel on or about December 27th of 2021, correct?
That's correct.
And you were also counsel for him when the amended interrogatories were served on May 30th of 2023, correct?
That's incorrect.
So you ceased representing him sometime before May 30th of 2023.
That's correct.
At any point during the divorce proceedings, was a pleading filed with the court or a paper served on opposing counsel that purported to have your signature that you were not the one that signed or authorized your signature on it?
Say that again?
Did anyone sign your signature without your authorization on any pleading or any other paperwork served on opposing counsel in the divorce proceeding?
I don't think so. If you have the documents, I can authenticate my signature.
That's an interesting question.
And you have testified that you also practice criminal law and divorce law and perhaps other types of law as well?
That's correct.
And are you aware that OCG 16-6-19 defines adultery as a misdemeanor crime in the state of Georgia?
If you say so, yes, sir. Go ahead.
Judge, I would ask the court to take judicial notice of that.
For what relevance?
Judge, I think it does go directly to the crime fraud exception. Because if, before we
Now they trying to charge him with adultery.
objection, because if Mr. Wade
Are bringing that up.
is providing information to him, to his counsel about his intent to either commit adultery or that he was committing adultery, then that would be a misdemeanor crime. It would implicate crime.
And nobody is on trial here. This is just a hearing to see if her, Nathan Wade, and her office is disqualified from trying former President Trump.
By exception. And additionally,
You
as
can
we
tell I've been watching a lot of news lately. You talk about some former President Trump.
know from yesterday's evidence,
Well,
we have
let me pause you there. Isn't adultery as a statute just on its face been found unconstitutional? You can't actually charge anyone with adultery anymore.
It is still current.
Then it can't be a crime.
It is still a current charge.
Let's move on to that next argument.
Additionally, Judge, with regard to the interrogatories, we have 3 different sets of interrogatories
I must have missed that.
that were filed that came into evidence yesterday, 21.
Oh, when Terrence had said it, yeah.
December of 23, that contain false information. We also have the January of 24 that contains the invocation of privilege. So to the extent that this witness has information, both with the original interrogatories that were filed in December of 2021, and frankly, with regard to the later ones, even though he wasn't counsel, that would be a false swearing and fraud on the court, which again is a criminal offense, and therefore the crime fraud exception would apply as well.
Okay. Understood.
No further questions.
Okay, Mr. Gillen. Okay, Mr. Gillen.
I don't know why that was in that quiet.
Good afternoon, Ms. Bradley.
Good afternoon.
Been a long day. When did you sign your engagement letter with Mr. Wade to represent him in divorce proceedings?
Yeah, I had said that earlier. How wouldn't he know when there would have to be some type of form of paperwork? Yeah, it'll be only for a few days though. I wanted to just cover this hearing and see what's going on with that. I'm quite bored with him, but we'll get back on him soon. I'm not, taking my foot off his neck too much. He just ain't got nothing going on right now.
2017, 2018. Same time frame, 2017, 2018.
So did you sign or
Facts. He didn't even get to smash. He didn't get to go on no trips.
have signed an engagement letter to represent him, or are you just speculating?
I can't recall. We were in we shared space. I can't recall if there was a contract or if there is a contract. I think there is a contract, but right now.
Oh, definitely.
That would be speculation.
Right now, sitting here, you do not know whether or not you had a signed engagement letter with Mr. Wade discussing the parameters of your legal representation of him. Isn't that correct?
That's not correct. I can't say. I don't have my files or anything with me.
Oh, sitting here, you do not have specific recollection or knowledge that you even had an engagement letter to represent him. Isn't that right?
I think I had an engagement letter, but I do not know specifically if I had an engagement letter.
Well, when did you?
But I also feel like he knew he was testifying, so there's certain things that he may need to know the data.
You open a file. Did you open when you represent someone? You open a file in your office. And when did you open the file on Mr. Wade.
I am going to object to the relevance of this line of questioning. There has been no dispute by the attorney or the client that there was an attorney-client relationship. And so I object to the relevance.
Then there shouldn't be attorney-client privilege then.
The circumstances under which that engagement began, because as Mr. Gillen knows.
I got you, Ray. I got you. He's been kind of boring lately. He hasn't really talked about nothing. If I did respond to him or something, it'd be regurgitation, and I really hate regurgitating what I've already said. So, we'll give him a couple of days. I'm sure he'll fuck up soon.
That's not a factor in determining whether there was a true attorney-client relationship.
Well, Your Honor, it's not just up to Mr. Wade and Mr. Bradley, it's up to the court.
I agree with you there, Mr. Gillen, and so I'll give you a little bit of leeway, but I don't think we could spend too much time on this.
No,
So,
okay.
I think on the second testimony, he was sweating more than this one.
Your Honor. Now, did you or did you not
I
open a
remember
file
correctly.
in your law practice with Mr. Wade's name on it? Yes or no?
That's a fact, Ray.
Yes, I had a file with Mr. Wade's name on it.
When did you open that file?
I'm assuming 2017, 2018. I can't tell you the exact date. I've said that 3 or 4 times.
Well, let's approach it from another angle. When is the first invoice that you sent to Mr. Wade for your legal representation?
And then it's crazy. If he started representing him in 2017, 2018 in the divorce proceedings, and 2021, the divorce wasn't even finalized, what kind of attorney is this? How much assets in other situations? I get it. Sometimes divorces do take a long time, but 4 years though?
I didn't send him an invoice in that capacity.
So what we have here is you're not knowing whether you even have an engagement letter. You don't know whether you actually even billed him, correct?
I represented Mr. Wade. I signed the documents that we filed. I filed the documents. There's depositions that I had with the divorce attorney that was representing his wife.
I'm sorry, sir, that's not my question.
Okay.
My question is, did you bill him in your capacity as the lawyer that you're telling him?
I don't recall.
As a matter of fact, did you have any invoices where you billed him on an hourly basis?
I don't recall.
And the answer really is no, isn't it?
Oh, it could have. It definitely could have.
Yes, sir.
I don't recall.
And the reason why it's no, isn't it, is because what happened is that you and Mr. Wade were in a law practice together, and it was a very small work environment, correct?
It was a work environment, yes.
A work environment where you and him would meet and talk literally every day, correct?
Not every day, no.
Well, almost every day.
Not almost every day. I stated earlier that I ran one side of a practice. Mr. Wade did, and we rarely were there at the same time. I stated that earlier today.
So, just give us totally how much money you got for representing Mr. Wade in this since 2017 or whenever you told us up until you dropped off the case in 2023.
I don't recall.
Would the answer be zero?
I do not recall.
Well, you would know whether he got paid or not, wouldn't you, sir?
I do not recall.
So you don't recall whether you as an attorney got a single dollar to represent Mr. Wade, correct?
Yeah.
That's correct.
Because you really did it as a friend, didn't you?
No, I did it as an attorney.
Well, an attorney that wasn't being paid. You were doing it pro bono for a friend, weren't you?
I don't know to ask me.
Right, because I ain't met one attorney that ain't worried about their money. Now, he could have represented him, his friend for free, but he don't know nothing.
So I'm just saying that, Mr. Gillen, I think the law is clear that money doesn't even have to change hands for that relationship. I'm making a finding based on the evidence that's already been presented, and with the fact that he signed pleadings to the depositions on Mr. Wade's behalf, that attorney-client relationship did exist.
Well, at some point, I was just laying the foundation of the circumstances in terms of the non-billing from the 2017 period and whether there was really an attorney-client privilege there. That's
Right. And I feel like the dude that's talking, he got a point right there, because if there was really no engagement or contract signed and no money, you know, exchanging hands, there was no attorney-client privilege. You were just helping a friend.
what I was trying to do.
That's crazy.
If the dispute is just when it occurred, you can try to hone in on that, but the questions I've heard so far are more from you were never paid ever, it was from an overall angle.
Well, from 2017 until November of 2021, you didn't receive $1 from Mr. Wade for your supposed or your representation of him, correct?
I don't have the file in front of me and I do not recall.
Okay. And the reality of it is, as I mentioned or asked you a few minutes ago,
And he probably fell out with Wade because he was like, oh, you're spending money on my credit card and you haven't even, regardless if he was paying it back, but you haven't even given me $1 or whatever. Like, you ain't gave me no money for representing you. So, bruh, he probably came at him like, I'm not doing this no
is
more.
that it was a small firm and you were doing him as essentially a favor as a friend and as a law partner, correct?
No, I was representing him as an attorney. Were we in the practice together? Yes. And were we, or are we friends? I mean, we were friends at the time. Yes.
Well, you were friends and law partners, correct?
Yes.
And in a small firm,
Ray, you're funny.
and I know because I'm in a small firm, people will sit around the office and talk about their social life and what they're doing, correct?
Yes.
Correct.
If that happens in your small firm, yes, yes.
Well, that doesn't happen, or did it happen in your small firm?
The witness has been asked very specific questions about conversations about socialization, and we've gone on through it, so I think this is asking that.
All right, I'll answer this one question overruled.
Repeat the question.
Well, did you in your small firm have occasion to where people would sit around and socialize and talk about what was going on in their lives as opposed to merely talking about the law?
Yes.
And you had those conversations with Mr. Wade as a friend on a social basis, didn't you?
Well, that's a good observation. That could have definitely happened.
Objection, going back into privileged communication.
Not yet, but it might.
I assume, yes, we talked about sports. We talked about, sports a whole lot.
You talked about life, about what was going on in your life and what was going on in his life, right?
Right. Sometimes, very rarely, yes, sometimes.
And that is what you do in a small work environment when you know people very well and you do favors for them, correct?
Again, I'm going to object.
Yeah. All right. Sustaining. Next question, Mr. Gill.
Now, in that capacity, didn't you have discussions with Mr. Wade about what was going on in his social life that had nothing to do with him asking you legal advice?
Objection, be more specific.
I think he's just asked whether he socializes outside of legal advice. So he can answer that question.
I did answer the question. I said we talked about sports a lot.
And I'm asking, sports is one thing. The social life, did you talk about each other's social life, like Mr. Wade, and who he was dating?
All right. So that'll be sustained on privilege.
Okay, Your Honor, just for the record, I would state that my objection would be that the privilege only protects communications in furtherance of seeking out a legal advice, not talking about something that might be personal or confidential. And that's the distinction that I would draw.
I think that's a accurate legal point. However, I think the witness has already been questioned and testified on this point. So, next question.
Now, you got into the fact that you were the initial attorney on the divorce case, correct?
That's correct.
Now, did you and Mr. Wade, without getting into discussions, did you and Mr. Wade together prepare his responses to the interrogatories which were filed initially in the divorce case?
I'm assuming we.
Objection, he's asking about interrogatory responses, preparation of the case in the divorce case. I mean, that's all covered under attorney-client as well.
Mr. Gale?
Well, I don't think it's the attorney-client. Did they meet together? And when the interrogatory answers were filed, did he file them? And did he do that in concert with his client? There's nothing privileged there.
Did they meet and work together, and that work taking the form of them talking back and forth to each other on the right responses?
I'll change a little bit. Did you review yourself the interrogatory responses given in the divorce case?
I did.
And whatever knowledge that you had when you were involved in the interrogatory responses, you had the knowledge of all that material or information that you had without getting into the content. You had all of that knowledge and information. I'm sorry, let me get my question out before he objects. And when you filed those interrogatories, you had all the knowledge and information that you had obtained from Mr. Wade from 2017 up until the date the interrogatories were filed, didn't you, sir?
Okay, so that's, the follow-up question to that is going to be incorporating knowledge learned during communication. So
No, I'm not going to have a follow-up question. I just want to know whether is that the case? When he filed the interrogatory forms, he had all of the information that he had discussed with Mr. Wade from 2017 up until the time. That's it. That's my final question.
Okay. In which case, without doing that extra assuming link that he based his answers on those communications, it has no relevance.
Well, it does in the sense that it shows what knowledge he may have had when he, the attorney, is filing interrogatory responses. That's what it shows.
Okay. I'm still not seeing the relevance of his knowledge as the attorney filing the responses, unless you're linking this back to Mr. Wade.
It gets back, Your Honor, to whether or not, if you're an attorney and you're filing an interrogatory response, which you have reason to believe, or specific information to know that certain responses are not accurate, then you shouldn't be filing them. And now, so that's where I was going with that. So if he's got a body of knowledge over here that's built up from his communications with Mr. Wade that everyone so dearly doesn't want everyone to know about, in spite of the allegations made against Ms. Merchant. Now,
so what if the question was, did you, when you signed your name to the interrogatories, did you commit any knowing fraudulent statement and submitting those to the court at the time? Would there be a problem with that statement or that question?
Well, I mean, I think that is a conclusion that others could draw, like
him and Nathan Wade.
Court. I just want to know that he had all that information at the time that he, as the attorney, filed the interrogatories. That's it.
We would object. This does fall under attorney-client, and he is making presumptions about when information may have or not have been disseminated.
All right, so there's Bradley's attorneys right here, sitting over here.
Mr. Bradley, in his capacity as attorney, he didn't have to know about anything at the time of, in the middle of, at the end of, or he may never have had that information. There's too much presumption associated with it. The whole matter is covered on his privilege.
One comment on that, Your Honor. We have spent almost a day talking about trying to block public the dissemination of what Mr. Wade said, either as an attorney or in any capacity, about his relationship with Ms. Willis prior to November the 1st, 2021. And questions about discussions in 2019, all objected to, the claiming the privilege. And now to say, well, that doesn't mean that he learned something after. I'm talking about, what did you know at the time the interrogatories were filed? And everything that now they're claiming privilege, well, that's fine. The court will address that in chamber and in due course. What did you know?
I'm sorry, Mr. Gillen, I really don't see the distinction. So your question's noted for the record and your objection as well.
All right. And
the judge is like, shut up already.
And I'll follow up with this. Now, you're leaving removing yourself from the case, the divorce case, correct? You withdrew from the divorce case, correct?
Correct.
Did you do that as a result of your concern about any of the accuracies
We got about 20 minutes until we head into the Nathan Wade. And that one, him and Fani's testimony was very interesting.
Or representations which have been made by your client in the divorce case.
No.
Objection.
Okay, so that's going to cover communications during the relationship?
Well, Your Honor, hypothetically, not saying this is the case, hypothetically, if Mr. Bradley, knowing, let's say hypothetically, that he speaking with Mr. Wade, was aware that the intimate or personal relationship, romantic relationship, existed prior to November the 1st, 2021, and started in 2019 or 2020, if he's armed with that information that he's obtained from Mr. Wade, but Mr. Wade would want to insist on responding to interrogatories which were contrary to the information.
Yes, I watched a whole bunch of people talking about how her dress was on backwards. She was pissed when she grabbed them papers and was like, it's all a lie. It's all a lie. Man, tomorrow that's going to be epic as hell. That's when we'll look at that.
Information that Mr. Bradley would have, then I'm asking.
And I was interested in the fact that her dad testified for almost 40 minutes too.
Him, whether he took steps as an attorney to say, I cannot be a part of that or countenance that, therefore I'm withdrawing from the case.
Sure. I still see that as covering their communications. So I'll just say no objection.
All right, thank you, Your Honor. That's all I have.
Thank you, Mr. Gill.
Thank you.
Mr. Kucherov, are you still with us?
Mr. Bradley, have you still got the exhibits 23, 24, 25 there in front of you?
I do.
And 23, that's one of the contracts for your personal LLC, your PC, your personal legal entity, right? For the district attorney's office? Yes?
Yes, that's correct.
Okay. And I understood your testimony to be.
Definitely did. And during his testimony was, man.
Any income that came into.
He basically proved that she was paying for D, in my opinion. You know.
The partnership. When I say partnership, let me be more specific. You had an individual legal entity. Mr. Campbell had an individual legal entity. Mr. Wade had an individual legal entity. But y'all had a partnership agreement, right?
Yes, but we didn't have that the entire time.
There was a period of time that we've been talking, that we had talked about in 2022 prior to leaving the firm, that there was an actual entity for the three of you, correct?
That is correct.
And that was roughly during the time period where y'all bought a building together.
Yes, correct.
Right. And it made things simpler, or for whatever reason, you decided at that time that a joint entity made sense to own that building, right?
Correct.
Okay. All right, but those contracts there, they're not with the joint entity, correct?
No, they're not.
Those are all with you individually, is that right? Can you take a look at 23, 24, and 25?
Yes.
They're all with you individually?
Yes.
Okay. 23, what's the hourly rate that you were being compensated? I think that was the first appearance.
23 is the, I don't think, no, 23 is not the first appearance. 23 is the taint, it says.
What's the hourly rate on that contract?
$150 an hour.
$150 an hour? All right. So the $150 an hour, the way I understand you all shared profits was you get 50, Mr. Campbell get 50, Mr. Wade get 50, and then y'all pay expenses jointly as well, correct?
Correct.
All right. What about exhibit number 24?
It seems to be the same.
Oh yeah, because Nathan Wade's wife is skinny.
Same amount?
Same amount.
I'm interested in the amount. Can you tell me the hourly rate?
The amount was $65 an hour.
$65 an hour?
Mm-hmm.
All right. That's not a particularly high rate for an attorney in the Atlanta metro area, correct?
No, it's not.
All right, was that the government rate that you were willing to accept at that time?
That is correct.
All right, and so $60 you're getting for that contract, again, that's split three ways, you, Mr. Wade, and Mr. Campbell, correct?
That is correct.
So when you were being
Minus
asked,
expenses and stuff like that. Yes.
exactly.
Well, essentially, they were only getting paid $20 an hour.
That was the income, and then expenses come from that, and then profits, whatever's at the end, correct?
Correct.
All right. So when you were being asked questions about Mr. Wade, I think the phrasing, and I object to, but I think you might recall the question, Mr. Wade brought you this contract, or Mr. Wade got you this contract. Do you remember those questions?
Yes, I do.
All right. So we're talking then about the split among the three of you of about $20 a piece, right? For that particular contract?
For this one, yes.
All right. What about 24?
Damn, imagine being an attorney and you're only getting paid $20 an hour.
You got 24 there? I'm sorry, 25. You got that in front of you?
I do.
What's the hourly rate on that one?
It's 150.
150 on that one too? All right. And the same sharing went through the business, the way you handled that contract as well, right?
That's correct.
All right. Who is Austin Dabney?
He was a probation officer that passed the bar, and we hired him and another individual. The other person didn't stay long.
And did Mr. Dabney and the other legal associate that you all had working for you at that time, did they do some work on these first appearance contracts?
Yes.
And that was a pretty good position for a younger lawyer to be sent to get some courtroom experience, correct?
That is correct.
All right. 2020, you're aware that Mr. Wade had a serious illness during that time?
I'm aware.
And you and Mr. Wade, I think you described your relationship in a lot of details earlier about specific circumstances. But you were business partners in, let's say, up till the time you left in summer 2022, correct?
That is correct.
You were business partners up until that time.
Hey, Marquise.
Yes, I said yes, that is correct.
Okay. And while you didn't socialize together frequently, you considered yourself a friend of Mr. Wade at that time.
Yes, we were friends at the time, yes.
All right. You are no longer business partners.
That is correct.
You are no longer friends.
I mean, if he's saying that we're not friends, then
I
yeah.
want to know what you think, Mr. Bradley. Do you consider yourself a friend of Mr. Wade?
I'll consider.
It goes to potential bias. Just cross.
Would I consider myself a friend of Mr. Wade?
Mm-hmm.
I would.
Probably don't think so no more.
You were asked questions, Mr. Bradley, about the circumstances under which you left the firm. Do you recall those questions?
I do.
All right. And you left the firm. The firm remained the same as far
Wait, so he was charging overtime and then he was going and laying up with her? I just reread that.
as other employees, Mr. Wade, Mr. Campbell, as the named partners of the firm.
Because I don't remember if Nathan Wade was in the courtroom at this time, but if he was, I'm sure he was mugging the hell out of this dude.
You were the one who left, correct?
That is correct.
And
even Fani, when Robin Yeartie came up, she was quick to say, "Nah, we're not friends like that." She was throwing shade.
you termed it as a disagreement. You recall answering questions as though you left due to a disagreement. Yes?
Yes.
And that disagreement was that there was an allegation of sexual assault by an employee made against you, correct?
Okay.
That is incorrect.
There was not an allegation that you that you sexually assaulted one of the employees in the firm.
That is incorrect, but Yes, yes,
Yes, there was an allegation that you sexually assaulted a member of the firm, correct?
yes, that was an allegation, yes,
And as a result of that allegation, you left,
I did.
and you were no longer business partners with Mr. Wade.
That is correct.
So now we find out the real reason. He talking about, oh, I just wanted to do my own thing. And whoever was sexually assaulted allegedly by him should have filed charges because he shouldn't be an attorney if he's like that.
The firm remained
That's
intact. In fact, the
crazy.
employee involved remained with the firm, correct?
I'm not certain of that. They did leave the building, of course. And I don't know, some
employees did leave. I did not hear that part. Also, because when I was watching it, you know what I'm saying? I just got timestamps when like testimony was done. But when I was watching, you know how like something come and like kind of distract you for a minute? Damn, that's crazy. That
Mr.
is
Bradley, in fact,
wild.
paid that employee $20,000, correct?
that is incorrect.
And that's probably why Miss Merchant wouldn't give him no coochie, okay? Because she already knew that he was built like that.
Or as what was
Ooh, allegedly. I ain't trying to get sued by Bradley, child.
On or about the time that you left the firm, and on or about the time that the allegation of sexual assault was made against you, did you pay the person who had made the allegation of sexual assault any amount of money?
There was money left in an escrow that belonged to me. I don't know what that amount was.
And did that money that was left in the escrow that belonged to you, was that paid to the employee who said that you sexually assaulted her?
I never signed any, I never gave any money. I left the money in the escrow account. What happened to that money? I can't, I don't know.
That's a good way of saying I allegedly abused said person and, you know, I just left money and I walked away. This is crazy.
What happened to it?
For what purpose did you leave the money in the escrow account? When you
Right, word spread around the water cooler. Damn.
left the firm?
I left the money.
Come on now, don't get to. Come on now.
Money in the escrow account.
For what purpose, sir?
There was no purpose.
You just left the money in the escrow account?
Yes.
Nobody just leaves money just sitting around. He was like, there was money left for me. Nah, you gave that money to that person for what you had did to them, hoping that they wouldn't go to the police.
There's no connection.
They should have took the money and still went to the police.
To the money you left in the escrow account and the allegation of sexual assault that an employee of your firm made against you. Why was it that you brought to my attention? Why did you respond the way you did about money in an escrow account when my question was, did you pay
Definitely paid her off.
this employee any money?
I didn't hand any money. It was money from my escrow account, to my knowledge.
To your knowledge, where did the money in the escrow account go?
To the employee.
To that employee.
And then $20,000 is a lot of money to just leave behind, walk away, right? Come on now. Wow.
Was there one allegation or one incident of sexual assault with this employee, Mr. Bradley, or was there more than one?
Just one incident.
There were not two.
To my knowledge, there were not two incidents. No.
I'm asking for incidents that you have been involved in. Were there two incidents where you sexually assaulted this employee?
No, I didn't sexual assault anybody.
So if it had really been one, would he have only given her $10,000?
Was there another occasion where you paid any money as a result of an allegation of sexual assault against you?
Wow.
No.
Did you sexually assault any clients of your firm?
No.
Never.
Never.
Who's Anna Rodriguez?
I don't even know their name.
You don't recall a client named Anna Rodriguez?
Anna Rodriguez? No, I do not.
Never met her.
I do not recall the name Anna Rodriguez.
Pardon me, Your Honor.
Well, the fact that he couldn't remember half of the questions that he was asked, that is crazy. This dude is wild, allegedly like that.
I would object to this. I'm not sure what we're trying to do here. So I would object to
You know what? He really didn't think that that part was even going to come up in reality. Wow.
Ms. Cross?
Your Honor, this clearly goes to the bias that the witness has towards Mr. Wade and other individuals, his motive in involvement. And I believe it's an appropriate avenue to pursue based on exploring his credibility.
And then the client part, like, if he really did that to a client, fam, he need to be in jail, period. Like, it couldn't have been no mistake. If he did it to the one girl twice, it wasn't no mistake.
At some point, though,
I'm not
it won't.
go much further.
Right. He definitely knows who Anna is.
Judge, if this is allowed to continue in this way, it does appear a little bit harassing, then is Mr. Bradley going to be excused from his privilege because this is not.
That's what I was going to do. Don't do that yet. Just sit on it. I think she's already done that.
Your Honor, I'm asking in all seriousness, that privilege, although.
Based on the answer right now, I think now we've opened up a whole area. What he has just responded to, he previously said was privilege. And that doesn't sound like privilege to me.
Girl, watch his victims come out now. Like with a full-fledged lawsuit. That's crazy. Put the woman's name out and everything. Watch. If y'all see her name in, you know, in the title or something like that with a lawsuit, you know, she coming for him.
Well,
that's
address
crazy.
that when we go back through the run. So, Ms. Cross.
I'm finished.
Okay. Mr. Say down.
But then he gonna sit up there talking about, yeah, I left the firm because I wanted to do my own thing. You wanted to do your own thing, all right. He's sick. Ugh.
You were accused by Mr. Wade of misconduct in the course of your representation of Mr. Wade, correct?
I was not accused by Mr. Wade, no.
Who accused you? Did Mr. Wade not, based on the questions we just asked, did Mr. Wade not bring to your attention the sexual assault allegations?
Ask that again, please.
Mr. Wade brought to your attention
He definitely is. I agree.
sexual assault allegations
Damn.
that you've been asked about by the prosecutor, correct?
Correct.
And at that time that Mr. Wade brought those allegations to your attention, you were still the attorney for Mr. Wade, correct?
Correct.
And therefore, your conduct as an attorney, and the attorney at that time for Mr. Wade was called into question by Mr. Wade's passing along to you allegations of misconduct, correct?
Like, you think that you know, he may get a case or something because of that? Where do you think she's gonna come out at? I'm just saying, I would feel like she gonna like sue him or something now. Because they did just say her name, her full name. Like,
After that, I don't think that's factually true. I don't
That's
know that that's
crazy.
not, I know that that is not legally true. The attorney-client relationship.
and then if they were, you know, counseled, right, the Miss Merchant talked to the lady, she probably talked her into pressing charges.
Is of a matter. It is not vitiated by
Damn.
other instances or anything outside that matter.
I'm not sure that that's accurate. He was accused by Mr. Wade, his client.
Accused by
Do you mind if I speak? I allowed you to speak. Mr. Wade
accused this gentleman of misconduct in the performance of activity while he's an attorney working with Mr. Wade and representing Mr. Wade. Those allegations of misconduct open up the question of whether or not he can defend himself by now discussing his confidential communications with Mr. Wade in connection with the representation as well as the allegations. That's the position of the defense.
Understood. So what is the question you're putting?
My question I'm going to ask you now is, tell us what Mr. Wade told you about when he began his relationship with Ms. Willis.
All right. So where I think we are with this is that
They trying to beat a dead horse.
Mr. Bradley previously testified that the reason he left the firm was totally and completely covered by privilege. When asked by the state, he went into...
Yeah, that's interesting since she was a client. That's wild. Imagine going to get an attorney and then they try to sexually assault you. That's crazy.
a factual scenario that, to my mind, I don't see how it relates to privilege at all. And so now I'm left wondering if Mr. Bradley has been properly interpreting privilege this entire time. And I think the only way I can cure that is by having that in-camera conversation with him.
May I suspend my redirect for you to have that conversation?
Exactly.
I think that makes sense. But is there anything else though that you were going to cover other than this issue?
No.
Okay. Ms. Cross, any reactions?
Only to, Your Honor, the premise of Mr. Sadow's question was that Mr. Wade accused Mr. Bradley of the sexual assault. That was not my question. I don't believe that's factual, though there was an employee who accused Mr. Bradley of sexual assault.
Okay. But regardless, though, the point is that these...
Wait, but the judge said he'll be back in like a week or two or whatever. So essentially, since they've done closing arguments and stuff, this portion of the case would be over, but they could definitely open up cases on, people that they need to file charges on. That's crazy.
Circumstances of his departure from the firm, from what I've now heard, had nothing whatsoever to do with his representation of a divorce.
I wonder, did the sexual assault have any weight on Nathan, not messing with him anymore?
Is that fair?
My question, I believe the testimony has been that the circumstances of Mr. Bradley leaving the firm were related, I can't say how much, but certainly in a large part, based on the allegation of sexual assault that was made against him by an employer.
Sure. And his previous testimony was that that was totally covered by privilege.
Yes, he lied.
Okay. All right. Other than this issue, which I think we've covered at length, was there any other questions based on Ms. Cross's examination from other defense counsel?
No, Judge.
They are.
Okay.
No, you are.
All right. With that understanding, can this witness be excused, Ms. Merchant?
Yes, Judge.
All right. So, Mr. Bradley, I would ask, I don't know if we may be able to do it today.
Oh, I'm sorry, because I don't think I finished Stephen Sadow. Mr. Sadow had reserved the rest of his cross for after you confirmed the privileges.
Right. What I'm about to say just logistically is, what I'm trying to do is, if we can conclude this hearing with the exception of that in-camera hearing, we end for today. And if as a result of that in-camera hearing that I learned that we need to reopen the evidence, then that's what I'll do. So to that end, I can give Mr. Bradley instructions that he's to report back if on order of the court, but otherwise, is there anything further the parties need from him today?
Not from him, but I wanted to get those certified.
I know there's other housekeeping things and things we need to do.
And based on the testimony, we do have another witness, Your Honor. It doesn't involve Mr. Bradley
Right.
requiring to be here.
Okay, so now the state does have a witness.
I do.
Okay, all right, in that instance, okay, Mr. Bradley, you can step down, sir. However, I'm giving you the order to stay in touch with your attorney, and that we're gonna have to find a time to meet again and go into a camera session. You understand, sir?
I do.
Okay. All right, thank you, sir. You can step down. Ms. Choker, do you have a card for me?
I do.
Okay.
All right, so that was that one. and we'll get done with Nathan Wade's before we're done today. So all right. Man, this whole thing is crazy. So here's Nathan Wade, the man that was having an alleged affair with Fani Willis.
My name's Nathan Wade, NATHANWADE.
Good morning, Mr. Wade.
Good morning.
Prior to filing this motion to disqualify, you and I were friends, correct?
Yes,
And in fact, I supported you when you ran for judge in 2016.
you did.
I wore your shirts. My kids wore your shirts.
Ms. Merchant,
Fines.
your personal opinions have no relevance.
Why does she keep trying to insert herself in this case? She did it with Terrence Bradley, and now she's doing it with him. I wore your shirts. What does that matter?
Not in the best way.
That's
All right.
completely fine. I
Let's
will
get to the
move on.
point.
Thank you. No. Totally fine. Thank you. You filed for divorce from your wife on November 2nd, 2021.
Yes, ma'am.
And in that divorce proceeding, did you file answers, things such as
Okay, so they did get a divorce, 2021.
interrogatories?
I did.
Okay. And so interrogatories are where you're responding to things that basically answers that the other side is asking.
Yes, ma'am.
And I've got your complaint for divorce. I'm just going to mark it for the record as Defendant's Exhibit 2. The first interrogatories that you answered, those were December 27th, 2021. Is that right?
Thereabout. Yes, ma'am.
Okay. And in those, you were asked different things, but those are sworn. You actually swear to those. You verify them, right?
Yes, ma'am.
Okay. And so that verification is where you're swearing under oath that everything in it is true?
Yes, ma'am.
And let's see, you were asked if you had any documents which relate to the purchase of gifts by you to any person other than the defendant with whom you have or had a relationship, romantic relationship from the date of your marriage, correct?
Yes, ma'am.
Okay. And you responded,
I definitely think they smashed. They definitely smashed. I mean, he's going to talk about how they went on cruises and his mom went. Like, that's crazy. They definitely smashed, in my opinion.
under oath that you didn't have any documents to that.
That's correct.
You again responded to an interrogatory. You updated those responses on May 30th, 2023.
Yes, ma'am.
Okay. And you actually sent those directly to opposing counsel in the divorce?
Yes, ma'am. I think so.
But in that one, you answered none against that question, correct?
Yes, ma'am.
Okay. So May 30th, 2023, you said that you didn't have any documents showing any purchase of anything with someone that you had a romantic relationship with.
I believe the interrogatory was gifts.
Okay.
Not anything, gifts.
And I have it if you want to take a look. I'm going to mark, okay, so just for the record, I've got your complaint for divorce marked as number 2. I've got the verification and the interrogatories from 2021. I'm going to mark those as 3. And then your May 30th, 2023, I'm going to mark as 4. Judge, may I approach the witness?
You may.
Thank you. That is what I marked as 4. This is what I marked as 3. Okay. Thank you, Judge. All right, if you take a look at what I marked as 2, 3, and 4. Just see if you recognize those.
I do.
And are those, that's your divorce complaint?
Okay, Jeanette.
And then your 2021 interrogatory and your 2023 interrogatory, correct?
Yes, ma'am.
Okay, are they a fair and accurate representation of what is filed in that case?
Yes, ma'am.
I'd move to admit those into evidence.
And this is 2, 3, and 4?
It's 2, 3, and 4, yes.
When you said that, you was talking about Terrence and Miss Merchant, or?
All right, any objection from the state?
Is in.
Divorce.
No objection to 3 and 4 and subject to Ms. Merchant's representation that 2 is a filing of divorce. I just don't, the divorce complaint, I don't have that in front of me, but subject to that representation, no objection.
What if Miss Merchant liked Nathan Wade and that's why she don't like Fani? I don't know.
Hands, any objection from other defense counsel? Seeing none, defendants 2, 3, and 4. This should be Romans. Well, we'll just call them 2, 3, and 4 admitted without objection.
So that interrogatory that you filed in 2023, that's one where you said no, that you didn't have any documents relating to the purchase of gifts, that you had a romantic relationship with someone, right?
Which interrogatory are we talking
Number 4, 2023.
about? Which number in the interrogatory?
Number 4.
So, which number interrogatory are you referring to?
It's defendant's exhibit number 4.
I have defendant's exhibit 4 here.
Uh-huh.
Which number interrogatory are we referring to?
Oh, which number out of the questions?
Yes, ma'am.
Yeah, I think she likes him.
Hold on. It is number 20, 24, 25, 26.
Or liked him, you know. This camera's making a lot of noise.
Oh. It's supposed to be number. I guess they're all numbered 1. So number 1 again, and then the third number 1.
That's your page number or something.
He didn't put page numbers on. He didn't put any on the file. I don't know how to tell you what number 1, because when you responded, you put number 1 on all of them.
You just point to it.
This one. This one, I'm talking about this number 1, where it's tabbed. There's 2 number 1s that are tabbed.
Okay.
And there's no page number, but it is the second page.
All right.
They're asking if you have any receipts for restaurants, hotels, bars, things like that.
The first number 1?
I believe it's the second number 1.
The second number 1? Okay.
So it asks you if you have any receipts for things like restaurants, bars, hotels, things like that, where you accompanied a member of the other sex romantic partner. Correct?
And it's odd because they're both sitting in the same spot, but they have different shines on their head.
It says identify any and all occasions.
Okay. And so it says to identify any and all
I heard that talked about, but I didn't hear Fani say that.
occasions where you entertained a member of the other sex, okay, who's not related to blood, and including dining, drinking, restaurants, bars, pubs, hotels.
But yeah, that is crazy for her to say that and then still have an affair with him. That's interesting. But again, I didn't hear it. I'm sure I'll hear it this time because I'll be concentrating all the way.
And what was your answer to that?
None.
None. Okay. So May 30th, 2023. You prepared this document.
I did.
Submitted it.
I did.
And it says none as far as entertaining a member of the opposite sex.
It does.
Okay. No hotels, no bars, no restaurants.
Correct.
Okay. You again updated.
He just perjured himself.
Did that.
Oh man, he looked like he would be a preacher and not.
Let's see. You updated it on December 22nd, 2023.
She had to bring him some papers, quote unquote.
I'm gonna mark that as defendant's number 5, and I have copies. Is that correct?
Yes, ma'am.
Okay. And then you updated it once again on January 26th, 2024, correct?
Yes, ma'am.
Okay, that one. May I approach the witness again, Judge?
Is that what you're marking as defense exhibit 6?
Yes, Judge. I'm marking number 6 is the January 26th, 2024 interrogatory, and then that one. And then number 5 is the December 22nd, 2023 interrogatory response.
All right, are you tendering those at this time?
Yes, I am.
All right. Any objection from any counsel?
When Terrence was up there, she didn't even come close to him at all.
So the defense exhibit 5 and 6.
Yes, Judge. No objection.
I don't think she brought him anything. I don't remember.
Just cross. Seeing none others.
Luckily, I have 10 for you. So now that you have those, let's just talk about those for a minute. Those were verified, so sworn under oath. Okay. And one of them was December 22nd, and then of this last year, so last December, and then one was just recently submitted in January, right? Okay. In May 10th, 2023, Judge Thompson heard a motion to compel in your divorce case as well, correct?
Yes.
And you were actually held in willful contempt.
Yeah, I'm going to object to the relevance of
His credibility is relevant, Judge, and if he was held in willful contempt for failing to provide answers and documents, I think that's relevant to this court.
How is that a prior false act or crime of conviction or anything else allowed for impeachment under the rules of evidence?
I'm not offering it as a prior bad act or something like that. I'm offering it towards his credibility, Judge, which you get to determine. If he's made misrepresentations in these pleadings, you're here to determine whether or not he's telling the truth or not. So if another
want to show him her shoes. Y'all look at her damn shoes. It don't even match the outfit, and it's ugly. Like, that shit is ugly as hell.
Court has held him in contempt, and that's part of the divorce proceeding. I think it's relevant.
But just contempt generally can be for many different things. Like
And then look at her stance. Like, her legs are wide spread apart. Lady, you're wearing a dress.
to produce is not necessarily a false act, right?
Right, and he's welcome to explain that.
He may not have to. Ms. Cross.
I object to the relevance of that. That's clearly not a proper impeachment.
And now she's standing like she played kickball.
We're going pretty far
with them shoes out.
Into divorce matters that don't have any direct relevance to anything that's pending before the court. Subject to the relevance of that and be further.
All right. Not seeing that being a proper grounds for impeachment. It's sustained.
Okay, let's talk about this December 22nd, 2023 verification. I tabbed it for you. Again, they asked you if you had any documentations showing proof of this relationship, proof of any relationship, correct?
I'm going to object to the phrasing of that question. I don't believe that.
And I don't know what it is about her, but these dress suits are not it. Like, it makes her look like she has a wide back.
Accurate read of the interrogatory.
All right, let's be precise, Ms. Merchant.
You, please read it. I want to make sure I'm accurate. Please read it.
Which number?
This one actually has a number. I tapped it for you, so you should be able to open right to the page. It's number 22. The question specifically is if you have any tangible evidence of any nature in your possession or control, or any other person or entity which relates to any manner of your activities to any person with whom you've had a sexual relationship during your marriage. Tangible evidence is notes, cards, letters, photos, films, recordings, documents, tapes, video recordings, receipts, invoices, and other tangible evidence.
Yes.
Okay. And you answered that you did not have any documents to that effect, correct?
Them shoes do look big. A size 13, definitely.
Correct.
At least a 12 and a half.
And that was on December 22nd, 2023?
Yes, ma'am.
You updated those responses again after the motion to disqualify was filed, though, correct?
When was the motion filed?
January 8th, 2024, when I filed the motion to disqualify you and alleged that you had a romantic relationship with Miss Willis.
Yes.
After that, you...
She do dress like Hillary Clinton with them damn dress suits.
updated these responses, correct?
Yes, ma'am.
And so your new
That is definitely something Hillary Clinton would wear.
responses, you now changed your answer from that you didn't have any of this to you're asserting the privilege under 24.5.505, correct?
Yes, ma'am.
Okay. And both of these are under oath.
Yes, ma'am.
You also updated your response to the question about spending time with someone other than your spouse for dinner, drinks, things at restaurants, bars, hotels, or the other person's home, correct?
Yes, ma'am.
So in December of 2023, you said no to all that. And then in January, after I filed my motion, you said privilege to all that, Fifth Amendment privilege.
Yes, ma'am.
Okay. And just to be clear, was it?
Sorry, I'm going to object the characterization of Fifth Amendment privilege. I think it was a statutory privilege, and that's quite different.
That's what I was just about to ask him. So that privilege covers infamy or Fifth Amendment privilege, correct?
So it's a privacy privilege is what I updated my response to do. Once you filed your motion to intervene in my divorce action, I then figured that you were in talks with my former wife's divorce lawyer.
Okay.
And because of that, I asserted a privacy privilege because I didn't want the proceedings of my divorce to bleed over into the proceedings in this case, which is the case that obviously you're involved in.
And now that they are divorced, they've been divorced since 2021, he said, it's weird that she didn't have to testify.
So your answers in December of 2023 that you didn't have any documents about any travel that you took with Miss Willis, that wasn't true though, correct?
They didn't ask me about any documents regarding Miss Willis.
A romantic partner. They asked you for documents regarding a romantic partner. So I'm sorry, I inserted Miss Willis's name. Let me rephrase the question. They asked you for documents about travel with a romantic partner in December 2023. And you under oath said you did not have any of those, correct?
I did not.
Okay.
And they asked me about gifts.
Right.
I never purchased a gift for Miss Willis.
And they asked you about receipts for dinner, receipts for drinks, hotels, bars, and restaurants. And you said you did not have any of those.
I did not and do not have any receipts for any of those things.
Okay. And part of the civil discovery, they say that even if you don't have it in your pocket, if it's within your purview, you got to get it and give it to them, correct?
Your Honor, I'm going to object again to the relevance of the questions about the scope of civil discovery. I think she's asked him about statements he made in pleadings. The answers are already in the record. And
this little twitch he got going on this. What is that about?
All right. To the extent you're trying to establish a prior,
he got this gonzo nose. I don't know if I like it. And then sometimes like he'll hold his jaw and it'll make it look like ain't no teeth in his mouth. That's just what I envision. I'm just saying.
Miss Truth, Miss Merchant, I'll allow you to ask a few more follow-ups, but if it's not there, we have to move on.
Thank you. So in 2023, December, you said you didn't have any receipts.
I do not have any receipts. I did not have any receipts.
But you did travel with Miss Willis in 2023, correct?
I did.
And you traveled with her in 2022, correct?
I did.
And you traveled with her in 2021, correct?
No.
So you only traveled with her in 2022 and 2023?
2022 and 2023 is what I recall.
That's what you recall?
Yes.
What is all that about?
Okay. So you just don't remember if you traveled with
Like,
her?
is it the coke or is it allergies? Like, what's going on?
2021?
2022 and 2023 is what I recall.
Is what you recall. My question is, did you travel with her in 2021?
Not recalling.
Oh, getting ready to lie. Yeah, body language.
So it's not.
And these are all things that people do just without thought.
No, you just don't remember?
I'm not recalling any travel in 2021.
So you did not travel with her in 2021?
Your Honor.
This has been covered. Let's keep going.
Thank you.
He do look like he get ready to steal the church's money. Like he a pastor that's getting confronted or, you know, there's a hearing about him stealing the church's money. That's what he looked like. He literally looks like a pastor. His grin, all of that.
Yeah. Let's see. You filed an affidavit in this case, correct?
I did.
Okay, and I marked that already. I gave it to the state as number 1. So then is it number 1, ma'am?
It's probably still smell like Fanny shit.
Coach Judge?
Right.
Thank you.
And now I'm not saying that they smell, but if he got divorced a couple of years ago, what's to say he ain't still topping her off?
In that affidavit, you swore under oath, correct?
Yes, ma'am.
And in that affidavit, you swore that.
You gonna put them glasses on like he really need his glasses.
Well, first of all, do you recognize the affidavit?
I do.
Okay. Did you sign the affidavit under oath?
I did.
And you gave this affidavit specifically to refute the allegations that I had raised.
Yes, ma'am.
Nobody forced you to sign this?
No, ma'am.
Drives up in a Maybach. His name is Deacon Trickoff.
You chose to sign it?
Or Bishop Reverend Trickoff.
I did.
And you signed it on purpose to admit into court to refute allegations?
I did.
You signed it specifically to prove that you were not in a relationship with Willis prior to November 2021, correct?
Correct.
Okay. And
when he do this, it look like he ain't got no teeth in his mouth. I swear it do.
you were a lawyer when you signed it?
I was.
And you're still a lawyer today, correct?
I am.
When were you barred?
1999.
Okay. And you believe that your relationship with Miss Willis.
Look, and then he took the glasses off. He didn't need them glasses for nothing. He got them glasses out of CVS. And Max said, who said, give my grandma her glasses back? Oh, Bell.
This is subject to attorney-client privilege, correct?
I'm going to object to that, Your Honor. I don't think that's factually correct. I don't think that's a relevant question, and I don't think it's appropriate to question this witness about the scope of his attorney-client privilege. He's got an attorney who can speak for him for that, but questioning the witness, I think is inappropriate.
He might have some good cologne on. I think that's the real reason why she mad at Fanny and Nathan Wade, because she didn't get to him first. What it's looking like.
All right, so a lot to unpack there.
Man.
The question is simply that
Deacon Dick him down. I'm dead. I like that name, Deacon Dick him down. I'm dead.
does he believe there's a relationship that exists in the terms of attorney-client privilege between him and Miss Willis? Is that accurate,
Yes,
Ms.
Judge.
Merchant?
It was. I asked if he believed his relationship with Miss Willis is subject to attorney-client privilege.
Okay, I don't see why yes or no would be barred.
Maybe I'm not understanding the question.
Right. Wouldn't it be attorney-client privilege for Fani as well? See? Y'all
If the
fucking
question
up.
is, does Mr.
Fucking up the church's money.
Wade and District Attorney Willis have an attorney-client relationship?
It is not.
There's no foundation for that. If the question to the witness is, does his relationship with District Attorney Willis impact his attorney-client relationship with his divorce attorneys? That I don't think is an appropriate question for that witness. First, first I believe is a proper phrasing. The second, I think there's been a representation that Mr. Wade preserves and doesn't waive anything, and so I think asking him particular questions in order to potentially backdoor.
This girl, Ms. Merchant, take them damn shoes off. Them shoes are ugly as hell. I don't know what the hell. These are like funeral home shoes. Like if you go into a funeral home and you ain't got nothing to wear on your feet, they just got a lost and found box. And she found these bitches in there. Them things is ugly as hell.
Or a waiver is inappropriate, and that's my question.
Like, and then if you like the shoe, they didn't have no white ones or off-white to go with your blazer or nothing. Like, girl, get your life.
All right, if we're just trying to, again, assess where
Like she bought that outfit at Savers. Yeah, or Ross.
privilege does or does not exist, and we're not actually getting into it, I think we can establish those, parameters. But Ms. Merchant, can you rephrase the question based on that concern, and we'll see where we are?
Yes. Do you believe that your relationship with Miss Willis is subject to an attorney-client privilege? Not
like she really thinks she ate. She really think that was a bomb outfit. You and
Miss Willis have one.
She thinks she showing up Miss Willis. That's why Fani came into the court when the judge said, I'll be back in a couple of weeks or whatever. She had gotten a whole makeover. Her hair was all pressed. She took the grays out, all that. Like, she came and did her thing. She was like, no, this bitch is not finna just be trying to flirt with my ex with them damn ugly ass hospital shoes on. But them shoes look like they're used to push gurneys down the hallway. Them shoes is ugly as hell. I'm sorry.
But do you
It is
believe
not
that that
it.
relationship is subject to one?
I'm going to object to that question as it's phrased. In what context? Any conversation with his attorneys is privileged. That I think is clear. What's not clear to me from that question is Ms. Merchant asking in the context of your communication with your attorneys? Is that or outside that context? Is it?
Right. And Ms. Merchant, I think we need to figure out what are we getting at with this.
I'm just trying to figure out if he thought that their relationship is subject to an attorney-client privilege. I mean, it's been asserted. I think it's
Them definitely some Payless shoes, but them is Red Wings dress shoe line, their collection.
going to be asserted, and that was all I was asking.
Shoes is made by Shaq. They
I mean, the actions themselves wouldn't be an issue. It's more
Right, if someone
communication.
saw-
American elephant.
Someone saw them, someone had knowledge of it. Is that attorney-client privilege? I want to
All right. Well, I guess I would find his legal opinion on this isn't relevant. We can deal with that as it comes up. So sustained.
And then her dress suit don't even fit her. Like, it's all like, it's got room in it and shit.
2022.
I'm telling you, she got that big ass bag.
In this affidavit, you swore that you and Willis developed a personal relationship.
Yes, ma'am.
Okay. And you said that didn't develop until
She bought that outfit at Plato's Closet.
2022, correct?
That's correct.
Okay. And that's different from what you said in your pleading in May 2023 in the divorce case, correct?
No, ma'am.
In May 2023, when you were asked if you had if you'd had any affairs, essentially, and you said none.
That's correct.
Okay. So in May, you said you had not, in May 2023 in the divorce.
Fani's dress was cute. It was just backwards, in my opinion. Because ain't nobody gonna put no zipper in the front. That's crazy.
Divorce case, you said you had not had a personal relationship, an affair, a romantic relationship with anyone.
That's correct.
But you told this court in the affidavit that you did have one that started in 2022. So that would have been ongoing at 2023.
So here, I think there's a distinction, if you'd allow me to explain. The interrogatory asked the question during the course of your marriage.
Not the gas station, bro. It was next to the tall tees. I'm dead. I used to hate them tall tees, fam.
Or to date, it actually says,
I'm going to request that the witness be permitted to answer.
Mr. Wade.
So my marriage was irretrievably broken in 2015, ma'am, by agreement. My wife and I agreed that once she had the affair in 2015, that we'd get a divorce.
See, and allegedly, the what I heard was Nathan's wife slept with his best friend.
We didn't get a divorce.
So that's what probably ran him into Fani's arm.
Immediately, because my children were still in school and I refused to allow them to grow up without their father at the time. So we waited. We waited until the youngest graduated and we dropped her off at college and then filed for the divorce. So if you're asking me about the interrogatory as it relates to having the 2022 relationship with District Attorney Willis, I want to say, because my marriage was irretrievably broken, I was free to have a relationship.
So the question, though, was if you had had a relationship. And in 2023, you said you did not. And that is different than what you said in this affidavit, correct?
See, he trying to use his little fine-tuned words to get up out of this one. Miss Merchant is correct.
No, ma'am. I said during the course of my marriage. So
you believe it too?
Regardless if that was a deal that him and his wife had because she had cheated. And that's just crazy. Like, he found out he can't trust his wife. He can't trust his best friend. He can't trust Terrence. Like, damn.
Let me finish, Ms. Merchant. So in 2015, my marriage was irretrievably broken. So I did not have
a relationship with anyone during the course of my marriage.
And in that interrogatory, they asked you if you had any receipts for travel with someone of the other sex up until the time you were answering it. Is that correct?
Yes, ma'am.
And you said that you didn't. You've already testified to that earlier. But in this affidavit, you
When he do that, that is ugly.
said you swore that you had travel expenses and shared expenses on travel with Miss Willis.
Again.
Right, exactly.
During the course of my marriage, I had no relationship or receipts.
I'm not asking about during the course of your marriage.
Your Honor, I'm going to ask the witness to be allowed to answer the question.
Continue. I have no problem with answer.
As it relates to receipts today, I don't have any receipts, ma'am.
So you don't have any travel receipts available to you for any travel that you did with Miss Willis?
I don't have any receipts, no, ma'am.
No receipts that, so you're.
He doing all this weird ass shit with his face. Nervous.
You used your business credit card for these trips, correct?
I use my business credit card for everything.
Okay, I guess. You used it for your kids' tuition.
Yes, ma'am.
You used it for personal travel with Miss Willis.
Yes, ma'am.
And you have receipts from those business credit cards that you have to file with your taxes, correct?
No, ma'am.
No.
I filed a statement. I turn over the statement, and whatever's there on the statement, the accountant looks at it, and the accountant says, okay, this is personal, goes over here, this is business, goes over here, here are your taxes.
So you have those statements. We'll call them statements instead of receipts. You have those statements, correct?
I have the statement, yes, ma'am.
Okay. But when you answered the interrogatory under oath, you said you did not have anything to show the records of travel with Miss Willis.
I answered the question. I had no receipts, ma'am.
You had no receipts, but you had statements.
I ordered the statement. Yes, ma'am.
You did order the statement. Okay. And so we're just talking to semantics between invoice and statements or receipt. I'm sorry.
Object, Your Honor, to the argumentative tone of the question.
Oh, damn. I basically said that he had to have been in a relationship. Like, okay, if he was technically married to his wife, but they stayed together because one of the children was going, they waited until the child was going to college, but he entertained Fani, then the answer is yes. To the question.
All right, it's the same.
Thank you, y'all. My bad.
Let's see. You also in this affidavit said that no funds paid to you for compensation as your role as special counsel was shared with Willis, correct?
That's correct.
Okay. And that you never cohabitated with Willis, correct?
That's correct.
By cohabitation, does that mean that you never spent the night with Willis?
I spent the night with her during travel. Yes, ma'am.
Okay. And so I just want to qualify your use of the term cohabitation. That means you didn't live together.
That's correct.
But you did spend.
But what if he was going over there and getting booty calls and going back home?
The night together?
Yes.
When was the first time you spent the night together?
Your Honor.
He do look like Joe's evil twin brother. I'm dead.
That's the subject of his affidavit, Judge.
Right, but it might not be the subject of this hearing. So the question is the nature and extent of the relationship. And so if they just spent the night on a single occasion, I don't think we're going to document in detail every single time that happened.
And I don't.
But they went to Aruba. They went on a cruise. They, you know what I'm saying, went here and there. So how did they only spend one night together, allegedly?
Intend to do that, Judge, but I
Hey,
think
girl,
what is relevant is when the relationship started, and that's what you had indicated on.
Well, why don't we start with that
I don't
question
have
and go
an
from
objection
there?
to that question.
And that's what I asked when the first time he spent the night with her was. That's what I asked.
That's a different question, isn't it?
Okay, so let's not talk about when you spent the night. When did your romantic
And
relationship
then it's the grin that he gives them, like, I got it all under control.
with Miss Willis begin?
2022.
When? In 2022.
early 2022.
So you were appointed in November of 2021,
Yes, ma'am.
and your relationship started early. What's early? January, February?
Around March.
Around March. But you two met at an October 2019 judicial conference, correct?
Yes, ma'am.
And describe your relationship at that point then.
Which point?
2019.
So I was at a judicial conference to teach a course, if you will, to newer judges. I did that in 2019. As I was exiting the conference, another judge was standing outside who was a friend of mine. I stopped and exchanged pleasantries with her. And standing, talking to her at the time was then Judge Willis. She introduced us. At that time, we shook hands, exchanged business
Oh yeah, I forgot that she was a judge too.
cards, and I got into my vehicle and left the conference. So that meeting was probably 3 minutes.
Okay. When was the next time you talked to her?
Didn't talk to her again, probably maybe a month or a month and a half had gone by.
Okay, so you talked to her November maybe?
Maybe.
On the phone?
On the phone.
Okay. How regularly did you speak with her in 2021 on the phone?
In 2021?
I'm sorry, 2019, I'm so sorry. 2019, how frequently did you speak with her on the phone?
2019, after the meeting, I probably talked to her 2 or 3 times. She would have questions. I was the district rep for the particular district that I sat in. And the judges would, when they would have questions, they sometimes would go to the rep. So she was outside of my district, but she would call me. She felt comfortable calling me to ask me the questions. I don't know if you know the racial makeup of certain benches, but it wasn't very diverse. So she felt comfortable calling me for advice. And she did that. And we had also in common that she was starting a private law practice at the time, and I'd already had mine up and going, and we talked about balancing the demands of the bench with their private practice. So we didn't.
Look at him trying to make it seem like the relationship was wholesome.
We didn't talk that often, but when she had questions, mostly legal issues that would come up, she would call me.
I just want to make sure, because my question was just how many times, and you said 2 to 3 times, right? Okay. And in 2022, how frequently did you speak in 2022? This is before you were appointed.
I'm sorry, perhaps Ms. Burgess, your timeline for 2022?
I'm sorry, 2020. 2020. How frequently did you speak in 2020?
2020,
He probably was rehearsing this in the mirror and shit.
it was more frequent than 19, obviously, but
More frequent. Can you tell me approximately a month how often you think you spoke with her on the phone?
Your Honor, I'm going to object to the granular detail. I think Mr. Wade can certainly answer however he wants to, but if we're going to go through every time you spoke on the phone as opposed to generally characterizing the relationship, it would be more detailed than is necessary.
Judge, I'm not going to go through every time they spoke on the phone. I'm asking for generally how frequently they spoke.
I think at that level, that's fine.
Thank you. About how frequently did you speak in 2020?
per month.
I mean, if it was 2 or 3 times that entire year, you can tell me that. If it was more than that, then you can quantify it by month.
No. We spoke on the telephone often. I mean, I don't know how many. I couldn't give you a amount of time because remember, COVID happened and the world was shut down. But so we spoke on the phone more than 2019, definitely.
Okay, let's qualify it. Before her election.
He probably did.
In 2020.
He need to stop making all these faces though. It's weird.
How frequently did you speak?
You mean as she was campaigning?
Before the election. Yes, as she was campaigning, before she was elected.
It's two different animals.
As she was campaigning before she was elected.
Okay, so during the course of her campaign, we didn't talk as much, obviously, because she was busy. Fulton County is a large jurisdiction to cover. So we didn't talk a whole lot, but she did know that I'd gone through the election process. So when things would come up, that she had questions about, she would call me and ask me. So,
and just to be fair, I'm only
Ms.
Judge, actually, he's not asked and answered. And I mean, I don't mind him explaining, but I just wanted to know how many times. I mean, if we talk about every conversation they talked about, I
Just gotta let him finish his sentence, and then if you need to redirect him or have me direct him, I can. Mr. Wade, you can continue.
Yes. So sometimes it would be like a 3-second call. She would go, during your election, have you ever seen this? And I would say, no, but here's what I would do. And we'd hang up. She had a lot of professionals working for her, but she trusted my judgment, so she called me. Be brief conversation, but she called.
So my question was, how
Hey, Information Man Show. I'm good. How are you?
frequently did you speak with her prior to her election? Frequently? Infrequently?
More than 2019, but it wasn't a everyday thing, no.
In 2021, before you were appointed in November, so January to November 2021, the only time I'm talking about, how frequently did you speak with Ms. Willis on the phone?
In 2021, then it became frequent.
Frequent?
Yes.
But you did not work at the DA's office at that point, correct?
I did not.
So the affidavit that you submitted, you showed on it, you submitted one record that showed that Ms. Willis had paid a couple $100s for one.
Good to see you too.
Flight, correct?
Say again?
The affidavit that you submitted to this court showed that Ms. Willis had paid for one flight several $100s. Is that correct?
No, ma'am. I think that, are you drawing a distinction for her paying for a flight or for her actually booking a flight? Because those are two separate things.
I will re-ask it. The affidavit you filed in this court, you alleged that Ms. Willis paid for one flight. Paid for one flight, correct?
No, ma'am.
You did not allege she paid for one flight.
No, ma'am. What I allege is that our travel was split roughly evenly. So where you see I have booked a flight or I've paid for a flight with my credit card, what you don't see is that she covered her own flight reimbursement to me. The flights that you see here are the flights that she would have booked with her own resources, with her own car.
And there's one flight, correct?
And maybe I would have believed that if he didn't have this weird credit card situation with Terrence.
One flight that she actually booked.
Ms. Merchant, let him finish and then you can redirect him.
One flight that she actually booked, yes. The other flights I booked, she paid for.
So the affidavit, you submitted one flight that she booked and paid for.
Yes, ma'am.
Your Honor, I'm going to object to the phrasing of that question. The line in the affidavit is not as Ms. Merchant is representing it. It said examples of the District Attorney Willis purchasing plane tickets for she and I with her personal funds were attached as an exhibit. It certainly did not represent that it was the only example of the District Attorney purchasing flights for Mr. Wade or for compensating other travel.
Understand, Ms. Cross. I think that's
Give it that box up.
You can,
for real.
it's not on the record, but also something you can take on Cross.
And then I remember Fani saying that her 50th birthday wasn't fun or whatever. I wonder if he was involved in that, because she's 53 now, but go back 3 years, you know what I mean? When she paid for his trip to Belize, was he supposed to pay for her trip somewhere or something for her birthday and it didn't work out right?
And just so everybody's clear, all I asked you is your affidavit, you submitted proof of one flight that she paid for in Florida. That's all I'm asking. Correct?
With the explanation, yes, ma'am.
Okay. It's all I needed. You said in the affidavit that you roughly shared travel though, correct?
Yes, ma'am.
Okay. So this roughly sharing travel, you're saying she reimbursed you.
She did.
And where did you deposit the money she reimbursed you?
Oh, it's cash. She didn't give me any checks.
So she paid you.
And then it's often weird too, because she didn't go nowhere with Robin Yeartie. She just, decided she gonna go, you know what I'm saying, to these other countries or whatever with Nathan Wade.
Cash for her share of all these vacations.
Mr. Schaefer, you'll step out if you do that again.
Yes, ma'am.
Yeah, and then he was her, she was his shoulder to cry on when the wife was cheating with the best friend, and he, they stayed together just until the child went to school and all this. And
okay. And so all of the vacations that she took, she paid you cash for.
Because he definitely on Viagra.
Yes, ma'am.
And you purchased all of these vacations on your business credit card, correct?
Yes, ma'am.
Okay. And you included those in deductions on your taxes, correct?
No, ma'am.
No, you did not.
No, ma'am.
Okay. We'll get to that in just a minute then.
And you could tell that her back is big because the jacket rides up in the back. I'm just saying, her back gets on my nerves, like literally just looking at her. She's annoying as hell. She's like a Karen, like just, I don't know.
Let's see.
You'll see tomorrow with Fani. You could tell that she's really angry at Fani.
So the only thing that you have actual documentary proof, not cash, is this one receipt that you attached to the affidavit. Is that correct?
Your Honor, I object to that question. That is a mischaracterization of the assertion that is in the affidavit.
I'm asking.
So then he can deny it. I think he can fend for himself, Ms. Merchant.
Is this the only written proof that you have of a trip she paid for?
That I have?
Yes.
Yes, ma'am.
Okay.
Wait, he said he had cancer.
So you submitted the one piece of written evidence that you have that she paid for something. Everything else is in cash. Is that accurate?
No.
That's not accurate. Okay. Please tell me, what other receipts do you have then that show that she paid for things?
I don't have them.
Okay. So this is the only receipt that you have to show that she paid for travel.
That I have. Yes, ma'am.
Thank you. Okay. In your divorce case, you filed a domestic relations financial affidavit, correct?
Yes, ma'am.
Okay. The first one you filed was in January 2022, right?
Okay, I got you. I must have missed that.
And those are under oath?
Yes.
Okay. And you also filed corporate taxes in 2022, correct?
Yeah.
Okay. And tell me about your business. Do you have a partnership or are you a solo practitioner?
I'm telling you, them shoes is ugly. I didn't even know they still made them.
As it stands today?
Yes.
So today, I have a separate PC. My law partner has his own separate PC.
Okay.
So, but we're under the same umbrella, under the same roof. So we share expenses, we share income.
The same thing he did with Terrence Bradley.
And we split it.
So are you a partnership?
We are a partnership in the sense of we share expenses, we share income.
Are you registered with the state of Georgia as a partnership?
So the WBC firm that included myself, Terrence Bradley, and Christopher Campbell, we were registered with the Secretary of State as a partnership
Right.
for a short period of time.
And that was dissolved, though, right, in 2023?
I'm going to object to the witness answer his question.
Mr. Wade, do you have something else?
Like what they got going on here. So they had a law firm, but it was dissolved and all that. And these are lawyers. Like what is going on?
Down there.
When things happened and we excused Mr. Bradley from that partnership, it left Christopher Campbell and myself. So now you have two separate PCs under the same umbrella, sharing expenses and income.
Okay. So let me just narrow down my questions then. Are you registered? And have you been registered at any time in the state of Georgia as Wade and Campbell?
Wade, no ma'am.
Okay. You've never been registered as a partnership?
As Wade and Campbell, no
Wade
ma'am.
and Campbell, yes, thank you.
But as Wade Bradley Campbell, yes ma'am.
Wade Bradley Campbell was registered on April 1st, 2021 and administratively dissolved on September 8th, 2023, correct?
Yes ma'am.
Okay. Other than that partnership, you have always been registered as law office of Nathan Wade,
Yes ma'am.
not with Chris Campbell.
Correct.
Okay. Thank you. So the affidavit that you filed in your divorce case, the first one in 2022. I think I'm up to number 7. I'm going to just show you, give you a group of exhibits so we don't have to go back and forth. I'm marking the 2022 as 7. I'm marking the 2024 as 8. I'm marking the credit card statements as 9, and your taxes as 10.
I'm going to object to the taxes, for the relevance of them at this point. The relevance of this entire business structure doesn't seem clear to me as either impeaching or relevant to the issues that the court's, under the court's consideration. But insofar as we're talking about tax returns and other things like that, certainly that's should be redacted, and I would object to the relevance of it.
I agree they should be redacted. I don't agree to the relevance, but I haven't.
Like this cameraman don't stay still. Like I get it, he gotta move the camera, but they got like stabilizers. It seemed like he got like a little cheap tripod from Walmart or something.
Tender them yet, Judge. I'm just marking them right now so that everyone
You're welcome.
can follow.
All right. And what is the eventual relevance that you were getting at here?
Well, I'm going to ask him because one of the things that we have to show in this case is a personal and financial interest. So, and he's talked about how he was reimbursed for these things, and so I have a right to go into the veracity of the statements.
It's good, Mr. J, the Great.
So let's see, 7, 8, sorry, 9. And then
there she goes, standing like a damn grown-ass man again.
All right, so right now I'm just going to show you what I've marked as these exhibits.
Can I see what you're showing?
Oh, yeah, of course. They're all from the Ministry Traffic Review.
And I think the cameraman knew what he was doing. Keep showing us her damn shoe. She's ugly as hell.
I don't want to hold you up to copy.
No, other than the traffic review. I'm just. Can I approach Judge? I'm just showing you what I marked as 7, 8, 9, and 10. Just so you have them for your reference as I ask you some questions.
All right.
So,
It looked like the same papers that Fani lifted up in the air and was like, it's all a lie.
So,
Right. Or something.
So these are sworn. I'm first going to ask you about the domestic relations financial affidavit. These are sworn. You're filed under oath, correct?
Yes ma'am.
And the most recent one that you filed was filed on January 26, 2024.
Yes ma'am.
So a few weeks ago.
Yes ma'am.
And in that one, You said that you made $9,500 each month, correct?
Yes, ma'am.
You said that in 2022, well, in 2022, in this case alone, isn't it true you were paid $303,000? Over $303,000.
I was paid?
Yes, in this case. Fulton County, by Fulton County.
I see where you're going. So.
And Judge, I just asked him to answer the question. If he wants to
I was about to say, because $9,500 a month is not.
explain it, I have a problem with that.
What the
Mr. Ray,
hell?
just listen to the question asked and just answer the question asked.
In 2022, isn't it true you were paid over $300,000?
No, ma'am, that is not true.
You were not paid over $300,000 by Fulton County.
No, ma'am, I was not.
Okay, how much were you paid in 2022 then?
So what I was beginning to explain was Fulton County wrote a check to my firm.
Okay.
What happens at that point is the checks are then deposited.
He qualified for food stamps. If he was making $9,500 a month, that's $114,000. Where's the extra, you know what I'm saying, portion coming?
Do you have the bank statements? You see that?
Oh, he do own a law firm.
And then they are dispersed.
Or had one.
Between the three of us. So there was Mr. Bradley, there was Mr. Wade, and there was Christopher Campbell. A third. So when you ask me if I was paid $300,000, the answer is no. I got a third of that went to my personal firm. Now, once the money was distributed to my personal firm, obviously the expenses come out of that, and I get, at the end of the day, whatever the profit is. So I did not get $300,000. No.
So where's the other $14,000 coming from?
And let me just clarify. My question was not, did you put in your pocket $300,000? My question was the law firm of Nathan Wade paid over $300,000 in the year 2022?
Again, a third of that came to the law firm of Nathan Wade.
So you're saying that the law firm of Nathan Wade did not receive checks from Fulton County government over $300,000 in the year 2022?
That's a different question. A third of the 300,000 came to Nathan Wade.
Okay. Again,
the way he's batting his eyes at her.
I'm not asking what went in your pocket. I'm asking, was the law firm of Nathan Wade paid
Right, so they each split it.
over $300,000 in 2022?
I'm just asking answers.
I know, but I think we're dancing around the point there. So final time, Ms. Merchant.
That's fine. I can move on, Judge. Thank you. So you said that they were dispersed amongst all of you, or put into an account with all of you. So it's your testimony that for 2022, every check you received from Fulton County government went into an operating account with you, Bradley, and Campbell.
No. That's not what I testified to. So the Wade, Bradley, and Campbell firm established an account when we decided to purchase a building in 2022. At that point, every piece of income that came into the entity went into that account. And then after expenses were paid, it was split a third, right? Once that was dissolved, then the funds would go into a different account, my account, one of my accounts. And then I would disperse the funds between now Attorney Campbell and myself, one half and one half.
Okay.
Make sense?
It does. Let me be more direct then. So the Synovus operating account that you had for Wade, Bradley, and Campbell,
Yes, ma'am.
the checks from Fulton County from January of 2022 until June 17th, 2022, those checks were deposited in that operating account.
Yes, ma'am.
Starting on July 15th, 2022, the checks you received from Fulton County up until May 26th, 2022, all went into an escrow account that you had at Fifth Third Bank, correct?
No, not all of them.
Not all of them?
Some of them, yes.
So it's your testimony that some of your checks from July 15th, 2022, up until May 26th, 2023. Some of them went into an account outside of Fifth Third Bank.
Your Honor, I object to the relevance of the financial transactions.
How much money you made is highly relevant in this case. It's the personal financial business and where the money was. And I mean, it's just a follow-up on other things that he's testified to.
And why is how much money he made relevant?
Because he represented it's very relevant. He filed an affidavit with the court saying, with another court, he told another judge that he made $9,500 a month. That's what he swore to. And
All right, so this entire inquiry is just to establish that prior and consistent statement.
yes,
All right. I'll give you a minute or two more to try that, but we're gonna have to move on.
thank you. So I know you're saying that you only got a third of the
Jeanette had said that too, that he made 9,000 something a month.
$300,000, but you were paid the firm was paid over $300,000 in 2022, correct?
So, Ms. Merchant, it's not what I'm saying. They're numbers. They're there. It's the truth. The funds were paid. They were divvied between the three of us, going into an operating account. Expenses paid out of it.
Okay.
At the end of that, the 9,000 figure is what you had.
So that's where you got the 9,000 figure from.
Yes, ma'am.
And let's see, prior to when you filed for divorce in November 2021, you would use Mr. Bradley's credit card to pay for things with Ms. Willis.
Right, but he's still like trying to be slick with it though.
Correct?
Here we go with the squinting.
And then pay him back in cash.
I've never used Mr. Bradley's credit card.
You've never used his credit card?
Never.
For transactions to anything with Miss Willis, out to dinner, anything like that.
Look, he trying to, cause it's a company card.
Hotels.
I've never used Mr. Bradley's credit card. I've never used anyone else's credit card. Not even my father's, and we have the same name.
And you'd pay back, if you ever did use someone's credit card, you'd pay back in cash, is that correct?
Ma'am, I've never used someone else's credit card.
Can you take a look at the bank records that I gave you? That's the largest tab you have.
For the record, which exhibit is this?
It is exhibit, hold on, Judge. Exhibit 9. It should be the largest section you got.
Your Honor, before there starts getting questions from
There you go. There she go, Jeanette. Went up there again.
the exhibits haven't been tendered, and I maintain my relevance objection.
All right, let's see what the next question is, and maybe then the objection is going to be highly relevant.
Is that an accurate copy of your Capital One statements that you provided in discovery to, is that an accurate reflection of your Capital One records?
That I provided in discovery.
Yup. Said that he used his business credit card. Yup.
Discovery to whom?
To your divorce lawyers or that you
But I think that Nathan's gonna say, like, he gonna try to get off on a technicality with that one.
in the divorce proceeding.
If I remember
Is
correctly.
the question, does he recognize it by sight?
I'm asking if it's his statement, his bank
I
statement.
think that is the question.
Well, I mean, it's a thick document, but I believe you if you say that this is.
Oh, so like he didn't want his wife to get the money, get any of his
What
money?
my wife's divorce lawyer gave you, I believe it.
Your name's on every page of that document, correct?
On every page?
Pretty much every page, if not every page.
And she ain't even got no stockings on or nothing. I know that little rubber from the shoe tearing her soles up.
No, it's not on every page, no man.
They're all Capital One bank records showing. Okay? Just take your time, look through it. Tell me if there's anything that you think is not yours.
No, they appear to be.
Okay. And those bank records show that you paid for.
Wait, you mean he still has access to the money today?
For travel with Miss Willis.
Yes, ma'am.
Your Honor, I'm going to object the relevance of these documents and the,
Well, I think, are you tendering Exhibit 9?
I'm going to, Judge, and they're highly relevant to the whole
Well, he's
reason.
asking a question about the contents of them and they haven't been admitted yet. So why don't we start there?
Thanks. Those show travel that you and Miss Willis took.
Well, so you're asking about the contents of something that hasn't been admitted yet. Right.
Well, I'm asking him if that's what it shows because I know that they're going to object on relevance.
Well, first we got to say if it's, you've authenticated it, perhaps. And before we get into other details of what's in it, I think
I can
it needs
tender
to be
them.
admitted.
That's fine. I move to admit them.
All right.
object on relevance.
On relevance. All right. And on that, overruled. Ms. Merchant.
Thank you. Those records demonstrate that you paid for travel with yourself and Miss Willis, correct?
They should.
Okay. And let's just talk about that travel.
Okay.
The first trip is Belize in March 2023. Is that a trip that you took with Miss Willis?
Are you asking?
Did you take a trip with Miss Willis in 2023 to Belize?
I did.
Did you take a trip to California with Miss Willis in 2023?
I did.
Did you pay for those trips on that credit card?
I used the credit card to book the travel, but understand.
She paid you back cash.
Well, let me say this. Let's take the Belize trip, for example, since you started there. That was a birthday gift to me, so I paid nothing for that trip. Zero.
Now, how many friends have you just paid $10,000 for them to go on a Belize trip? You give them $2,500 spending money, and you pay for the taxis, you pay for the room, you pay for everything else, Ubers, everything. That's just a friend, though. Y'all, they was definitely screwing. Talking about that for my birthday trip. They were, how was they close like this?
So
That's
the
crazy.
charges that are on your card, she gave you cash
I
for?
don't believe it.
She did.
Okay. So all of the charges.
Excuse me, Your Honor, I believe the witness had finished answering the question.
Oh, did you have more?
I knew it
Okay.
when I heard Fani say that his mother and him went on a cruise. I was like, girl, bye. You met the mom too. They was definitely screwing.
I wanted to get into the charges on the card because so traveling with her is a task. You can probably imagine the attention that happens. So for safety reasons,
So you mean to tell me that in Belize people know Fani? Maybe to the airport while it's still in America, but in Belize they know Fani?
to limit her transactions. I mean, imagine trying to walk through an airport or sit at a restaurant.
Exactly.
So there's no attempt to conceal.
No. This is Fani right here, standing here this whole time through her hearing.
It's a credit card. Everything is here. So
And that's not what I asked.
okay.
What I asked was the charges for Belize in March 2023 on that credit card. Those are things you purchased to go with Miss Willis to Belize.
Those are things that we booked with my card that she
Yes.
paid. Yes,
Yes. So those show up
But
on
he is wearing the little pimp suit.
your credit card.
they do.
And you're saying that she paid you cash to reimburse you for all of that.
She did.
And she paid you cash for both of your portions or just hers?
Both.
Okay, so that trip, Belize, just Belize, she paid you for everything on Belize.
The entire trip.
Okay. So the food, tattoo parlor, all that stuff, she paid for.
She done took the man to the tattoo parlor. Oh, they definitely screwed.
I'm sorry, maybe do the question?
There was no tattoo parlor in Belize.
The charges, there's a tattoo parlor on the charges. I'm not getting into what it was for. I'm just
That's what I was saying earlier. He definitely looks like a preacher. He definitely does, but he's an attorney.
asking if everything that's on that card related to Belize, she paid you back for.
She paid for it, yes, ma'am.
Okay. Let's talk about California in May 2023. You all went to California together.
So in March, they went to Belize. In May, they went to Cali.
Yes.
And you booked plane tickets.
Or June, whatever.
And her name was on those plane tickets.
They were.
And so I know you said that you were worried about security and things like that, but that was in her name. When she traveled, she had to use her name.
Oh, so the plane tickets? Yes, ma'am.
Okay. And you paid for those plane tickets and you paid for a hotel.
So again, the card, yes.
You used your credit card, and I'm not asking about after what happened. I'm asking, did you use your credit card to book your flight and hotel to California?
I did.
And there's a lot of Ubers on there as well for California. Did you pay for those Ubers as well?
Yes.
Did
We were in Napa.
And you're saying that Miss Willis, are you saying that Miss Willis paid you back for that?
Yes.
Did she pay for the entire trip, or did she pay for her half of the trip?
The Napa trip, she paid for the excursions. So the expenses sort of balanced out. I mean, there was never, let me be clear, there was never a time when I would say, hey, I bought dinner. Dinner costs $25. You need to give me $25. If you've ever spent any time with Miss Willis, you understand that she's a very independent, proud woman.
I object.
So she's going to
overruled, Mr. Wade.
So she's going to insist that she carries her own weight, and it actually was a point of contention between the two of us.
So you as an older gentleman got with Fani, who was treating you like the youngster, and she's the cougar.
Is going to pay her own way.
Because he just pimped her out of all that.
Let me re-ask the question.
Facts, going for sugar mama.
In California,
Big facts and Mac facts.
that you paid for, saying that she did not pay you back for cash. Instead, she paid.
Right, what is that for the tattoo? Who got the tattoo and what was it?
For excursions, and you believe that was roughly half.
Now, she gave me some cash, yes.
She
but
gave you
what I'm
some.
saying is everything that we did when we got into Napa, she paid for.
And look how happy he is while he's talking about these trips. He really enjoyed her company and, had a good time. He didn't have to come out his pocket like that.
The trip that she booked on her credit card in
And that's what makes him look more and act more like a preacher.
Miami,
in my opinion.
Did you pay her cash back for your half of that?
No.
So you never paid her back for the ticket?
Now that he got Fanny name on his ass, I'm dead.
She bought for you?
With a rose in her heart going through it or something.
No, I would say I did pay her back because there were times when I would pay for dinner.
Okay.
She would pay for dinner. It would balance out. But in a relationship, ma'am, you don't, particularly men, we don't go asking back for anything. So you're not keeping a ledger of things that you pay for versus the thing that she's paid for.
I mean, earlier he was on the verge of falling asleep, barely paying attention. Now he's not missing a beat. He's going into depth about their trips. And like M. Max said, proud as a peacock. He's literally like strutting his stuff right now. He's showing you all his colors. Interesting.
Which is why I said that it was a point of contention because she was very emphatic.
Pimping and Owen, fact.
And adamant about this independent, strong woman thing. So she demanded that she pay her own way.
But she's the district attorney of Fulton County, and she has to file financial disclosures disclosing any gifts with anybody that she does business with in Fulton County, correct?
I don't know.
Okay. Let's talk about Tennessee. You booked a cabin in August 2023 and paid for a cabin in Tennessee. That's when you paid for it. I don't know when the trip was. Can you tell us about that?
August of 2023.
You booked a trip.
Why you do his face like that?
For $1,481.54.
Are you asking me, did I take that trip?
I agree. I think they just acting
with
Miss
Willis, or are you asking me?
First, I was just asking you to acknowledge that that is correct from the records, that you paid for a cabin in Tennessee. Do you recall, and hopefully you can do it from your memory, do you recall paying for a cabin 6 months ago, $1,400.81 in Tennessee?
Now, why would these two, right, need to go into a cabin together? A cabin? That is personal. Like, no.
Where are we now? What page is that?
I'm just asking from your memory. Do you remember paying for a cabin in August?
Your Honor, if he's going to be asked about a particular transaction.
You can answer whether he remembers or not.
I mean, that probably adds to the excitement, knowing that they're fooling around at work and, you know, there's a chance they may get caught or whatever, you know?
Mr. Wade, I'm not asking you to go through 1,000 pages.
Not Tyrone Bigum's cleaned up nice.
Records. I'm asking if you remember paying for a cabin 6 months ago in Tennessee.
No.
Do you remember booking a cabin?
I booked lots of cabins.
So he could remember the trip to Belize, but he couldn't remember the cabin?
Did you go to a cabin with Miss Willis ever?
Like, he's grinning from ear to ear talking about those trips. I wonder how many memories played in his mind.
Ever?
Ever. You've never gone to a cabin with Miss Willis?
No.
It took him all that time. I really think that Terrence Bradley and him is related because they do this thing when they're asked the questions, they just wait a crazy amount of time to answer the easiest question. Like, what was that? Right.
Have you ever gone to Tennessee with Miss Willis?
And there's nothing to do in a cabin. So what was y'all doing?
Yes.
Okay. When was that?
That was around 2022, early 2022.
So he can remember 2022, but not 6 months ago?
Early 2022? Okay.
It was a day trip.
Right, they was fucking.
Okay, so you didn't spend the night?
So it was a day trip.
Okay.
We would drive there, have lunch, drive back. The reason we would do that is because the attention, she couldn't get any peace of mind going locally, so we get my.
Or was it if y'all were driving around in Fulton, you know, hugged up and kissing, that it would get back to everybody? Because he keeps talking about, you know, everybody knew her, everybody seen her and stuff like that, right? Like she goddamn Janet Jackson, or like somebody said Rihanna or something. Like, this is a DA, bro, a judge. She was a judge. And I'm not trying to downplay her parts. I actually like Fani, right? But, bruh, it's not like she's, you know, bro, like Beyonce or something.
Car and drive to.
Hey, Ivan.
Someplace off the beaten path and have lunch and drive back.
Is that when you went to Fani Goat?
Right, when he took that long to answer, like, seriously?
With her. It's in Jasper.
No, that's in Georgia. I don't recall going to Fani and Goat with her.
So the Tennessee day trips were only Tennessee.
Yes.
Okay. Did you ever do these day trips in Georgia?
Did we drive anywhere in Georgia?
Yeah, you were talking about day trips going out, and I'm talking about outside of the metro area. Day trips that you were just talking about. These trips you were talking about. The ones that you were, I'm only asking about the ones you were just talking about. Are all of those in Tennessee?
No, we drove to Alabama before.
Okay.
Back.
You drove to Alabama?
And who takes a day trip with their boss? Because essentially she was his boss.
Did you go anywhere in Georgia? North Georgia?
Yeah, I'm going to object to, if he wants to direct his attention in some way to a time frame or a location, then I think it might be easier for the witness to accurately answer.
Ms. Merchant, I think if you don't have the specific details yourself, we need to start getting into specifics or more maybe broadly phrased questions. We can't just be exploring around indefinitely.
Is it fair to say that you've taken so many trips with her, you don't even really remember all the places you've gone?
So many trips?
You're having trouble remembering going, if you went to North Georgia or not.
Were you asking me about specific places? And I want to be candid in my responses. So I have to jog my memory because these are places that I have frequented, but not her. So I want to make certain.
Like, the question was easy. Have you been on so many trips with her that you can't even remember? And then he goes and runs around the lake and comes back with some.
That
this
if
is
there was
crazy.
ever a time that she accompanied me, that I was candid in that response.
Aruba, October 2022. And I've got business record certificate for these, Judge, might be a little faster. But did you take a trip with her to Aruba in 2022?
Yes, ma'am. So that Aruba trip there was a package deal there. My mother had recently retired, and I decided to take my mother on a cruise.
Okay.
Y'all, would y'all bring y'all mother on a cruise with your boss or a coworker? I'm just saying, like, what?
And the second leg after the
Don't this sound like, Mom, I met a girl, a woman or whatever. I'm going to set up this cruise so you can relax a little bit and you can meet her.
Concluded, D.A. Willis and I went to Aruba. So that was all one trip, if you will.
Okay. So my question was, did you go with D.A. Willis to Aruba in 2022?
I did.
Thank you. And you paid for that trip using your business credit card, correct?
I did.
Okay. And you paid for a cruise as well, correct?
That's the cruise I was referencing with D.A. Willis, my mother, and myself.
Okay, and because there's two cruises, so let's just talk about the first one. Okay. So the first one was that's the one with your mother.
Yes.
And so you introduced D.A. Willis to your mother. That trip, you all took a cruise together, the three of you.
Yes.
After the cruise was done, you and D.A. Willis flew to Aruba together, and your mom flew home.
Yes.
And you paid for all of this with your credit card, on your business credit card.
I did.
And are you saying that Ms. Willis paid you cash back for that?
She did.
And
no, but let me make this distinction though, because the number that you're looking at reflects the three people on the cruise ship. There were things that my mother and I did, just the two of us, that D.A. Willis didn't do.
Look at him try to blame it on his mother.
And I'm not attributing that. I did not. My math is not good, but I did not include anything with your mother on this. Can I show?
You wouldn't be able to see it because it's not separated out. It just shows a charge on the account when actually it would have been something with my mother and I.
Judge, may I approach with exhibits 10 and 11? They're both certified business records one's from Vacation Express, one's from H2.
I thought 10 was taxes.
I'm sorry, 11 and 12. Yeah, thank you. And these are business records, Judge. They have the certification, so I moved to admit them.
All right.
He done been up to the podium where he at the witness stand about 4 or 5 times already.
11 and 12.
He ain't go up there one time while Terrence was there.
Based on Ms. Merchant's representation that they are true and accurate as to the certification that was provided to her, you have no objection.
All right. Again, seeing no other objection, they're admitted.
He probably did make his mama pay him back for the trip.
So the trip, just the trip to Aruba alone for you and DA Willis was
Or the cruise.
$3,835.26, correct? Just Aruba.
I'm looking for the amount.
This one is 11.
You don't put them CVS reading glasses back on.
Yes, ma'am. $3,835.26.
And then the Royal Caribbean for just you and Miss Willis was $1,269.70, correct?
No, ma'am.
Your mother's got a different line item on there. I'm talking about the cruise, the actual cruise cabin.
I think you need to rephrase that as in the form of a question, Ms. Merchant.
Did you pay Royal Caribbean for yours and Miss Willis's cabin $1,269.70?
Where are we? Which page?
We're on the receipts. There's just a few pages of receipts on exhibit number 11.
And the way that they said it is she's saying that they shared a cabin on the cruise or what?
Okay. I'm in 11.
Right.
Can you direct me to where you are in exhibit 11?
The receipt for Royal Caribbean. So we've got your flights on the one page. I already asked you about for Aruba. And just for the record, I blacked out their dates of them. And then Royal Caribbean may be on, oh, it's small. It's hard to read. It's very hard to read. So let me ask it this way then. Do you recall paying around $1,269.70 for a Royal Caribbean cruise for you and Miss Willis? You don't remember that?
That amount seems kind of small. I don't.
Okay, so you believe it was higher?
Not he said it's small.
Okay. While you were in Aruba, then you bought a cruise, a Norwegian cruise, right? And that was the New Year's Eve cruise?
While I was in Aruba, no, ma'am.
Oh, they was going on vacation while vacationing on another vacation.
Credit card documents that were admitted earlier show the purchase date when you were in Aruba, but you don't remember doing that in Aruba?
I didn't purchase.
Why does he keep wiping his eyes? What is up under there?
Just a cruise while I was in Aruba. That may be when the cruise company decided to run the invoice, but I didn't purchase a cruise in Aruba, no, ma'am.
Yeah, the 1,000 something.
Around the time you went to Aruba, you purchased
He should have really just been quiet when he was talking about, no, it was more.
a cruise for Norwegian for you and Miss Willis to take for New Year's, correct?
Before I went to Aruba, yes, ma'am.
And
Facts.
that was roughly $3,387.
Oh, yeah, for 3, that's not bad at all.
The cruise to Aruba.
That's why I was saying, did they share a cabin? Because 1,000 something bucks.
I mean, the cruise to, I'm sorry, the Norwegian cruise.
So that cruise was with my sisters.
Okay.
And the number that you are seeing would reflect my buying dinner for my sisters and their husbands.
I'm just talking about the cruise.
So wait a minute. So he went on a cruise with Fani. We got the mom and all that situated. But he went on another cruise with Fani, and his sisters went, and they brought their husbands. Child, they was definitely screwing.
The amount that was paid for the cruise ahead of time.
Because who he posted? Like, come on.
I'm just talking about that.
Okay.
That was a little over $3,000.
Yes, ma'am.
Okay. So, and I understand you're saying you paid for other things, but I'm just talking about the cruise amount. Okay. And you paid for a Jeep and you paid for dinner while you were there in Bahamas.
Yes, ma'am.
That's the one that Miss Willis paid for a flight for, correct?
That's one of the flights she paid for. Yes, ma'am.
Actually, a documented paid for, not cash. I'm talking about a non-cash transaction. That's what she paid for.
You mean the one that I provided the receipt for?
Yes.
Yes, ma'am, that's that.
Okay. And so she booked that on her credit card and wasn't worried about, I know you said earlier that you were booking everything because she was worried about people knowing where she was traveling. She didn't have any fears booking that one though, correct?
I'm gonna object to the phrasing of that question, speculated.
Don't nobody in Aruba know Fani.
So what was the motivation
Fani.
of the district attorney? She wants to ask if that was the transaction, and he responded that was the transaction.
Ms. Merchant, I think you can rephrase the question, but I'll sustain it on the current phrasing.
So she purchased that under her own name, correct?
She did.
Okay. Let's see. So I know we talked a little bit about the seminar where you all met. Isn't it true that you would go to Miss Willis's house in South Fulton County occasionally?
I've never gone to her house in South Fulton County.
You've never gone to her house in South
I've never seen her house. The first time I even heard the address of that house was when one of the individuals in the election fraud case somehow doxed it and it got out. That was the first time I'd even seen that address.
But you would go to the East Point condo, correct?
What East Point condo?
East Point, Hateville, something like that.
I've never been to East Point with Miss Willis.
You've never gone to a condo in either the East Point or Hateville area with Miss Willis.
Wait, that's different. I have gone to a condo in Hateville.
Okay. So Hateville.
Yes, ma'am.
Are you trying to get off on technicalities?
So you have gone to a condo with Miss Willis in Hateville.
I have.
Have you spent the night there?
Never.
Never spent the night.
Never.
Is that for real or is that a joke, Jeanette? They need to. They both done jeopardized everything.
Is that the condo that was rented by Robin Yeartie?
I believe it was.
And other members of the DA staff were there as well, correct? Sometimes.
I've never been around other members of the DA staff at a condo in Hateville.
There's never been any.
Well, I'm sorry, but it almost would have been better if he said that he was at a condo with other people, because you just spending too much alone time with Fani.
Security for Miss Willis?
Not around me.
Did you ever ride with Miss Willis with her security detail to and from the house?
I believe so. Yes.
No.
You served on Miss Willis's.
In order to practice in that state, yes.
Correct?
Yes.
And you were part of all of her interviews where she interviewed and re-interviewed employees?
Right, exactly. How many like little freak offs? How many like booty calls did they have? You know,
I would say
since he didn't spend the night.
99% of them, yes.
And what was the real reason why he didn't spend the night? Because he wanted to respect his quote unquote wife, even though, you know, their relationship already had issues with it, or so that the child, you know, didn't suspect anything.
Fair to say you took an active role in
I think it was because of the child.
interviews?
Yes, ma'am.
Prior to this, you'd never worked at a DA's office, right?
Have I ever worked in her DA's office?
At a DA's office, any DA's office.
No, ma'am.
Plus, I wonder how many trips or, you know, cruises that he went with Terrence Bradley.
Have you ever managed a large law firm? Or a
Your
large...
Honor, I'm going to object to the relevance of these questions.
Ms. Merchant.
He served on her transition team, and so, and what we're trying to prove is that there's a personal and financial relationship, and that it was improper. And so, you know, whether or not he had experience to serve on this transition team, I think is relevant.
Right. I think I already said it. We don't need the evidence.
Okay.
At that point.
Okay. Terrence Bradley also received a contract for Fulton County, correct? Correct.
You're asking me about Terrence?
I asked if Terrence Bradley also received a contract for Fulton County.
I believe that he did.
And you were partners with him at that time, correct?
I was.
So under what you testified to earlier, you would get a third of that contract as well, correct?
I would have.
And Chris Campbell also had a contract with Fulton County.
I believe he did.
And so under what you've testified to, you would also get a third of that, correct?
I would.
They both had contracts for what are called first appearance, which is where they would appear on behalf of the district attorney to do first appearance hearings, correct?
I believe they did.
Okay. And they also had what's called a taint contract. They both entered into them January 25th, 2021, correct?
Filter, yes, ma'am.
Taint or filter.
Yes, ma'am.
And that was for work in the anti-corruption unit?
I don't know that it was anti-corruption. I think that it was civil rights, maybe.
Okay. And Judge,
They need to name it something else, not anti-corruption.
the DAs or
Clearly.
Fulton counties come and
Take that
I got
off.
a certificate now, so we would move to admit the contracts. I've got those. Under that certificate, I was planning on doing it under the open records officer, but I believe now they've certified it. I just haven't looked at everything they've certified though, so.
I'm going to ask that the document be looked at and confirmed prior to its sender.
All right, Ms. Merchant, is there anything else? What other areas were you planning to cover on just direct other than these documents?
I'm planning on introducing all of the contracts and invoices, but I haven't had a chance to look at what Fulton County certified. So I'm planning on introducing those and then not much.
Can we do the not much? We'll do the not much and then we'll get back to the contracts.
Okay, yeah, definitely. Okay, so this taint contract, and we're not admitting these right now, but if I represent to you that they say anti-corruption unit, can you tell us what a taint attorney for an anti-corruption unit would do?
I didn't have a part in those contracts.
They were your partners at the time though, correct?
Oh, absolutely.
Okay, and so you didn't have a part in those contracts, but you got a third of the contract payment.
Oh, absolutely.
Okay, so the taint contracts that Bradley and Campbell, who are your law partners at the time, had for doing taint review, you got a third of those.
Yes, ma'am.
Okay.
Okay.
You signed a confidentiality agreement with the DA's office as well, correct?
I did.
And I think I'm up to Judge 13. Marking that as number 13. No. Yeah, approach Judge.
Yeah.
Showing you a copy of what I marked as number 13. If you could take a look at that and tell me if that is the confidentiality agreement that you signed with the district attorney. Okay. And this basically says you can't talk about anything that happens inside the DA's office, right?
No.
It doesn't say you can't talk about it?
No. You said it basically says that I can't talk about anything that happens inside the DA's office, and that's not what.
Are you tendering this exhibit?
I am, yes. We would tender 13.
Ms. Cross.
Fail to see the relevance, or lodge a relevance objection, but otherwise.
Ms. Merchant, relevance of this?
Judge, it's relevant to his testimony. If he signed an agreement that says he can't talk about things that happen in the district attorney's office, I think that's relevant to this. I also think
How?
that because it's motivation in his testimony. I mean, whether or not he's going to testify to something. It's also been certified. I mean, it's part of the record as from what Fulton County gave us.
Sure, but he hasn't said that that's preventing him from testifying in any way today, is it?
Go on, then I can ask him about that.
Yeah. Mr. Wade, is this confidential agreement affecting your testimony today?
No, sir.
Okay, all right, that's fine. Let's see. The contracts judge and the invoices that I wanted to admit all of his invoices and contracts with Fulton County. I have them certified. I guess I have them certified through Fulton County, so I wasn't sure if I needed to do that. I just wanted to know if the state had an objection to those before.
Well, they've had a chance to look at them. So that's the sole remaining exhibit in line of questioning here?
Yes.
And in terms of the follow-up questions, would it just be for him to say what's reflected in these documents themselves?
If they have an objection to the certificates that Fulton County has given, I would admit them through him because he could recognize them.
But assuming they're admitted, would there actually be anything substantive he would add other than the documents themselves? No. All right. Okay, so subject to that qualification, do you have any other questions of this witness?
May I just have a moment?
Sure.
Thank you. Is it possible actually we take a quick break?
We're getting there.
Okay. Thank you.
certainly have the opportunity over lunch to take a look at these documents and work out whatever we could.
Did you discuss your relationship with Miss Willis in social settings?
Help me understand your question.
Did you discuss your relationship with Miss Willis in social settings?
No, I heard the question. I just need to understand what you're asking me.
Oh, you need to think of an answer.
Like,
So how'd you hear the question, but you can't answer?
what relationship when
Your personal relationship with Miss Willis, unqualified, I'm sorry. Did you discuss your personal relationship, your private, personal, romantic relationship with Miss Willis in social settings?
No, ma'am.
You've never discussed it in social settings?
No, ma'am.
Did you ever discuss it in front of Robin Yeartie in a non-social setting?
No, ma'am. Miss Willis is a very, as am I, we're private people. Not, our relationship wasn't a secret. It was just private. So, not at all. I wouldn't have discussed my relationship with Miss Yeartie or anyone else publicly.
I mean, why would he discuss it publicly, especially if they weren't supposed to be fraternizing with, other prosecutors, attorneys, whatever?
I actually did have some questions just about the invoices. If we want to just.
These are the documents that you're referring to.
Yeah, they are. It's all of his invoices. I mean,
what kind of questions would these be other than the invoices say what they say?
it's just that, yes, that they say what they say.
All right.
Just talk about it. That's fine. No.
All right.
Thank you.
All right. At this point, we'll take a break. I'll ask the parties to take a look at.
As exhibit number 14 contains several items
All right, this is back from break. I'll be right back, y'all.
that did not come apparently from Fulton County, and I'm standing next to Ms. Merchant to show them that they're not in that group of.
I don't know. The county attorney has no idea what to do.
Right, that's what I'm saying, Mac, because it was like he wanted, like they didn't want to be seen around people that would know, that who they were.
I got
This is very weird. I'll be right back.
I can't agree that the documents that are not in the certified bundle are properly admitted as part of the exhibit.
Okay, Ms. Merchant, would you like to repackage and present to Ms. Cross Defense Exhibit 14?
They're exactly what I got from the county attorney. Apparently they didn't want to testify, so they gave us a certification but didn't put these in, so they're gonna have to testify. I got them from them.
The documents the difference between the two document productions, what is the difference?
They read these bank records, credit card statements, things like that, that would ordinarily be part and course of the Fulton County records.
But I got them from the open records portal, so that's where I found them.
No, I understand.
Yeah.
But the difference in production, Ms. Merchant, you've taken a look at them and they're actually material to your case?
Yes.
In what way?
They're all of his invoices, Judge, and then he has this is what I got from them. It's all of his invoices, and one of the invoices a reimbursement that he printed some things, but for the reimbursement. I mean, I don't really care if they take the reimbursement out because they actually are already admitted in the other exhibit I did.
I don't have any problem with the invoices. The invoices are clearly the records and contained in the certification. So if we remove the items that are in dispute, then I don't have an objection to that.
They're already in exhibit.
So you're removing them?
Yeah, that's fine. You want to take them out?
All right. So again, let's have opposing counsel look at a revised Exhibit 14, and then I'll hear whether there's any objection.
The revised exhibit number 14 contains only the invoices that were submitted, and the state has no objection.
All right, then, not seeing any other issues from other counsel, we'll note Exhibits 14 through 18 have been admitted for the record without objection. I think at this point, it'd be good to make sure we've got, I think, 1 through 18 with the court reporter.
Others, but do you want me to give them to the witness?
Let's, if he's done looking at them, let's just get them all compiled and organized and with the court reporter in case other defense counsel are going to reference them. No, it wasn't for him to have them all. We just need to have 1 through 18 organized with the court reporter. Yeah.
So you want me to take all the exhibits back from him?
I think we ought to do that.
Yeah, thank you.
Yeah.
That's not.
This is.
Okay. I'll organize it.
All right, as Ms. Merchant is doing that, let me go down the list. Mr. Sadow.
Your Honor, if the court will permit, Mr. Gillen has been asked some questions that I was going to ask. I'd like to be able to just follow up if there's anything you can touch on. That'll work.
Let me just, to keep it consistent, I'll go in order. So if Mr. Sadow is deferring, then I'll go to Mr. Stocks.
I'll defer to
Mr. Durham on Zoom.
No, Your Honor.
All right, Mr. McDougall.
I will defer to Mr. Gill.
All right, Mr. Rice. All right, thank you, Mr. Gillen.
Thank you, Your Honor. Good afternoon, Mr. Wade.
Good afternoon, sir.
A few follow-up questions. I'd like to start off with the exhibit number 4 that you should have up there. Those are the interrogatories.
No, sir.
They're not up there.
Remember, I asked her to compile them all. So now you can grab them.
Right here, I'm gonna give it to you. If you wanted me to come over.
Yes, sir.
Okay. Now, these are the interrogatories that you had filed on May the 30th, 2023 in your divorce case, correct?
Yes, sir.
Now, you went over in part some of those interrogatories, but what I want you to do, because I want to get down to the specific language to clear up exactly what the interrogatories asked for and exactly what you answered, okay?
Yes, sir.
Now, if we look on the interrogatory that I believe, as we indicated, they're really, I think, on page 2, the one that starts off, describe each instance in which you've had sexual relations. You see that one?
Yes, sir.
Right. Now, that interrogatory begins, describe each instance in which you have had sexual relations with a person other than your spouse during the course of the marriage, including the period of separation. You see that?
Yes, sir.
Now, these were filed on May the 30th, 2023, correct?
Yes, sir.
Now, at that time, you had had sexual relations with Miss Willis, correct?
Well,
Your Honor, I'm going to object to the question as phrased. I think the question is properly at that time certainly asked about his answer, but I object to.
All right, Mr. Gillen, I just asked you to rephrase, but I think you can make the same point.
Well, Your Honor, it's a specific interrogatory, and I would, so the words do matter. And I would like him to answer whether or not he'd had sexual relations with Miss Willis, because if he answered yes, then this interrogatory is a false interrogatory. So I would ask the court's indulgence. I'm not here to jump into some salacious bedroom situation, but this is an interrogatory that matters. So I would ask the court's indulgence.
Ms. Cross?
These questions have been asked and answered several times. I understand Mr. Gillen is coming at it from a different way, but this question is not substantively different than those that have already been asked and answered in the information that he is seeking.
All right, Mr. Gillen, I'll allow maybe this question one more, but I think you are asking it in a different way, and I'll ask you to stick to the point.
Right. Now, as of May the 30th, and may I answer the question that okay, thank you, Your Honor. As of May the 30th, 2023, you had had sexual relations with Miss Willis. Isn't that correct?
The interrogatory, sir, asks during the course of the marriage and the period of separation.
Excuse me. Your Honor, I would ask the court to direct the witness to answer my question, yes or no. As of May the 30th, 2023, had you had sexual relations with Miss Willis? Yes or no?
Mr. Gillen, let's start with at the higher level whether he believes he answered it truthfully, and then we can drill down into why or why not he doesn't, and maybe we'll end up exactly where you left us.
Well, but again, Your Honor, the point of it is that the words matter, and that we have to establish what did and did not happen, and then he can give whatever explanation he chooses to what apparently is a false answer. But I would like an answer to my question.
And you may get one. I just would ask, I would like us to start at the high level before we drill down into specifics to see whether he actually contradicted that interrogatory, if I'm making sense.
Well, the interrogatory is relatively direct and explicit. Sexual relationships with a person other than your spouse during the course of the marriage, including the period of separation. That's pretty simple.
Sure. Let's see if that's something you can get him to admit.
You did have sexual relationships with someone other than your spouse during the course of the marriage and during the period of separation, which included up to May the 30th of 2023. Isn't that correct, sir?
My answer to this interrogatory is none. Is no.
So you're saying that you did not have sexual relationships with anyone outside of your marriage, and the period of separation is during the period, then you're answering the question to this interrogatory, correct, sir?
I'm saying during the course of my marriage, I did not have sexual relations to anyone, and this answer's no.
Well, again, Your Honor,
you can proceed, Mr.
We need a yes or no. Let's just get down to it. Did you or did you not, by May the 30th, 2023, have had sexual relations with Miss Willis, yes or no? Yes or no?
Yes.
Okay. Now, what you did is you answered no to that question, didn't you, or none, correct?
I didn't answer no to the question you just asked. I answered no to the interrogatory question.
And the interrogatory stands that you answered as a pleading in a civil proceeding, your divorce case, right?
Yes.
Now, excuse me. The next interrogatory, let's move there. That interrogatory states as follows: identify any and all occasions in which you entertain a member of the opposite sex other than your spouse who is not related to you by blood or marriage. You see that? Now, there are two parts to this. The second part is, I read on, or in which a member of the opposite sex, other than your spouse, not related to you by blood or marriage, entertain you. And then it goes on to say, including but not limited to dining, drinking, in restaurants, bars, pubs, hotels. You see that, correct?
I do.
Now, as of May the 30th, 2023, when you filed this interrogatory, you had in fact entertained Ms. Willis on many occasions, had you not?
Again, during the course of the marriage was irretrievably broken in 2015. Well, the answer's still no.
Let's read what the interrogatory
answer would still be yes, regardless if it, could not be, fixed or whatever.
Interrogatory says about the time period required to answer the.
Hold on. Come on, motherfucker. It's not my internet. Let's see, we're at 120. Come on, motherfucker.
Interrogatory, because what it says is, it goes on to say, including but not limited to dining and or drinking at any restaurants, bars, pubs, hotels, or persons' homes from the date of marriage to the present. You understand what the word present means?
I do.
And present means the filing on May the 30th, 2023. Isn't that right?
It is.
So as of May the 30th, 2023, you had done a lot of entertaining of Ms. Willis, had you not?
I had done some, yes.
And in fact, under your testimony, you would have said that she had also entertained you. Isn't that correct?
Yes.
And so your answer to this interrogatory is false, is it not, sir?
No, it's not false.
Well, hate to dance around The answer is yes, you did entertain Ms. Willis, correct? Right?
Yes,
She's not your spouse at that time or any time, correct?
that's correct.
She's not related to you by blood or marriage, correct?
That's correct.
But you entertained her, right?
Yes,
And during the course from your marriage, the period of time up to the present, so the answer would have been, yes, I did entertain somebody, correct?
during the course of the marriage, no.
Mr. Wade.
I think he's saying that because he got a divorce in 2021.
Mr. Gillen, I think we've made your point. I think it speaks for itself. And
He's still doing that wordplay, you know?
I'll just follow up with one quick question. You understand what the word present means?
Your Honor, that's what I asked him.
I think we did cover that already as well.
Okay. Now, what has happened from the time that you filed this court document in May of 2023, let's go over some of the things that you had been involved in terms of being entertained or entertaining. Prior to your filing on the answer on the interrogatories on May the 30th, 2023, we've already established, have we not, that you had paid for a Royal Caribbean cruise to the Bahamas with Miss Willis, correct?
Yes, sir, with Miss Willis and my mother.
Max and Mac.
Well, your mother's not part of this interrogatory. I'm talking about Miss Willis, okay? So you paid and caused to be paid approximately $3,335 on that trip, Bahamas trip from October the 28th through October the 31st, correct?
Your Honor, objection. I think we've said this ground several times already.
Mr. Gillen, let's cover new ground.
Well, I'm just trying to establish with specificity the things that he had done to entertain or be entertained prior to May the 30th, 2023. I'll try to move through it.
Sure. Well, that's already part of the record in terms of his prior testimony. And so if you want to link those two things together, you can do that during argument.
Well, so let me discuss this. You indicated that during the course of your explanation concerning the Belize trip, that Ms. Willis paid you all that money back in cash, remember?
Yes, sir.
Now, the Belize trip had just happened, hadn't it? That occurred in March of 18th, 2023, right?
Yes, sir.
So you're filing this maybe 2 months after you have gone to Belize with Ms. Willis, correct?
Your Honor, again, I believe all of this is our.
I think you might be getting somewhere new. We'll see.
All right.
Yes, sir.
So we've got the trip in to Belize on March the 18th, 2023. You and Ms. Willis, correct?
Yes, sir.
Now, 2 months later, you file the interrogatories that speak for themselves that we've gone over a few minutes ago, correct?
Yes, sir.
Now, the March the 18th, 2023, to state the obvious, is before May the 30th, 2023. Will you agree with me on that?
I do.
Okay. So then you tell us that Miss Willis paid you in cash all the money for the entire trip. It was a gift for you for your birthday, correct?
Yes, sir.
And I'm sure you probably have the deposit slips where you took the cash and deposited the cash into your account, don't you?
I did not deposit the cash in my account.
You don't have a single solitary deposit slip to corroborate or support any of your allegations that you were paid by Mrs. Willis in cash, do you?
No, sir.
Not a single solitary one.
Not a one.
Now, when Miss Willis would pay you in cash, would you scamper down to the ATM with her and as she drew money out of her account
Your
to
Honor.
pay you these thousands of dollars?
Mr. Gillen likes scamper, but there's been no evidence that Mr. Wade does. I object to the phrasing, the argumentative nature.
Oh, she objected to the word scamper.
On that issue, overruled.
Did you in this way scamper down to the ATM machine and have her draw out? For example, on the Belize trip, just on your payment would have been $2,794.
Miss Wade.
For clarity, yeah, thank you.
Pardon me?
Miss Wade and I didn't go to Belize.
No, excuse me, Miss Willis. I'm sorry. Did You go down to.
Yeah, so he didn't even take his wife to Belize. Where did he take his wife? Because it seems like his travel partner in more was, Fani.
The ATM with Miss Willis while she drew out
His
2,000.
wife probably watching this, like, all I got to do was go to Wyoming. I don't know.
$794 to pay you in cash.
Get that on bags.
Did you go to the ATM with her?
No, sir. She didn't go to the ATM. She carried the cash.
Oh, and so she would give you the cash.
So wait a minute. Fani is worrying about people seeing her at the airport, yet she carries thousands of dollars on her. Make that make sense.
Did you have a little place in your house where you just stack up all this cash that you apparently got to repay you for these benefits that you bestowed on her?
And Mr. Gillen, if I answered that, I'm putting myself in jeopardy. If I tell the world that I have cash someplace in my home, don't you think that could be problematic?
No, I don't. I want an answer as to whether or not you have a little cash work in your house where you have allegedly taken the money that you got from Mrs. Willis and went and put it somewhere. Where'd you put it?
No, sir.
Now, just put it on the hip and kind of walk around money?
Did I put it on my hip?
Yeah, just walking around money where you would spend cash yourself?
Let me finish. Did I put it on my hip in Belize and walk around with it?
When you got paid back, would you take the money, the cash that she gave you, and would you just carry it around with you for spending money around town?
So we have to break down each trip because, for example, for the cruise, she paid me the money before we took the cruise. So I was here and I could put the money in my pocket or put it away wherever I wanted to do with it. Other trips, she would give me the money there. So at that point, I could either spend it or put it in my pocket or put it in the hotel center.
There's no special place that you would have all this cash that you would be getting from her that you've told us about to pay back for the benefits that you have bestowed on her?
The only special place that cash would have gone would have been to one of my children.
Okay. Now,
right, they acting like it was a few thousand or whatever.
Are you aware? Have you discussed these pleadings with Miss Willis?
No, sir.
So there's been no discussion between you and Miss Willis about the allegation concerning the benefits that you have bestowed on her. Is that correct?
I've been phrasing the benefits bestowed upon her. I don't believe that's an accurate reflection of the testimony, and I don't think that's an appropriate question.
I think overruled. You can answer the question.
Okay. When you said proceedings, are you talking about the divorce proceedings? Because we were talking about the interrogatories. To that question, the answer is no. If you're go ahead.
I'm sorry. Go ahead with your answer. I'll hear the complete answer, then I'll follow up.
Okay. If you're asking me about this hearing, the proceedings of this hearing, have we discussed the financial piece based upon Mr. Roman's motion? Yes.
So you have discussed the financial piece. Where did that discussion take place?
Conference room.
Were you other people there, or were you and Ms. Willis discussing this about what your position was going to be?
The relevance of this.
Well,
Mr. Gillen?
and the relevance has to do with suddenly we have a declaration from Mr. Wade in this case where he says roughly equal and then shows one alleged payment by Ms. Willis. No mention of cash, none. So I need to find out a little bit more about how suddenly we have this revelation about cash from the witness stand today.
Overruled.
So we part company there when you say no mention of cash. If I provided one receipt that didn't amount to what you would think was roughly equal, the rest of it is cash.
Well, did you in your declaration, sir, that was filed in this case, did you tell the court in that declaration that the expenditure that you...
I don't know why they zoomed into this person because this ain't his wife or his ex-wife.
had provided on behalf
That
of
don't even look like Fani.
Ms. Willis was paid for back by her in cash, yes or no?
I believe that I did when I said that the expenses were split roughly evenly.
If you could point to me any place in your affidavit where you use the word cash, I would appreciate it. Take your time.
I didn't use the word cash. No, sir.
No, you didn't use the word cash, did you?
But I didn't say that she didn't give it to me in cash.
No, you just didn't tell anybody that you allegedly got paid back in cash, right?
No, I told everyone who asked.
Today.
Yes, sir.
Now, who else was with you, if anyone else, when you and Ms. Willis were discussing how you would be handling the financial component of the motion here today, that is the personal benefits?
I would object to the relevance of that, Your Honor.
Mr. Gill.
Well, the relevance is if they know that they're going to be called as witnesses, they've been subpoenaed, and they are discussing what they're going to say, we need to know that. The court needs to know that. It goes to the veracity of Mr. Willis and, Ms. Willis and Mr. Wade.
We didn't discuss how we were going to handle testimony.
My question was, when you were discussing with Ms. Willis in the conference room, when you were discussing what you perceived to be the situation concerning the benefits for the payments.
Yes, sir.
Was there anyone else present?
No, sir.
How long did the meeting take?
Probably 5 or 10 minutes.
Did Ms. Willis tell you what she was going to say?
No, sir.
Did you ask her whether she had any bank withdrawals that would corroborate the assertion that she would pay you back in large sums of cash for these trips to the Caribbean, Belize, California, on and on and on?
Your Honor, again, I object. The proffer when the last relevant suggestion was made was that Mr. Dillon needed to know who else was there. These could be potential witnesses that he could cross-examine. That question has been answered, so I can't object.
Okay. I think it's still exploring possible bias or motive to shape his testimony, so overrule on that ground.
Thank you. Now, Mr. Willis, Mr. Wade, when you were having this discussion, did you ask Ms. Willis, do you have anything to support these cash withdrawals?
No, sir.
Did you ask her where she got the cash?
This is the conversation. I produced my credit card statement that showed what Ms. Merchant in her filing was representing. That was the conversation.
Okay. So when she would pay you back in cash, were you aware of what her financial situation was? Do you know what?
No, sir.
Your Honor, I object to the relevance.
Well, Your Honor, it's relevant because we've been bombarded with a book, Find Me the Votes, in which...
What's at issue is the financial benefit, and if that plays a material interest in an actual conflict of interest. So I think that's relevant.
Thank you. Now, have you read the book, Find Me the Votes?
I have.
You have?
I have.
Okay. Now, in that book, Ms. Willis is telling the authors about how financially destitute she was, or kind of hitting down on the bottom as she was running for DA. Do you remember that part of the book?
So let me qualify the response. I've read the book in parts. I hadn't had the time to sit and read the book in its entirety.
Did you read that part about how she's telling the authors about how little money she had and how financially she was in bad shape prior to when she was running? Did you read that part?
No, sir.
Did you ever have discussions with Ms. Willis about her financial situation, which was in apparently in rough shape prior to her being elected DA?
No, sir. Ms. Willis made it clear that her financial business was just that. It was her business. I know nothing about her financial status. I know nothing about how she was faring before or after the election, or even now. I know nothing about her finances.
You're telling us that she didn't share that with you, but chose to share it with the authors of a book that's been published and printed and sold nationally.
I think that's a fair question for Cross.
I don't know that she shared it with the author. I don't know that the author was telling the truth. I don't know the author, so I don't know, sir.
Okay. Now, did you give an interview to the authors of that book?
I've given no interview, sir.
So you haven't talked to them at all?
I haven't talked to any media.
All right.
No.
Now, as it relates to
I'd like to, though.
As it relates to,
Was that a hint that he's gonna start doing interviews?
again, from your bank records that you're aware of, there'll be no cash deposits, right?
I didn't say that.
Are there cash deposits which line up with the money that you have allegedly received from Ms. Willis to quote, pay you back for her part of the trips?
So here's the thing. In my bank records, you will see cash deposits. You will see check deposits. I can't say that you look through the bank records and you won't see cash deposits because I have two sources of income, sir. Income comes from my private practice, my firm, and income comes from the contract here with Fulton County. During the course of private practice, occasionally I will have occasion to deposit cash into my account.
And in preparation for this hearing and your testimony, did you go through your bank records to find out if you could locate any cash deposits that would corroborate your testimony?
No, sir, I didn't go through my bank records at all.
Now, so what you would do, the money that you received, of course, the money that you received from your work for Fulton County, that's public funds, correct?
No, sir, it's private funds. It's my
Public funds pay you to do work for Fulton County, correct?
Yes.
Tell me what the definition of a public fund is.
A public fund would be your funds, as in not fund, but funds, money. Public money, as in money from taxpayers, either in Fulton County or the state of Georgia, pay you to do the work that you're doing here in this case, yes or no?
One or the other, I'm certain.
Do you know which one?
The case. I don't know which one, no, sir.
Now, you would take those public funds, and those public funds were then used, deposited in your account, and they were then used to pay on the credit cards for the trips that you would take with Ms. Willis, correct?
I object to the question insofar as the characterization of public funds. The witness didn't testify to that, and I don't believe there's been any evidence to that. Once it's paid to Mr. Wade, it's private funds.
The point of it is that you got money.
Mr. Gillen's rephrasing.
Yeah, let's break it down. You got money from Fulton County for the work that you do here, right?
Yes, sir.
You would send in invoices, and they would pay you money, correct?
Yes, sir.
Those money, that private money, that money was money from either the citizens of Fulton County or from the state of Georgia, correct? That's what I mean by public funds. Agreed?
So I guess I'm having trouble with the notion that the citizens of Fulton County have paid me any funds. I'm not certain the funding source. I can tell you that either the state of Georgia or Fulton County has written me a check.
So that would be, those two entities are public entities, correct?
Yes.
So that would be public funds, right? Right? Yeah.
Yes.
And those public funds are from the same source that you would then use to pay out on your expenses for the trips that you took Ms. Willis on, correct?
No, sir. As I testified to moments ago, I have income coming in from my law firm. I also have income coming in from the funds that we're here discussing now from either the state of Georgia or Fulton County and or both. I'm not certain what it is. So to say,
sorry, I didn't mean to cut you off. Go ahead.
So to say that I'm paying a credit card statement with funds coming from Fulton County or the state of Georgia would not be an accurate statement because the funds could have very well come from my private practice.
What percentage of your income in 2022 came from money where you're working on this case or from your partners working for the Fulton County office?
In 2022, I would say 50-50.
You think 50-50 in 2022?
Yes, sir.
What about 2023?
Probably 60-40.
60-40.
Yes, sir.
So the money that would be in those accounts, at least 60% of those, in your view, would be public funds, that those monies were then used to pay for the expenses that you had incurred for the trips that you took Miss Willis on, the cruises, the Napa Valleys, the Bahamas, correct? Right?
Yes, sir.
Okay. And now, what you did is that when you signed on in November 1st of 2021, that's when you signed on to be counsel for the anti-corruption matters, right?
Yes, sir.
Now, as you know, in your engagement letter, it doesn't say that you're signing on and your scope of work is to work on the Trump special grand jury investigation, does it?
No, sir.
It says that you're signing on to work on anti-corruption, the anti-corruption unit matters, correct?
Yes, sir.
Matters with a plural, correct?
Yes, sir.
So in your contract, there is no specific reference to any specific case. Isn't that right?
That's correct.
Okay. Now, but you didn't sign on for the duration. There was a period, you have a contract, and then it would then expire, and then you would have a new contract, correct?
Yes, sir.
Now, of course, the extension that you received, the first one was in November of 2021, and then you filed, or excuse me, there was a renewal in November the 15th of 2022. Is that right?
Sounds right.
Oh, okay. Now, that was right after you got re-upped by Miss Willis, right after you took Miss Willis to Aruba. Isn't that right? On that November the 1st, 2022 trip to Aruba and through November the 4th, 2022, correct?
What does re-up mean?
Well, re-up means that you came back, your contract was up, and then on November the 15th, you and Miss Willis signed a new contract for you, right?
Yes, sir.
Okay. Now, when you were in taking her to the Aruba and on the cruises and the resort there, did you discuss your re-upping of signing an extension on your contract?
No, sir.
I'm not sure. I know what re-upping means to me. I don't know what it means to them.
But you make an excellent point. I'm glad you pointed that out. So the trip to Aruba, the contract was not in existence then.
So you're saying that you were not
under contract.
In your contract, did you send any invoices in for work that you did after your first contract expired?
No, sir.
You didn't?
No, sir.
So when that expired, that was it. So and then you're saying that after the Aruba trip, you get re-upped with a new contract, correct?
I signed a new contract. Yes,
Now,
sir.
was there any
Means like it sounds like they're saying like update as far as the word re-up.
modifications on that contract? Did you get an extension on the cap that you were limited on the first one? Were there any modifications at all, Mr. Willis? Excuse me. I've done that again. I apologize.
I've been called
Mr. Wade,
worse.
I'm sorry.
I've been called worse.
Now, were there any modifications on that?
Do you have the contract in front of you where you could?
I don't have it in front of me, but I think that
because I believe as the work gradually, as the time of the work gradually increased, the hourly cap would increase. In other words, starting out the investigation, it was impossible to anticipate the level cooperation during the course of the investigation from some of the witnesses. So if you assume that there would be great cooperation with the witnesses in terms of interviewing and speaking and being voluntarily speaking with you, it doesn't take as much time. So after getting into it, realizing that most of the witnesses were not willing to speak or willing to turn over evidence or information, quickly you figure out that this is going to take a little more time than originally anticipated. And because of that, you have to compensate for those hours.
And that's why there was a compensation on your extension?
Yes, the caps.
A cap. Now, did Mrs. Willis, did Ms. Willis review your invoices with you when you would submit them?
Never.
Did anyone ever question whether or not you worked 24 hours in one day and billed 24 hours in one day?
I've never worked 24 hours in one day and billed 24 hours in one day.
Okay.
And I'm glad you asked me that question because I'd like the opportunity to talk about that.
I think you should go ahead.
So if you look at that invoice where it says 24 hours in one day, it actually doesn't say one day. If you look at the top of the invoice, it says date completed. The date that's reflected on that invoice reflects the date that the work was completed. It doesn't say when it started. It just says this is the date that is completed. So if you go through the invoices, probably around the first 5 or 6, you'll see that that's the billing format. I would bill only after.
Why would you put the date completed but not the date started? That doesn't even make sense.
That particular task has been completed. That's why you see a 24-hour period with the 1 day there. I kind of wish some of the experts who had opined on that had called me and asked me the question, but there was never a billing of 24 hours in 1 day. Now, probably around the 6th or 7th invoice, you see the format changed. I started using a range so that it got less confusing, right?
I'm confused, so maybe you can correct it.
Okay.
In Exhibit 14, you've got down a specific day.
Mm-hmm.
Prepared cases for pretrial. November the 5th, 2021, 24 hours at $250 an hour, 6,000. Now, this wasn't about a range. It was about the work that you did on November the 5th, 2021.
No, Mr. Gillen, look at the top of the invoice where it says date completed.
Yeah, what I want you to do, Mr. Wade, is focus on the date that you have down there and tell the court what you billed for on November the 5th, 2021.
Are we gonna?
I thought it was already in. I thought 14 is in.
Again, Mr. Gillen, it says completed date completed. The dates that you see here are the dates that work was completed. So on November the 5th, I completed the task of preparing the cases for pretrial. That's the date I completed it.
Just read, if you would. Then my question was, read out loud the entry for November the 5th, 2021, and how many hours you billed that day. Just do that for me, if you would.
I can't do that.
Excuse me, I believe the witness is entitled to answer his question. That certainly wasn't the question that Mr. Gillen asked.
All right, well, the question now is to read a certain entry. So
I just read into the record, Mr. Wade, on November the 5th, 2021, how many hours did you bill the citizens of Fulton County for on that day? Just read it out, please.
I completed the task on November 5th, 2021. 24 hours was billed at $250.
So now I understand why he's like, it doesn't matter when he started it allegedly, because it took him 24 hours and then he put the date that it ends. But it seems like already with how he was doing his billing process, at least somebody was confused, because he then later on went on to correct it, like do it a different way that was less confusing. Right.
Now,
And he always goes the long about way explaining shit.
when you talked about your relationship with Miss Willis, and your testimony is that it began in 2022. You remember that testimony?
No, sir. Our relationship began
Your romantic
2019.
relationship began in 2022?
Yes, sir.
That's your testimony?
Yes, sir.
Okay, now, when you were re-upped on this contract, you had a romantic relationship already established with Miss Willis, yes or no?
In 2022?
You know, when
Yes,
you were re-upped on November the 15th, 2022, you had a romantic relationship with Miss Willis.
I signed the second contract. Yes, sir.
Answer my question, please.
I'm not going to use the word
When you
re-up.
signed up on the, we re-up or whatever you want to call it, your contract on November the 15th, 2022, you had a romantic relationship already existing with Miss Willis, yes or no?
I signed the contract, the second contract. Yes, sir. During the course of a romantic relationship.
Yes
Why is he acting like he don't know what this man is asking him?
or no, you had a romantic relationship with her at the time that you signed up the extension on November the 15th, 2022, yes or no?
The answer to that question is yes.
Thank you. Now, this was before the special purpose grand jury released a report. Isn't that correct? Correct?
Are you asking me if it's before the work was completed or before the special purpose grand jury actually publicly released the report?
When they
Those are
released
two
the
different-
report. The relationship with Miss Willis already existed when the special purpose grand jury released its report, correct?
At the time the report was released, yes, sir. But you understand that the report had, the work had been completed prior to the release of the report. You understand that?
And your relationship with Miss Willis, of course, was prior to the indictment in this case, correct?
Yes, sir.
Your Honor, if I may just ask my folks over here whether there's anything I need to clean up on. That's all the questions, Your Honor, I have. Thank you.
Your Honor, I do have questions.
Well, Mr. State, I think we went through.
No, I had asked you for permission, that he was going to go first on this, and then I was going to follow up. That's the deferment, was to allow him to go first. That's what I thought I had asked for.
All right, all right, with the understanding next time, we're going to keep going in order and not skip around the order. All right.
But that's why I brought it up, because I thought that's what.
Okay. All right, Mr. Sato.
Not this.
I'm going to try to keep my questions very specific.
Yes, sir.
Okay?
Yes, sir.
And I'm going to also, of course, try not to go back into specific questions that have already been asked. Okay?
Yes, sir.
When did your relationship with Miss Willis end?
2023.
Can you give us an approximation of, not by date, but by month?
Summer 2023. Forgive me. I'm a man. We don't do the date thing. Summer 23, I would say June, maybe.
Okay. Using the euphemism personal relationship, did you have any personal relationship at all with Miss Willis after the summer?
That's what I'm thinking too. Yeah. Because why wouldn't he have to submit his invoices to somebody?
of 2023.
And she was his boss, so
I want to make sure that I'm answering your question. Are you, because
let me rephrase if I might. The way it has been characterized in, for example,
like they was money laundering or something.
The response of the state, and I believe in your affidavit, is there's a difference between a personal relationship and a professional relationship, correct?
Yes, sir.
Okay. I'm not talking about a professional relationship. I'm talking about a personal relationship. Have you had a personal relationship at all? And you know what I mean by that, after the summer of 2023.
Are you asking me if I had intercourse with the district attorney?
I was trying not to, but I guess if you're going to characterize it as that, the answer would be
no.
So it's been purely professional since the summer of 2023.
So that's where we're having issues.
Okay, you'll have to explain because I don't know what the issue would be.
No, I will explain to you. You said
this dude is like the king of bullshit.
Personal. We're very good friends, probably closer than ever because of these attacks. But if you're asking me about specific intercourse, the answer is no.
How about if I change it from intercourse to romantic?
No.
Okay. During the direct examination, you made a statement, at least I believe I heard it correctly, that you, personal relationship, and now I'm talking about that characterized the sexual romantic relationship, was not a secret. Is that correct?
Wait. If you're asking me if people knew that we were having sex, no, they didn't.
I'm asking you whether the people knew that you were dating, whether you were romantically involved. You said that it was not a secret.
Oh, it wasn't a secret. It was just private. My mother knew, obviously.
Okay. Did anyone in the district attorney's office that has worked on this case know that you were dating or had a romantic relationship with District Attorney Willis?
I don't know.
Proof that he took Fani on that cruise to meet his mother.
What they knew?
Well, did you tell anyone?
No.
Do you have any knowledge of whether Miss Willis revealed it to anyone?
I have no clue.
Okay. So as far as you know from personal knowledge, no one in the DA's team knew, correct?
That's correct.
Okay. So if it was a legitimate relationship, is there any particular reason why it was kept secret or private?
It wasn't kept secret. It was kept private.
And the purpose for that was?
It's what we chose to do.
I'm asking you why then, not just because you chose. Why, if you're dating someone, why keep it private?
So, a few reasons. The first one is, and I want to say this respectfully in the right way, there are some people who are in the public eye who just don't like it, don't wish to be there. I have tried to have lunch or dinner with her publicly, and I can't count the number of people that would approach the table or would accost us as we're trying to walk into a restaurant and just have lunch or have a meal. It is not secret, it is private. We don't want the world asking questions or interrupting that time. So we weren't trying to keep anything a secret, Mr. Seda. There's nothing secret or salacious about having a private life. Nothing.
Okay. I'm not suggesting that there was. I'm asking the questions. When you went on the various trips that have been outlined by both Mr. Gillen and by Ms. Merchant.
This is crazy as hell.
Did anyone in the district attorney's office know that the two of you were traveling on personal trips together?
To my knowledge, Mr. Seda, no.
And again,
I mean, they didn't wonder. I mean, maybe they left on the weekend and came back, on a Monday or something like that, went to work. But if they went during the work week, I'm just saying, what would be the chances that both of them would be, on vacation, just always at the same time? And another thing, He's sitting up here acting like nobody in the office knew and shit. Bro, there's always telltale signs that people in the office are screwing.
That was for privacy, according to your testimony.
Privacy, yes, sir.
Okay. Did you and Miss Willis go to the Hapeville condo
Right, they was creeping.
prior to your relationship starting beginning of 2022?
Prior to having physical contact, prior to having intercourse, did we go to the Hapeville condo?
Again, you keep going to intercourse. I'm trying not to, but fine. The answer to that, my question would be yes. Did you and Miss Willis go to the Hapeville condo prior to what I want to say November 1st of 2021?
Yes.
Okay, and the purpose for going to the Hapeville condo with Miss Willis prior to 2021 would have been what? Or prior to November 1 of 2021?
Could have been any number of things, because at that time.
That's what I'm asking, so tell me.
So he's already admitted that they're in a sexual relationship, that they went on cruises. So why he just can't say that he went to the condo and knocked her boots? Like, why he just can't be real?
Yeah, could have been any number of things, because at that time, she had a friend living in that condo. Miss Yeartie lived in that condo.
Okay. Maybe it was my question was poorly worded. Let me try again. Your answer is yes, prior to November 1st of 2021, you would have gone to the Hapeville condo and been there with Miss Willis, correct?
Yes.
And you would have been there, as you indicated, for many reasons, right?
Yes.
Can you give me, just list a few of the reasons?
Miss Yeartie resided there, went to visit her, maybe went to talk about a document that I received.
Miss Yeartie already stated that she didn't live there when Fani was there.
You would go to the condo to talk about a document that you received?
Absolutely.
Okay, go ahead.
Absolutely.
Any other reasons?
None come to mind.
None come to mind?
No, sir.
And would you say that was frequent? When I say frequent, do you think prior to November 1st of 2021, you were at the condo more than 10 times?
No, sir.
So it'd be less than 10 times?
Yes, sir.
So if phone records were to reflect that you were making phone calls from the same location as the condo before November 1st of 2021, and it was on multiple occasions, the phone records would be wrong?
If phone records reflected that, yes, sir.
They'd be wrong?
They'd be wrong.
Okay. Where did you live during that time period?
The same place I live now.
Which is not in Hapeville, correct?
It is not in Hapeville.
It is north of Atlanta, the city of Atlanta, correct?
It is.
Okay. So, and any other reasons why you would be in the Hapeville area on multiple occasions prior to November 1st of 2021?
They done pinged his whereabouts.
Let's see. The Porsche Experience is there.
I'm sorry?
The Porsche Experience is there.
Okay, so that would have been one. Any other reason?
Yes, sir. The airport is there.
Airport in Hapeville.
Yes, sir. Delta Airlines is
okay.
Headquartered there. Let's see. Restaurants there.
Okay. If that's your recollection, that's fine. I'm not asking you to try to remember everything, but if
Good point right there. And Max said, if it was business, why didn't she come to his home?
Okay.
Yes.
Did you discuss your affidavit filed in connection with the response with Ms. Willis?
No, sir.
Did you know, personal knowledge, whether Ms. Willis reviewed your affidavit before it was included with the response?
I have no clue.
So as far as you know, personal knowledge, Ms. Willis did not know what you said in the affidavit.
I didn't give it to her.
That's what I said. You have no personal knowledge.
No personal knowledge.
And as far as you know, no one else has told you that she did or didn't.
I hadn't asked anyone.
We've kind of worked this up a little bit, and the numbers could be off. But according to our numbers, $10,000, give or take, would have been reflected on your credit card statements in connection with things of potential benefit to Ms. Willis, okay? I want you just to assume that. Assuming that there was $10,000 that you had on your credit cards, is it your testimony that Ms. Willis paid you back $10,000 in cash? I'm not acting about.
I object that the characterization of $10,000 for Ms. Willis's travel, I don't believe is an accurate reflection of what the numbers, at least the summary that I've been provided by the defense would reflect. I think that's joint travel. Is that right, Mr. Sater? I'm sorry.
No, it's not joint travel. But all I'm trying to understand, I'll rephrase because I don't want to get bogged down on specific numbers. You would have received thousands of dollars in cash from Miss Willis, correct?
Yes, sir.
Okay. And the thousands of dollars in cash from Miss Willis, do you know, I'm not asking you whether she took it out of her pocketbook or she took it out of a suitcase. I'm saying, do you know the source of the cash?
Just that, out of her pocketbook. Yes, sir.
You don't know where she obtained the cash?
I didn't ask her.
And the whole time that she was paying you in cash, you never said, hey, why do you have this amount of cash?
Well, Mr. Sadow, in my practice, people come into my law firm all the time with cash. I never question where they got it.
Yeah, but we're talking not about people that come into your law firm. We're talking about the district attorney of Fulton County, who I'm assuming receives a paycheck. She doesn't get paid in cash.
So just like you assume.
That she probably has a bank account. That is weird that she's just walking around with all this money.
I assume.
But she worrying about people, spotting her in locations, but she's walking around with racks on her. Literally, that is weird.
She got it from her paycheck. I don't know.
Okay. But of course, it's already been, and I'm not going to go back into it. You've not seen any records indicating withdrawals of cash from Miss Willis at all.
Why would I ask her?
I didn't ask. All I said is you haven't, right?
No, sir.
Okay. Now, can you explain why you filed for divorce one day after you were hired by Miss Willis? You filed on November 2nd of 2021. You're hired on November 1st of 2021. Why the day after?
Because he met his new boo.
You mean one day before? So
you filed for divorce one day after you were hired, right?
Okay. I'll answer your question.
Okay, please.
Yeah, which is interesting. So he said that his wife was unfaithful in 2015. Oh, he had said that they stayed together so that there was no divorce and the child wasn't all fucked up. This shit is weird.
So in 2015, when my wife had the affair, we had a conversation that we would divorce right then. Again, the better practice, at least for my children at the time, was to stay in place until the youngest could graduate and matriculate into college. We did that. When she graduated, matriculated into college, at the time, my wife had moved back and forth to Houston, to Texas. So she's in Texas. We take our child off to college. We come back to Georgia for a brief period of time. Divorce gets filed. She gets served. There we go. Now, the reason that date was...
They was just cool, chilling, going to the college and all that. He could have served her ass right there.
Selected. Yes, sir.
On the way back, like, matter of fact.
That's what I asked.
The specific reason that specific date was selected was because she was only in town.
I'm going to object, Your Honor. This is attorney-client privilege. Why he decided to file this.
And why do you have the right to object on his behalf for attorney-client privilege?
Because,
well, I'll make formal.
All right, there we go. And
I believe that he's already attempted to answer this question and there was no privilege raised.
I'm just going to tell you right now, I'm not buying that he wanted the youngest to be in college and all that. It sounds like a really good excuse.
So he's given a partial answer.
I'm not saying that people don't do that, but I'm just saying, like, I'm just over this dude with his lies.
And now he's about to finish that. So First of all, I don't think it's covered by attorney-client privilege, and I'll deal with that if you want me to. But otherwise, he's already answered part of it. So he doesn't get to say, now I'm going to stop. So.
Well, it was a long preface, but I don't think it ever actually got to what might have been at issue there. So if you can lay the foundation, we'll deal with the objection.
Okay. Take a step back. Okay. You realize that an attorney-client privilege is the privilege of the client, correct?
Yes, sir.
And you, in connection with your representation, at least has been proffered to the court by Mr. Bradley, that it's up to you to decide whether you want to raise the privilege, right?
Yes, sir.
It's not up to Mr. Bradley.
Yes, sir.
So you have the power, in order to get to the truth of the matter, you have the power.
Right, I agree, Mac.
To waive the attorney-client privilege, do you not?
I believe that's an inappropriate.
And then with his best friend, allegedly, what?
The privilege is there.
Whether he uses it or not, it doesn't matter why. Mr. Sato, I think if we're trying to get to the answer to your question, let's figure out whether it covers the question you were trying to get to.
And if I may finish, and your position is you have no intention of waiving your attorney-client privilege, correct?
That's correct.
All right, so now, can you answer the question why you waited until November 2nd, the day after you were hired by Ms. Willis, to file for divorce?
I can.
Okay.
So, again, Joycelyn had relocated to Texas, and she had been in Texas for months. She was only here for a brief period of time to drive my daughter's car back with her. And when she came here to do that, I was able to then get her served.
But he says that like they were beefing. They're not even beefing. It seems like they were pretty cordial together. Anytime you could spend from 2015 to what, 2019, 2020, 21, you know, in a relationship where you're not together, but you guys are living together and you don't want the kids to know that y'all split up because infidelity. He acts like they were on like hard grounds. You were cool. What do you mean till you could get her served? That should have been pretty easy. You could have Terrence Bradley walk his big ass up in there.
Okay, so your answer as to why you waited until the day after.
Well, what if Terrence Bradley is the best friend? Now I'm just playing.
After you were hired by Miss Willis on the
Right. He probably was holding her, you know, cheating over his head. I mean, over her head and shit. Like, don't ask me what I'm doing when you cheated on me with so-and-so.
which would be November 1st, 2021.
Oh, man, right.
To file the complaint for the divorce on November 2nd, 2021. Your testimony under oath is because your wife was here, but had not been here in October, had not been here in September, had not been here in August of 2021.
She had been in Texas taking care of her ailing mother and
your testimony,
aging father. So the first
Why you ain't bring her ailing mother on a trip? I'm just playing.
opportunity that I had after speaking with my lawyers to take care of that was the date it was filed and served, because she happened to be here. It had nothing.
He said take care of that like he was talking about an abortion or whatever, like an unwanted baby.
That was purely coincidental, that contract.
I understand it's purely coincidence.
Ooh, great point right there, M. Mac. He probably did wait so that he didn't have to pay alimony or child support.
Testimony.
Yes, sir. And understand.
Talking about he didn't want to, you know, cause a hardship for the kids.
And that this was by agreement between she and I, she being my wife and I, that we would divorce when the children matriculated out, and that there would actually have been an agreement attached to the filing. It became apparent that the agreement wasn't going to happen, and things got a little.
Thank you, Information Man Show.
Contentious, so that's when the privilege will kick in, and I was forced to do it when I did it.
So I understood correctly, again, you tell me if I'm wrong. Is it your testimony that your wife was not in Atlanta, Georgia, or the metro area throughout October of 2021?
No.
That's not your testimony?
In October of 2021, she was back and forth between here and Texas.
Okay, so she was, at least on some occasions, in the Atlanta area.
But that was during the time when we were working through the consent agreement that fell through.
Again, I think we're pretty far afield on relevance. The answer to the question about the timing of the divorce filing.
Understood, Ms. Cross. Ms. Sano, where are we going from here?
We're about to finish this area since I'm not going to be able to go any further about, if we want to call the X, we'll call the X for that purpose.
Well, we're going to have to discuss whether that's a collateral issue altogether.
No, I'm just saying.
And I'm wondering why the ex-wife didn't testify anyway.
I didn't say we will, but we'll.
Okay.
All right, so you said that you were aware of the contracts that Mr. Bradley and Mr. Campbell had with the Fulton County District Attorney's Office, correct?
Yes, sir.
And how did you become aware of those?
Just through conversation.
With who? Conversation with who?
Mr. Bradley and Mr. Campbell.
So you were discussing matters with Mr. Bradley which were not related to attorney-client privilege, correct?
Related to the contracts, yes.
Okay, but you were having conversations that would not, even though, if I understood correctly, Mr. Bradley was your attorney at the time, correct?
At what time?
At the time that Mr. Bradley received his contract from Fulton County, which would have been beginning of January or in January of 2021, right?
Is that the date of his contract?
Pretty close.
I don't know what the date of his contract was, but if it was after the date of the filing of divorce, then yeah.
I'm not talking about after the date of the filing of divorce. It's been represented to the court that you had an attorney-client relationship with Mr. Bradley from 2015 forward.
Yes,
correct?
Sir. Yes, sir. That is correct.
When Mr. Bradley received his contract with Fulton County, that was in 2021, correct?
I don't know.
We can prove that through other evidence. But at the time that Mr. Bradley was doing work for Fulton County, if I understand, you still had an attorney-client privilege, at least you're claiming one, with Mr. Bradley, correct?
Yes.
Okay. So when you talk to Mr. Bradley about matters with his contract in Fulton County, those were not covered by your attorney-client privilege, correct?
They were not.
Okay, and that meant that not all communications with Mr. Bradley were covered by attorney-client privilege, correct?
Well, those certainly weren't.
Well, but my question was, not all communications with Mr. Bradley were covered by, at least as you've been represented to the court, by the attorney-client privilege, correct?
Those communications were not.
So there were communications outside of the attorney-client privilege, correct? With Mr. Bradley.
If you're asking me if I ever communicate with him outside of the attorney-client privilege, the answer is yes.
Okay.
I communicated with him outside the attorney-client privilege.
Let's finish this up. And did you call it Roman number 4 or just defense? Okay, in defense exhibit number 4, and Mr. Gillen went over with you your responses to certain interrogatories on May the 30th, 2023. Remember that?
Yes, sir.
Not going back into those, the words in the interrogatories are already in evidence, so we're not going to do that. But the ones that we've got that were gone into, there were 2 of them. And your answer to both of those was none, correct?
Yes, sir.
Okay. Now, on January 25th of 2024,
yes, sir,
you again were in a position that you answered those same interrogatories, the 2 that we're talking about. I can get specific if we need to, but as long as we understand we're talking about the same 2, right?
Yes, sir.
Okay. And they are in defense exhibit number 6, and they are interrogatories number 4 and number 5.
Okay. Go ahead.
No, I want you to be able to see it. So it's defense exhibit number 6.
I don't,
I see you have 6 up there. I'm told that you have 6.
okay. Here we are.
Okay. You would agree with me that in defense exhibit number 6, and we're talking about interrogatories of January 25, 2024,
Yes, sir.
that as to interrogatory number 4, that's the same interrogatory, same words that were in the interrogatory that Mr. Gillen went over, which was dated May 30th of 2023, correct?
Yes, sir.
And your original response in defense exhibit number 6 was none, correct?
Yes, sir.
Your updated response was the plaintiff declines to respond to this interrogatory and asserts his privilege pursuant to OCGA section 24-5-505, correct?
Yes, sir.
You know that 24-5-505 breaks down into two privileges, right?
Which is why I was specific. I said I asserted the privacy privilege.
Well, that's what I'm asking you. But
I didn't know you could do that, just assert a privacy privilege.
your updated response, there's no reference to privacy,
That's how I'm gonna
correct?
deal with it now. Privacy privilege.
Yes, there is in the code section 24-5-505.
Okay, but it also,
reference to privacy.
just go with me, okay? That code section says, does it not, no party or witness shall be required to testify as to any matter which may incriminate or tend to incriminate such party or witness, or which shall tend to bring infamy, disgrace, or public contempt upon such party or witness. You'd agree with that, right?
I'm not reading it.
I'm sorry?
I'm not reading it. I don't have it in front of me.
If I may.
Mr. Sino, we can, I can take judicial notice. That is what the rule says if you want to ask him any follow-up questions.
Okay, thank you. You are not claiming that your answer to number 4, interrogatory number 4, on January 25th, 2024, incriminates
What is he wiping under his eyes?
you, that is, as in Fifth Amendment privilege, right?
That's correct.
You're claiming the second part, that it would, it
The way that he just wiped his eye like that, that looked like a soothing measure.
would bring infamy, disgrace, or public contempt, correct?
I'm going to object to that. I don't think that's the full thing, but and also the witness doesn't have it in front of him, so I don't know how he could respond to that. I think he's said several times privacy is why he invokes that statutory.
Overruled.
I'm claiming privacy.
The privilege that you make reference to is to infamy, disgrace, or public contempt upon the witness, right? Or party. That's the section that you were relying on, correct?
If that's what it says, yes, sir.
Okay, look. I could show you, but I think the court has already indicated he can take judicial notice of the statute. So assume that what I'm telling you is accurate, okay?
Yes, sir.
Okay. How would an answer of none bring infamy, disgrace, or public contempt upon you?
So as I explained in direct of Mr. Roman's counsel, the minute she elected to intervene into my divorce proceeding, I then started to understand the bigger picture, which was that all the attorneys in the election interference case were colluding with Joycelyn's divorce lawyer. And because of that, I said, privacy. I don't want my divorce proceeding to bleed into this criminal proceeding. I just didn't want that.
So you raised a...
But why though? If the reason why they were getting divorced is because his wife cheated. Why
privilege, if I understand,
this dude
that indicated that your answer would bring infamy, disgrace, or public contempt upon you, right?
Your Honor, I'm going to object to the relevance of this. It's been asked and answered several times.
But let him tell it. He's gonna be like, because the way that my wife cheated on me, made me feel some type of way. And what if she cheated in revenge? Like he originally cheated, she cheated back, got caught, Then he ran around with Fanny. Fine.
Mr. Sato, where are we heading with this?
I think I can finish that up by saying, you didn't say none again. You asserted a privilege, correct?
That's correct.
Okay. And you did the same thing, did you not, with number 5?
That's correct.
That is, you didn't say none again, right?
Correct.
Okay. Is the answer to the interrogatory number 4, that you have it in front of you, is the answer none? Is that the truth?
The answer is to that interrogatory is as I placed it at the time I responded, sir.
I'm asking you now, is the answer to that interrogatory
The answer
none?
is, the answer is still privilege.
All right. So he's apparently electing to apply the same privilege, Mr. Sato, to that exact same question.
And I have a case which indicates that we can get beyond that if the court deems that appropriate.
And to what end? To what end?
Exactly. And then with his best friend.
That the privilege actually does not apply and he must answer the question.
And where does that get us? Even if he answers the question, hasn't he already kind of said everything he has to say about the nature of the relationship, how long it lasted, when it ended?
No, I think it would prove, I think if he is forced or compelled to answer the question, he will either answer it falsely by saying none, or he answer it truthfully by saying yes, and then telling us what it is. That's what I believe. That's why I'm asking.
But the interrogatory you're referring to, though, the question contained there.
Two interrogatories, yes, sir.
It's the entertaining one. It's whether there were other relationships, right?
With the specific language that's in the interrogatories.
Sure. Haven't we already covered that in all the other questions that we've had so far?
We have, but again, the court could, if I could require or compel an answer from him as to whether his answer would still be none, then we would know whether or not he was telling the truth now. If the answer is no, then obviously there was a time in the past where he was not. It simply requires him to now answer under oath what he refused to answer and claimed, what I might suggest is a bogus privilege, and that you can pierce that privilege because it's a material fact in connection with this case. Again, it's a call that Your Honor makes. I have case law that says you can do that, but it's your discretion.
Ms. Cross?
Your Honor, Mr. Wade's been on the stand now for several hours. He's been asked and answered very personal questions that I believe cover the issues that Mr. Sato is making an argument, and it's probably an argument to make for the later to the court and not a question to propound the witness.
So as I see it, the only relevance these interrogatories had to this case really whatsoever would be as either prior inconsistent or consistent statements.
And dude ain't even that attractive. I know Fani could do better than that.
And to that end, I think the question has been put to him again and again and again.
About to risk it all for dude.
He's answered how he believes he felt his answer should be and why he answered a certain way. And as it goes to credibility, I think at this point we're arguing weight, and I don't really see the value in pushing this issue further. So,
all right. Well, just for the record, the case that I was going to refer to is State versus Wakefield at 324 Georgia Appeal 587, and specifically, let's see, it would be 590, in which they talk about this specific privilege. This is a 2013 case, and then they footnote to footnote 3. And footnote 3 says, there are times when the materiality of the evidence outweighs the testimonial privilege. And it goes and explains what that is. That's what I'm bringing up.
And I see what you're saying, that we could say that you need to answer the question regardless of the privilege you asserted. At this point, though, I think we've covered that ground and we're ready to move on.
Okay. Based on that, I have nothing else. Thank you.
Okay. Mr. McCall.
The judge is literally in some of the questioning allowing them to try to beat the answer out of him without putting their hands. It's like beating a dead horse.
Anything on behalf of Mr. Floyd? Moving through defense counsel.
Oh, I'm sorry.
No, I'm looking behind you. Mr. McCall.
Okay.
On behalf of Mr. Floyd, he's elbowing you, sir. Okay. Mr. Cromwell.
Nothing, Your Honor.
All right. Ms. Cross.
Mr. Wade, have have you still got exhibit number 14 in front of you? That's the one with all of the invoices, I believe.
I believe I have them all.
All right. So you were asked, Mr. Wade, about a couple of the invoice items. And your testimony, I think, was that the percentage of income post special counsel appointment in November 2021, the percentage of your income roughly after that time was about 50-50 Fulton versus other income from your law practice, correct?
Roughly, yes, ma'am.
Sometimes more, sometimes less.
Yes, ma'am.
All right. How about your time? I'm interested in the percentage of your time from November 2021 to, let's say, the close of the special purpose grand jury when it was dissolved in January 2023. Can you estimate for us the percentage of your time that was spent on Fulton County work versus other work?
Oh, gosh. 99.1. 99% of the time here in this building, working on this case.
All right. It was, as I understood your testimony, it was an intense period in terms of hours while that special purpose grand jury was meeting, correct?
Yes, ma'am.
And who was head or manager of the election integrity case during that time for the district attorney's office?
I was.
You were coordinating the efforts?
Yes, ma'am.
And those efforts included not just the proceedings that were happening in this building, correct?
That's correct.
We don't need to go all through it, but is your representation that 99.9% of the time, let's restrict it to 2022, 99% of your professional working time was devoted to this case?
Yes, ma'am.
And the remainder, whatever it was to some of your other cases that were ongoing?
Yes, ma'am.
All right. 2022, I want to focus on that a little bit because if we are looking at, I believe, the financial affidavits, do you have those in front of you as well?
I do.
The financial affidavit that was filed in your divorce case in January 2022, you estimated your monthly income at that time was $14,000 a month, right?
In 22?
January 22.
Yes, ma'am.
January 23, what'd that number come to?
9,000.
What about 2024?
I don't know.
Is that there in front of you? Is that one, that's not one of the ones that's there in front of you?
No, ma'am.
All right. So as reflected in those financial affidavits, your income decreased as a result of your work in this case, correct?
Significantly.
The structure of your firm, we talked a lot about that, and I don't want to go through it anymore, but than we need to. But 2022, the structure of your firm changed. Is that correct?
That's correct.
All right. In the early part of 2022, there were three of you. You and Mr. Campbell and Mr. Bradley, you split expenses, is that right?
That's correct.
And you profit shared among yourselves, correct?
Correct.
Right. After Mr. Bradley left the firm, then there were just two of you, correct?
That is the cause of the significant change. Yes, ma'am.
So now you have two people bringing in income, correct?
Correct.
And one of those people, you, is spending almost all of your time devoted to this election integrity case, correct?
Yes, ma'am.
And your income from this election integrity case is less than what it was the year before.
Yes, ma'am.
We talked about the monthly caps. We didn't talk about it. There was talk about the monthly cap that was included in your contracts, indicating there was a certain threshold that you could reach number of hours a month. And over that amount, you were not going to be compensated, correct?
That's correct.
All right. And you kind of smiled when you said that. That's a little bittersweet there, isn't it?
That's bitter.
All right. Exhibit 14, is that still there in front of you?
It is.
I want you to take a look, please. That's a collection of exhibits that includes all of your invoices as was represented. I want you to take a look at invoice number 9.
Yes, ma'am.
Is that there in front of you?
I have it.
Invoice number 9, Mr. Wade, indicates that you performed hours of work that you were not compensated for because your cap had been reached.
Yes, ma'am.
I want you to take up, and what did you do in those circumstances? When the hours that you worked per month were more than the cap that was in your contract that you were permitted to be paid for?
I was forced to lose that time. I didn't get paid for it.
Okay. And that's what exhibit number 9 shows?
Yes, ma'am.
All right. And in exhibit number 9, you've got a task, hours that were completed, and you just didn't bill for it. You noted the time and then a 0 beside it because you didn't bill the county for that time.
Yes, ma'am.
All right. What about exhibit number, invoice number 13? Can you flip to that for me?
I have it.
Is that a similar situation?
Yes, ma'am, it is.
And what is it on invoice number 13?
This invoice makes me cry. There's so many hours here that I worked that I couldn't get paid for. So,
And you work those hours anyway, Mr. Wade?
oh, absolutely. This is not the type of job that you could walk away from just because you're not getting paid for it. I think there's some professional rules of responsibility to an attorney who's engaged in a case. You have to see it through. So it's not like I can just throw my hands up and say, well, I reached my monthly cap, I'm done. I can walk away. I can't do that. This is ongoing, it's constant, and I have to do the work.
Can you look at invoice number 23 for me there in exhibit number 14?
Yes, ma'am.
Does that reflect a similar situation, the hours worked that you were not compensated for?
Yes, ma'am.
Invoice number 24 and 27, can you take a look at those and let us know if that reflects the same situation?
Are you trying to depress me?
No.
Look at the money I'm
No, I'm sorry.
It's the same, yes.
Okay. And there's no workaround to that? You didn't attempt to work around that contractual cap on your hours?
Oh, no, ma'am.
All right. You were asked a lot of questions, Mr. Wade, about the affidavit that was submitted, correct? Do you recall those questions?
I'm sorry, I'm stuck on this invoice. You know, if I was gonna get a benefit, I'd like that benefit. That's the one I want. That didn't happen.
That didn't happen?
Okay.
All right. And there was no renegotiating your contract to reflect that those hours should be paid or anything?
No, ma'am.
Okay. All right. Do you have your affidavit there in front of you?
I do.
The affidavit, of course, was attached to and provided in support of the state's response to Mr. Romney's motion, correct?
Yes, ma'am.
All right. And you prepared that affidavit?
I did.
You signed that affidavit?
I did.
All of the allegations and the representations in that affidavit are true. Is that right, Mr. Wade?
Every one of them.
Every one of them. You were asked a lot of questions about our line number 34. Can you turn to that for me, please? It's on page 4 of that affidavit.
Yes, ma'am.
Can you read it out loud for me, please?
The district attorney and I are both financially independent professionals. Expenses for personal travel were roughly divided equally between us. At times, I have made and purchased travel for District Attorney Willis and myself from my personal funds. At other times, District Attorney Willis has made and purchased travel for she and I from her personal funds. Examples of District Attorney Willis's purchasing plane tickets for she and I with her personal funds for our personal travel are attached.
Funds, Mr. Wade. As you understand the term funds, does that include cash?
Yes.
Does that include credit?
Yes.
Does that include reimbursements?
Yes.
You didn't represent in your affidavit, Mr. Wade, that you were including all of the receipts from funds or travel expenses that were paid on your behalf by District Attorney Willis, correct?
That's correct.
You had, I think your conversation with Ms. Merchant was you produced the receipt that you had.
Yes, ma'am.
Are you aware of any other receipts? Well, I may ask you this way, may I put you on there for just a sticker? That's all right, I'm gonna write it on there now. I'm gonna mark this as state exhibit number 1. You testified, Mr. Wade, that District Attorney Willis purchased and funded the entire trip to Belize. That was her treat to you for a birthday?
Yes, ma'am.
And you testified that she purchased the plane tickets for you, correct?
Yes, ma'am.
And while you may not have had the receipts on hand when you filled out the affidavit, because they weren't in your possession, are you aware now that there are receipts and that it reflects that the district attorney.
This is going to go into evidence. We'd like to look at this first.
I've got a copy. Do you remember, Mr. Wade, approximately how much, and that's again, safety exhibit number 1, may I approach the witness stand? Do you remember how much the flight was for you, your flight to Belize? And if you don't, I'm not tendering it for you, I'm just asking you to take a look at that and see if that refreshes your recollection as to the amount that that plane ticket cost that was extended by district attorney. You may keep it. You keep it. Does that refresh your recollection, Mr. Wade?
It does, thank you.
Approximately how much was the amount of the ticket that District Attorney Willis purchased for your travel to Belize?
$887.35.
And I'm not tendering it, Your Honor, but I will leave it with the court reporter for reference and inclusion in the record. All right, Mr. Wade. Your testimony here in court today and consistent with your affidavit was that the personal relationship, I think we called it dating today as well, the personal or dating relationship between you and the district attorney began sometime in early 2022, March, I think was your testimony, is that right?
Yes, ma'am.
And that March date isn't included in the affidavit. The affidavit is less specific, but that was your testimony today?
Yes, ma'am.
And that there was no personal or dating relationship prior to that time, right?
None.
Right. Mr. Wade, I'm sorry. I'm going to direct your attention to 2020. In 2020, were you dating the district attorney?
No.
2020, that was during the COVID pandemic, correct?
It was.
Was there a situation for you, Mr. Wade, that made you particularly vulnerable during the COVID period?
Yes, ma'am. And in 2020, and a portion of 21, I was battling cancer. And that
there's the cancer thing.
Prevented me from pretty much leaving environments that aren't sterile. And I had health on my mind.
You were particularly cautious during that time.
Yes, ma'am.
Were you dating anyone in 2020?
No, ma'am.
Yeah, just like he successfully got a divorce before he started entertaining Fani. Yeah, right.
All right. Thank you, Mr. Wade. That's all I have.
Ms. Merchant, recross on those points only.
Yes. All right, Mr. Wade. The state asked you about how much money you're making now versus before, and you said you're making significantly less since you've started working for Fulton County, correct?
Well, I did say that, but what we're talking about is because now at this point, the splitting of the financial obligations in the firm are now there are 2 people carrying the weight of 3. So that would scale back on the amount of income, right? Amount of profit.
Well, you're splitting the profits 50-50 though, instead of 1/3, correct?
The profits, yes.
Okay. So, but you did testify that you're making significantly less now. We heard about it for a few minutes, significantly less now that you work for Fulton County, right?
Yes.
Okay. Would you agree with me that $236,000 is more than $184,000?
Absolutely.
Would you agree with me that $262,000 is more than $236,000?
Absolutely.
All of these years, despite you saying that you were a 3-way partner with Wade and Campbell and Bradley, and now a 2-way partner with Campbell, all of your corporate tax returns are filed in the law firm of Nathan Wade, though, correct?
My returns, yes, ma'am.
Yes, for your law firm.
Well, for my law firm, because I also have personal returns.
Right, and I'm not talking about your personal returns. I'm talking about your business returns.
Yeah, but the question contemplates that my bring home money is more or less. So I want to be clear that is reflected in my personal returns.
I didn't ask you anything about bring home money though. I'm not sure what you're talking about.
What I'm talking about is your question was the portion of my testimony dealing with earning significantly less money.
No, my question is I'll just break it down. During 2019, you filed your business returns. I'm not talking about your personal, your business returns for the law firm of Nathan Wade only, correct?
I filed personal and business. Yes, ma'am.
And even though you said you were partners with Bradley and Campbell later on, you filed your business returns not with them, but as a solo practitioner, correct?
I see where you're going. There's a different return for that Wade, Bradley, Campbell entity.
And I'm not asking about that. What I'm asking about is during the years 2019, 2020, 2021, and 2022, you filed a business return for the law firm of Nathan Wade.
Yes, ma'am.
And in 2019, you said that the law firm of Nathan Wade made $184,000, correct?
No, I don't know.
Does that sound familiar? Does that sound about like what you made in 2019 and reported on your taxes as a business law firm?
If that's what's on the return, yes, ma'am, you're right.
Okay, and I'm happy. I can bring those up. I've got one copy. I'm not planning on admitting them because they're tax returns, but okay. All right, may I approach them?
Yeah.
Thank you. So in 2019, gross profit for the law firm of Nathan Wade is $184,000, correct?
Let's see.
It's the second line, number 2, gross profit.
Yes, ma'am. 184,824. Yes, ma'am.
Okay. And then in 2020, you also filed Nathan Wade, attorney at law, and your gross profit was $230,000, correct?
Yes, ma'am.
And in 2021, you also filed as a solo Nathan Wade PC attorney at law, and your gross profit was $236,000, correct?
Yes, ma'am.
And then in 2022, you filed as a solo practitioner Nathan Wade, and your gross income was $262,000, correct?
Yes, ma'am.
Okay. I'm not into this. I've got your position. But nowhere in these documents do you document that you received cash payments from Ms. Willis, correct?
I hadn't looked through them. I would be surprised if there were something in there that said that.
Do you want to look through?
Listen to the answer. I'd be shocked if there was something in there that said that I received some cash from Ms. Willis.
Okay. But there is itemized expenditures for travel in here. You did itemize that.
I didn't itemize anything.
Your accountant itemized it.
I hope so.
But you're responsible for your taxes, even if your accountant files them.
Look, he talking about his accountant.
Right?
I agree.
And so you itemized your expenses for travel on all these documents, but you did not itemize, you didn't put anything in there about you being reimbursed for half of that travel.
Well, those are business returns.
Yes, you used your business card to pay for the travel, right?
But I wouldn't put a personal expense on a business return.
But you used a business card to pay for these personal travel.
I use a business card to pay for everything. And what I do is turn over the statement to the accountant, and the accountant then says, okay, this expense, that's personal. We'll put that over here. This expense, that's business. We'll put that over here. And they reconcile it. So you wouldn't find a reimbursement from Ms. Willis on a business return.
Okay, so they're not anywhere there.
Nor would you find, well, go ahead.
No, I'm just asking. So there's nowhere for any of that cash to be reconciled there, right?
On the business returns, no, ma'am.
Okay. We talked a lot about the financial affidavits. I know the state asked you a couple questions about them. You filed one in 2022. In that one, you stated that you only had $5,000 in cash, correct?
I believe you. Yes, ma'am.
That was sworn under oath.
At the time of filing, yes, ma'am.
Okay. And then in January of 2024, you filed another one that also swore that you only had $5,000 in cash, correct?
At the time of the filing, yes, ma'am.
Okay. So in 2022 and 2024, you only had $5,000 in cash.
At that time, yes, ma'am.
At that time. I'm sorry. Excuse me. And then you also, all of those interrogatories, I'm not going to go through them in painstaking detail, but every single interrogatory you filed, there are 4 of them, all verified ones. Every single one you said you didn't have any cash stored in a safe, a safety deposit box, or any other location. Plaintiff rarely carries cash. If plaintiff does carry cash, it's a nominal amount, correct?
That's correct.
Okay, so we've got what? 2021, you said you don't have cash. 2023, you said you don't have cash. Again in 2023, you said you don't have cash. And then in 2024, you don't have cash, right?
So you're assuming that I received the cash and I stored it. I received the cash and I saved it.
Well, you didn't put it in the bank, right?
What's wrong with receiving the cash, Ms. Merchant, and spending it?
Nothing's wrong with it, but you didn't put it in the bank.
That would contemplate why the response is what it is on the interrogatory.
So you spent the cash. That's because before when it was asked, you said you didn't want to disclose where the cash was.
No.
For privacy reasons.
No, well, I said that if I were to store cash in my home, then why would I share that with the world, is what I said. I didn't say that I had some cash stored up in some place, because that's not the truth.
And you've talked a lot about this, I split with a third, I split with half. From the check you received from Fulton County, July 15th, 2022. So all the way back for July 2022, not a single check that you've received from Fulton County has gone into a joint banking account. Every single check has gone into your own personal banking account, correct?
All of them, with the exception of the checks that were going into the WBC firm, went into my business bank account, which is solely in my name.
Right, your WBC account that you're talking about, that account was closed though in June of 2022.
Correct.
Okay. So everything after June of 2022 was put in a Nathan Wade bank account, not a corporate bank account.
I'm going to ask Privilege to be permitted to.
I think the question right before that only needed a yes or no.
So no, ma'am. The checks were deposited into firm accounts, law firm accounts.
Law firm of Nathan Wade PC.
Yes, ma'am.
As a solo practitioner.
Yes, ma'am.
Okay, so they were not deposited into accounts with Campbell or Bradley.
No, ma'am, they were not. However, there were checks written to Campbell and Bradley that will reflect the third.
And we've tried to get those bank records, but you've objected to those, correct?
You've tried to get what bank records?
We subpoenaed bank records and you've objected to all of those, right?
Your Honor, I'm going to object to the relevance.
It's relevant if he's saying he has all these records, but yet we've tried to get them and he's trying to keep them from us, but he doesn't bring all of the records. And you can make an inference if there's law that says you can make an inference if some documents are within the party's control and they won't provide them, that there's an inference that they're not positive.
Your Honor, there was no obligation for Mr. Wade to produce evidence that Ms. Merchant couldn't find an admissible way to produce. I believe it's irrelevant. We've covered the ground, and I object to any further questioning.
All right, I'll sustain that. Ms. Merchant, let's find some new ground here.
Okay, thank you. Are you willing to waive your privilege with Mr. Bradley so that he can testify?
I am not willing to waive attorney-client privilege.
Okay, thank you.
I'll wait on the health questions that were asked. And I can ask you from here, from immigration. I don't want to get into the type of cancer. I don't want to get into the medical condition itself. Did I understand you to say that you had cancer in the year of 2020?
Yes, sir.
And you explained that because of that, in 2020, you kept yourself in a sterile environment?
That's right, yes, sir.
Now, what about 2021?
2021, just focusing on my health, trying to get back to myself.
Do you remember I asked you some questions about Hateville?
And why were you traveling during the Rona?
Yes, sir.
In the condo?
Yes, sir.
And you indicated that prior to November 1st of 2021, you had spent time at the condo, the Hateville condo?
Yes, sir.
With Miss Willis, right?
Yes, sir.
And with someone else? You said Miss Yeartie?
Miss Yeartie, yes, sir.
Okay, so you were not concerned, that was not a sterile environment, was it?
Are you inferring that Miss Yeartie and D.A. Willis is not sterile? Of course it's a sterile environment. It's a condo.
But don't you remember then I followed up and said, where else might you have been to show your cell phone records from Hateville? And you said the airport, right? Not a sterile environment though, the airport, you agree?
It is not.
Okay, what about restaurants? Not a sterile environment, right?
They are not.
And the Porsche, you said something about a Porsche what?
The Porsche experience.
That doesn't sound very sterile to me. Is that a sterile environment?
You're inside your vehicle.
Yeah, but don't you mingle with others?
You can.
Yeah, and you were doing all that in 2021 before November 1st. That's what you testified to, correct?
Yes, sir.
So there's no reason why you couldn't be dating in 2021, is there?
Give me 2020, Mr. Sadow.
No, say 2021.
All right.
Correct?
Dating? No.
No reason.
No
right?
reason.
Got it. Thanks.
All right, Mr. Gillen. Okay. Mr. Stocks. Stockton, excuse me.
Just real briefly, you said you started dating in early 2022, and you also used the term personal relationship. And there was no dating, no personal relationship prior to early 22. Is that correct?
I want to make sure I answer you. So let's be clear. 2022 was the start of any intimate sexual relationship with the district attorney.
Okay, and that's what I was wanting to
Okay.
make clear. In your affidavit, you used the term personal relationship.
Got it.
Today, you've used the term dating. And your testimony today is that that includes the term basically physical.
Come on, we're almost done. Come on, fucker. Come on. Well. Well, fuck it. I'm gonna leave that. Hello.
Term basically physical or sexual or intimate relationship. Is that correct?
Yes, sir.
And there was nothing, according to your testimony, there was none of that prior to early 20.
That is correct.
That's all I've got, Judge.
All right, not seeing anyone else. Ms. Cross, any redirect? All right, Ms. Merchant, can this witness be excused?
Judge, we'd ask to keep him under subpoena. We might need him to come back after.
All right. All right, you may step down, Mr. Wade, and please don't discuss your testimony with the other witnesses.
She mentioned subpoena, Judge. Let me just say this. That was an inference made that I was somehow evading service of a subpoena.
We can take that up. I don't think we need to have it on the record in this hearing. Understood, though.
Thank you.
So that is what I have today, y'all. We went through 5 hours and 5 hours and about 30 minutes worth of testimony today. Nathan Wade is full of shit. And we heard from Terrence Bradley for the first time. We heard from Robin Yeartie. So today, we'll be hearing from Fani's father, Roy Barnes, which is the governor, as well as Terrence Bradley again. Now, there's only one person that I left out of the trial, and that's the dude that testified for only 8 minutes. He had like a little man bun on top of his shit. It was really nothing important about that, so I did leave that portion out. But again, tonight, we will have about the same amount of time that we spent with this one. And then that will bring us to basically closing statements. And I don't know if I'm going to cover that. But I do appreciate you guys for coming through. I know normally we talking about some other topics and stuff like that, But I definitely wanted to talk about this Fani Willis situation. Again, I was following along with the testimony and was like, what in the hell? So I do appreciate just chilling with you guys and stuff like that. Thank you for everybody that liked or donated and things like that. I definitely appreciate it. So tonight, what I'm trying to do is come back with the Fani testimony, as well as her father, Roy Barnes, the governor, and then Terrence Bradley went up again to speak even more. So with that said, I appreciate you guys. I'm not even going to play any outro music because it's already 2:40 where I'm at and I'm tired as hell. And I still got to upload this Fani Willis portion so that we can have our show done tomorrow. So expect me about the same time. Tonight. Or also check the community tab because I'll let you guys know if we're skipping tonight or if we're picking it back up on Monday. But I want to try to get in here tonight. Shout out to everybody. Stay you, stay royal, stay uncompromisable, and please stay woke because you will see me hear my voice or whatever in another upcoming live stream or edit. Much love, you guys, and I will see you guys soon. Bye-bye.